Apologize for the delay. We had some technical challenges with Zoom. Welcome to the June Planning Committee meeting on June 15th. We've got somebody's speaker on or something. Thank you. I'll call the meeting to order at 9:10 a.m. and I will confirm that we have all members of committee here with the exception of Councillor Kent. We do not have the CAO today, but we have the assistant clerk, deputy clerk. Thank you. The director of development and services, environmental sustainability, and other staff members are present. The agenda was published and invited, and people were invited to contribute through the email on the township email. Today's meeting is being live streamed and recorded on the Township of Muskoka Lakes website and YouTube channel. And by participating in the open meeting today, you are consenting to your image, voice, and comments being recorded and posted online. We have a supplementary item on the agenda, and that Mr. Ken Pierce will be providing comments on item 12C, which is the planning committee process. Let me ask if any of committee members have any disclosures of pecuniary interests on any of the cases we're dealing today. Very well. That's it for the opening remarks. So the first items we're dealing with is 5C, and these are concurrent zoning bylaw amendments and consent applications. And the first one is B5422ML Valenti, and Ms. Caitlin Walker is going to present this to us.
Thank you, Chair Bosenworth, and good morning, everyone. The first application to be heard this morning is consent application B/54/22ML and zoning bylaw amendment application ZBA/5422 bylaw 2022-189 in the name of Valenti. The subject property is known municipally as 22 Chiefs Island J5. I would direct committee's attention to the submitted consent sketch starting on page 34 of the agenda package. The purpose and effect of the application is summarized as follows. A severance application has been submitted to create one new lot and to provide exemptions from the minimum lot dimensions required in the WR4 zone. Bylaw 2022-189 will have the effect of permitting a lot to be created in the WR4 zone. The bylaw will permit the severed lot to have a minimum lot frontage of 300 feet and a minimum lot area of 2.8 acres. The retained lot will be permitted to have a minimum lot frontage of 538 feet and a minimum lot area of 2 acres. Notice of this public meeting under the Planning Act was circulated 27 days in advance of today's meeting, and 6 submissions have been received to date. Comments have been received from Nick Snyder, the Township's Chief Building Official, Tim Sopko, the Township's Public Works Technician, Douglas Holland, the Township's Fire Prevention Officer, Curtis Savret, District Planner, and these submissions were all circulated to committee prior to today's meeting, and I can read any of these submissions in full at the requested committee. After comments were circulated, a letter of support was received from Susan Baxter, a property owner on Chiefs Island, and the submission is as follows. My name is Susan Baxter, and I'm the legal owner of a property on Chiefs Island, Lake Joseph, Muskoka. My husband, Stuart Ellis, and I have a cottage property on the site that we actively use. Our property is to the west of the property owned by David Johnson and Alicia Valenti. I'm aware of their proposal to divide their property into 2 lots. I have no objection to their proposal. Please feel free to reach out to me if you have any questions or require further details. Many thanks, Susan. A letter of objection was also received after we circulated comments from Lucille Hamlin, also came in, and this submission is as follows. As an owner of Crow or Bottle Island across from the property in question, I would like to register my disapproval for the proposed severance of Lot 26, Plan M577. Chiefs Island has been very contentiously developed and subdivided into very large lots in order to preserve the true nature of Muskoka's pristine forest. This is one of the greatest gems to the Muskoka Lakes, to create 2 very small lots on a magnificent island would fly in the face of the fundamental nature of Chiefs Island and this part of Lake Joseph. As an owner of Crow Island, in the channel between Crow Island and Lot 26 is extremely narrow. There is a large amount of boat traffic going through this channel to get to the big lake, or in the reverse direction to get to the Joe River into Lake Rosso or Footsbay area of the lake. The dock on Lot 26 juts out into the channel, making navigation more hazardous. Boats generally travel at a speed that is too fast to navigate this narrow channel and with the dock in question. If a dock is put up on the new lot, though, it won't be jutting directly into the channel. It will be another congestion factor, and it is in this heavily trafficked part of the lake. It's easy to imagine a very bad boating accident occurring. The owner should move his dock if he wants to sever so he and his family can safely swim, and there will be no immediate risk of a bad accident. I strongly recommend not amending the bylaw to allow this severance. Lucille Hamlin. I've prepared a detailed planning report for committee's consideration. If committee is considering approval of consent application B/54/22ML, in addition to the standard conditions of approval, staff have recommended the following conditions. First, that the applicant enter into a consent agreement with the township pursuant to section 5126 of the Planning Act. Said agreement shall be registered against the title of lands and contain provisions to the satisfaction of the township whereby the owner agrees, first, not to utilize public parking and docking facilities as the principal means of access to the retained and severed lots. Second, that the adequate long-term parking and docking facilities used to access the severed lot be secured at all times, and to implement the recommendations of the water quality impact assessment prepared by Beacon Environmental dated September 2022, and that exemptions from the township's comprehensive zoning bylaw 2014-14 be approved to recognize the proposed lot frontage and area of the severed and retained lots, and to require an increased front yard setback from the severed lot or for the severed lot. If committee is considering recommending approval of zoning bylaw amendment application ZBA-14/23 bylaw 2023/044, staff recommend the following minor amendment: that 164-foot front yard setback be required for the land-based buildings and structures and any leaching bed distribution pipe on the severed lot. I have no further questions, no further comments, but I'm happy to assist committee with any questions. Thank you.
Thank you very much. Are there anybody wishing to speak in favor of this application? Oh, sorry, the agent. Thank you very much. I think it's Mr. Fauner.
Yes, thank you very much, Chair Bosworth, members of Planning Committee. Stephen Fauner, Northern Vision Planning Limited, 109 Meadow Heights Drive, Bracebridge, Ontario, P1L1A4, sorry. Here representing Alicia Valenti, and I believe her husband may be on listening. I'm not sure. His name is David Johnson. He might want to comment about the dock. I'm not sure. So first of all, I'm going to apologize because I've got a nasty cough, and further apologize that you're going to have to listen to me on 4 different applications this morning. So anyways, just getting into this, certainly thank staff for their positive report. My client has no objection to the enhanced front yard setback on the severed lot. If we could just put my PowerPoint presentation up, I think I can get through it fairly quickly.
Oh, yeah, he gets 5. Sorry, I was late.
Yeah, if we can just go to the next slide. Certainly there was a comment about these being small lots. They certainly meet the intent of the official plan. And one of them is a little smaller in acreage, but certainly the frontage at 540 feet is a considerable size, and water access lots under the current official plan is 300 feet. So we meet those requirements. I wouldn't say that these are small lots. Next. And this is just showing the layout of the properties. This is really at the more or less southeast corner of Chiefs Island. Next. And this is a photo showing the frontage of the proposed severed lot, heavily treed. Next. And this is, again, just another part of the frontage. Next. And this is at the far, I guess, far extent of the severed lot. You can see a building in the background. If you look very closely, that's a neighboring property owner. So next. And this is just turning around from that, and you can see the heavily vegetated shoreline. You can also see some of the slope as well. Next. And this is looking up the slope, and you can see some rock outcropping. And however, with the enhanced setback, we'll be up above that. Next. And this is up on top of that area, so there's certainly a significant amount of flat land once you get above the slopes. Next. This is another portion of the relatively flat area that's up above the slopes. Next. And this is the retained lot down near the corner of the island, or the point, I should say, at the south end. Next. And this is really the actual point itself. In terms of, I'm taking this photograph and I'm not even quite in the channel that was mentioned, and you can see there's a considerable distance. I recognize that channel is a busy channel, but in my opinion, the dock that's there would not interfere with boat traffic. Next. And this is the retained lot, and this is near the furthest sort of southwest corner, fairly level land there, but heavily treed as well. Next. And this is a flat area possible building site. Next. And another possible building site. So as you proceed on to the retained lot further to the southeast, you'll find that it's fairly level in that corner, and it slopes as it goes towards the severed lot. Next. And this is some of those slopes near the severed lot, but most of it's fairly level. Next. So the PPS permits limited development or limited additional lot creation. A water quality impact study was done by Beacon. Next. And water access is from Gordon Bay Marina. There's been a water access agreement that's been drafted by Melissa Cope's office and has been entered into with Gordon Bay Marina. Access for the retained lot will continue from a waterfront landing on the Joseph River. Next. Planning Act criteria has been satisfied as far as I know. We also have support from, we didn't get it submitted, but Jamie Blair has also indicated he's a neighboring property owner immediately to the south. He has no objections to the application. Next. And my conclusions, I don't think I need to repeat those. I would say, though, that, again, I'll repeat that I don't believe, in my opinion, that the dock would interfere. When my photos were taken last year, the dock was not there, but nonetheless, I didn't feel that there was any restriction for boating in front of this. It's certainly nothing like the Joe River, that's for sure. So those are my comments, and I'm here to answer any questions. Thank you.
Thank you very much, Mr. Fauner. Now I will ask if there's any people who would like to speak in favor of this application. No, none online?
Oops. Oh, hi there. It's Dave Johnson, husband of the property owner. May I speak?
Yes. Are you speaking in favor of the application?
Yes.
Yes, of course.
So
sure.
thank you, Steve. And
of course you are in favor. Unless you've got a marital problem.
Not today. Thank you to everyone for joining this morning and considering this application. I think I would just, Steve summed it up quite well in reviewing Caitlin's report. It was reflective of what we understood to be the considerations associated with the application. Speaking to the dock matter, and this does sound as if it's a concern regarding the placement of the dock as opposed to a core concern regarding the development of the lot. I think that's particularly highlighted, and this is my first time hearing of this, but highlighted by the fact that she indicated that if we wish to create another lot, we may wish to move our dock, which sounds like she'd like the dock moved. I would note that the island that she owns, or I think there's a joint ownership of their family, is meaningfully offshore. It is undeveloped and undevelopable, given it's a small picnic island. And when the dock was put in place, it was put in place in accordance with the township's requirements. We obtained a dock permit, which, Caitlin is aware of. And we also installed the dock with the guidance of our neighbor, Jamie Blair, because obviously I'm sure some of you know him. He's a prominent realtor in the area. His family has been there for in excess of 40 years. We share a property line, and I indicated, we installed the dock. Jamie was present when the dock was installed because I wanted the guidance of both someone who was very experienced in the area, plus the neighbor. We're looking to come, we're newcomers, and there are folks that have been there for a long time, and we wanted to do the right thing, both practically speaking in terms of the location of the dock and also getting the input and consent of our neighbors. So I'm disappointed to hear that someone is unhappy with the placement of the dock. And I would have, of course, encouraged her to speak with us or take the opportunity to do so outside of a public forum. But, to the extent we can, find an opportunity to speak with the dissatisfied neighbor with the dock placement, you will, of course, do so.
Thank you very much. Now let me ask if there's anybody other than the applicants wishing to speak in favor of this application. Seeing none, are there any who would wish to speak against this application? Seeing none, are there any questions for committee members? Councillor Nishikawa.
Thank you. Sorry, this would be to staff. There was a mention about 164-foot setback. And I find like I need more information about that and that recommendation. And also, I have a further question about the marina parking certificate, I guess.
Ms. Walker.
Through you. The 164 setback or 50-meter setback, which is kind of a bit easier to comprehend for myself, is just based off the slopes on the severed lot. It's directly from the Beacon report that was done, the water quality impact assessment that was done. This will set any development back from the slopes on the property. So that would apply to any future dwelling, sleeping cabin, and it will require the septic system also to be set back that distance from the lake.
Absolutely.
So I'm not. Is that written as such in the bylaw, or is that? Because that's what I was trying to make sure that was clear throughout.
Through you, Chair Bosenworth. Yes, we've recommended an amendment to the zoning bylaw. Amendment to include that as part of the bylaw. Yeah.
And just to be clear, that reads in the bylaw, it says required an increased front yard setback on the severed lot. So that would be in line, I presume, with the report.
That's correct.
Okay. Second question.
Just about the certificate from the marina about parking. I thought from conversations, and it might have been a council previous to this, or even two councils that we weren't necessarily satisfied with just getting a letter from a marina as far as their parking location or their landing location. And I think I'm going to ask Mr. Pink to this. I don't think it.
Director Pink, can you talk about that?
Certainly. Through you, the municipality in the past has always required a consent agreement that stipulates the owner is not permitted to occupy public parking and public docking to access their property. We have quite a few years ago did accept letters from Marina, and I think, as you noted, I think there's a few applications on the current agenda where we are requiring now evidence of a long-term lease or secured arrangement to ensure that there's long-term parking being satisfied. And I believe Ms. Walker and Mr. Sharp can outline for the current application how those arrangements have been addressed.
Ms. Walker, could you tell us what those arrangements are?
Yeah, so the severed lot there's a lease agreement that's been entered into between Gordon Bay Marina and the applicants. It's for a 5-year period at this point, and there's the option to renew it at the end of those 5 years.
Yep.
So I'm just curious of the tracking system that the township has in place to see that that has been renewed, or do we have that type of system?
Director Pinckney, would you like to answer that or address that?
Sure. Certainly through you. Unfortunately, you know, follow-up or enforcement or monitoring is a challenge with respect to you know, our resource limitations. I think, like most bylaw enforcement matters, we do work on somewhat of a reactive basis. If there were concerns submitted, we would certainly investigate, but the onus is on the property owners to comply with their obligations and agreements.
Councilor Zavitz.
Thank you, and through you, I guess to staff, maybe perhaps to David, on that point. I know we have a couple of other items today as well. Obviously, island development is becoming a little more, what's the word, prevalent, as there's less land-based properties to develop. And David, to your point, I'm not so sure that I'm satisfied with where we have to be with that answer, if you will. You know, there's a number of marinas that are all being bought by one company. So there's obviously the opportunity for people to sell marinas, you know, do those arrangements move with the sale. Things that, you know, where we don't have eyes on after 2 years, place gets sold and the guy's, you know, using a public dock at Bull Morris, for example. You know, we need to get better at that because this is going to become a bigger deal. And I'm wondering if we can somehow, perhaps that's one of the mayor's task forces. I mean, perhaps not, but we need to do a much better job of knowing that the parking piece is being respected. And I'm concerned by the fact that we lose sight of it as soon as we sign off today, essentially.
Thank you much. Thank you very much. I think that's viewed as a comment and a suggestion. Any other questions from committee members? Fair enough. Let me read the resolution. Moved by Councillor Roberts, seconded by Councillor Edwards. Be it resolved that Planning Committee recommend to Township Council that a consent application B5422 ML Valenti be approved subject to the following conditions: that a registrable description deed of the severed lot and any required right-of-ways be submitted to the township along with a registered copy of the reference plan. The cash in lieu of parkland be dedicated to the township in the amount of 5% of the assessed value of the newly created severed lot or the entire lands, whichever is less. The confirmation be received that the township is satisfied that the severed and retained lots are satisfactory for on-site sewage disposal, and that any problems identified with any existing sewage systems be corrected to the satisfaction of the township. That the application entered into a consent agreement with the township pursuant to section 51(26) of the Planning Act. Said agreement shall be registered with the title against the title of the lands and contain provisions to the satisfaction of the township whereby the owner agrees to not use public parking and docking facilities as the principal means of access to the retained and severed lots. That adequate long-term parking and docking facilities used to access the severed lots be secured at all times. To implement the recommendation of the water quality and impact assessment preparations by Beacon Environmental dated September 22 rather, and that exemptions from the township's comprehensive zoning bylaw 2014 be approved to recognize the proposed lot and lot area of the the severed and retained lots and require an increased front yard setback on the severed lot. Is there any discussion from committee members? Seeing none, let me call the vote. All those in favor? Any opposed? That's carried. Thank you. We have a minor amendment to address the 164-foot setback, moved by Councillor Mazin, seconded by Councillor Nishikawa. Be it resolved that the Planning Committee recommended recommend to Township Council that the zoning bylaw amendment ZBA 54/22 bylaw 2022-189 be approved, subject to the following minor amendment: that a 164-foot yard setback be required for land-based buildings and structures, and any leaching bed distributed pipe on the severed lot. Any discussions? All those in favor? Carried. The next case is B 53-6222 ML, Tames and Stevenson, and that again is Ms. Walker.
Thank you very much, Chair Bosenworth. The next application to be heard is consent applications B/53/62/22 ML and zoning bylaw amendment application ZBA-55/22 bylaw 2022-190 in the names of Tames and Stevenson. The subject property is known municipally as 2109 Lake Muskoka Shore. I would direct committee's attention to the submitted consent sketch starting on page 166 of the agenda package. The purpose and effect of the application is summarized as follows. 2 severance applications have been submitted. The first is for a lot addition to the neighboring property to correct an encroachment of existing legal non-complying 2-story boathouse. The second consent application is for the creation of a new lot. Bylaw 2022-190 will provide an exemption from the minimum lot area requirement of 2 acres. The proposed new severed lot is intended to have an area of 1.5 acres. Bylaw 2022-190 will also provide an exemption from the maximum dock width requirement of 75 feet. The existing docks on the retained lot equate to 91 feet in width, and there is a requirement to recognize this width owing to the reduced frontage from the severances. The majority of the dock width is comprised of an encroaching dock from the neighboring property. Bylaw 2022-190 will also provide an exemption from the minimum side yard setback of 30 feet for a dock. An existing dock on the retained lot is to be set back 1 foot from the new lot line projection, resulting from the creation of the new severed lot. Notice of this public meeting under the Planning Act was circulated 23 days in advance of today's meeting, and 7 submissions have been received to date. Comments have been received from Nick Snyder, the Township's Chief Building Official, Tim Sopko, the Township's Public Works Technician, Douglas Holland, the Township's Fire Prevention Officer, Curtis Savret, District Planner, and 2 letters of objection have been received. The first is from Marcy Anderson, an area property owner, and the second is from Cynthia Krelsey, the owner of the benefiting lot. These submissions were circulated to committee prior to today's meeting, and I'm happy to read any submission in full at the request of committee. After submissions were circulated, a letter of support was also received from Stephen Benson, an area property owner. The submission is as follows. To whom it may concern, I am a very close proximity neighbor to Lee Stevenson and the property she is asking to be allowed to be severed in the Tames and Stevenson application. I state clearly that I am in full support of the severance. I am also an elder at the Church of the Kettles Board of Directors and can state that the church is an immediate neighbor. And after discussion, it can be stated that the church board is also in favor of this severance. I've prepared a detailed planning report for committee's consideration. If committee is considering approval, staff have made a slight modification to the recommendations that are outlined in the staff report. Staff have opted to separate the 2 consents into 2 separate resolutions. If committee is considering recommending approval of B/53/22 ML, which is the lot creation, staff have recommended the following conditions: that a satisfactory registerable description and deed of the severed lot, together with any required rights of ways or easements, be submitted to the township along with a registered copy of the reference plan. That consent application B/62/22 ML be finalized prior to the consent application B/53/22 ML. That confirmation be received from the town that the township is satisfied that the retained and severed lots are satisfactory for on-site sewage disposal, and that any problems identified with the existing sewage system be corrected to the satisfaction of the township. that the proposed lot line between severed lot 1 and the retained lot be adjusted to bring the existing as-built dock on the southwesterly shoreline of the retained lot into compliance with the required side yard setback of 30 feet. That the applicant enter into a consent agreement with the township pursuant to section 5126 of the Planning Act. Said agreement shall be registered against the title of the lands and contain provisions to the satisfaction of the township, whereby the owner agrees to, first, not utilize public parking and docking facilities as a principal means of access to the retained lot and severed lot 1, and that adequate long-term parking and docking facilities used to access the severed lot be secured at all times. That a cash in lieu of parkland be dedicated to the township in the amount of 5% of the assessed value of the severed lot or the entire lands, whichever is less, and that the zoning exemptions to be approved to permit the creation of the severed lot 1 with an undersized area and recognize the existing overwidth docks on the retained lot. If committee is considering recommending approval of consent application B/62/22 ML of which is the lot addition application, staff have recommended the following conditions: that a satisfactory registrable description/deed of the severed lot together with any required rights of ways or easements be submitted to the township along with a registered copy of the reference plan. That a legal undertaking be submitted in order to confirm that severed lot 2 will merge in title to the lot it is intended to be added to upon registration of the transfer/deeds. That subsection 3 of section 50 of the Planning Act applies to any subsequent conveyance of severed lot 2. And that confirmation be received that the township is satisfied the retained lot is satisfactory for on-site sewage disposal, and that any problems identified with any existing sewage system on the retained lot be corrected to the satisfaction of the township. If committee is considering recommending the approval of zoning bylaw amendment application ZBA 55/22 bylaw 2022-190, staff have recommended the following minor amendment: that exemption C, which is to permit a dock to be 1 foot from the side lot line projection, be removed from bylaw 2022-190, owing to the recommended condition of consent requiring the southerly side lot line projection to be reoriented to achieve a compliant side yard setback. I have no further comments, but I'm happy to assist committee with any questions. Thank you.
Thank you very much. Do you have a point, Councillor Davis?
I do, thank you, and through you to you. I wonder if Ms. Walker could read the letter of objection at the beginning of her presentation from a person who's from a benefiting lot. I think that's what I heard.
Yeah.
And I'd be very interested in understanding.
So I can
We
read
can
that in full
Yeah, I
if you
think-
would
I think
like.
that's
It
appropriate.
was circulated to committee, but let me bring it up here. So this is a letter of objection from Cynthia Carlsey, and she is one of the owners of the benefiting lot. So the benefiting lot in the application is owned by myself and my sister. Both properties on the application have been in our family since approximately 1946, the benefiting lot, and 1971, lot 2 and proposed lot 1. I'm writing to you today to express my objection to the proposed location of the new southern lot line for the retained parcel contemplated in consent and severance application B/53/22 ML. In my view, if there is to be a lot creation exercise on the property, it should be seen as an opportunity to reflect the existing conditions and to, as much as possible, bring the existing lots, buildings, and structures into conformity with the current requirements of the zoning bylaw. For the following reasons, I believe the new lot line should be established to the north of the small cabin at the tip of the peninsula as shown on the attached sketch prepared by MHBC Planning. We can share that sketch later if that's helpful. So number 1, this is the first point in the letter. The lot creation exercise should reflect historic and practical arrangements. The historic arrangement in the family has been that the cabin has been part of my property and has been used as such since it was purchased in approximately 1971. For example, The cabin is even supplied with power from my property. Discussions amongst the owners, including my late mother, who was on title for the proposed severed lot and the retained lot at the time of her death, resulted in drawings showing where this alternative line might be drawn at the end of the Smith. Please see page 2 of the attached document from MHBC Planning. I believe that if approved, the consent should reflect this historic and practical arrangement. Point number 2. The consent should eliminate or reduce instances of non-compliance. Currently, the number of buildings and structures on the benefiting lot is significantly over the allowed density. If the new lot is moved to the north, as I have suggested, from the additional land added to the benefiting lot, will alleviate much of the density problem. Excuse me. At the same time, moving the lot line slightly further to the north will not affect the area or density compliance of the retained lot. The proposed location of the southern lot line on the retained lot will create a non-complying situation. The dock and ramp attached to the existing boathouse with a second-story sun deck will only be 15 feet from the property line, whereas a 45-foot setback is required for the boathouse. Creating a new lot line only 15 feet from the dock and ramp would potentially create issues for the enjoyment of the property on both sides, especially if ownership were to change in the future. Point number 3, the consent should normalize the lot pattern. The azimuth of the land runs between the benefiting lot and the retained lot is very narrow. The lot line proposed in the application creates 2 irregular shaped lots, whereas the lot line I am suggesting would normalize the lot pattern and eliminate problems and confusion over matters such as lot frontage, area, utility location, just to name a few. I would look forward to discussing this matter with committee on June 15th. In addition, I request that my sons, Lewis and Douglas Carlsey, be permitted to speak with me if necessary on the matter during the meeting. Regards, Cynthia Carlsey. And there's also an attachment from the planner that they retained, MHBC Planning, which I can read if you would like, but we could also bring up the photo showing the proposed lot line. Is that?
I think it's best if we have Mr. Fauner speak on behalf of the applicant. Perhaps he can address these issues.
Okay.
Please go ahead, Mr. Fauner.
Thank you, Chair Bosworth, members of Planning Committee. Again, it's Steve Fauner, Northern Vision Planning Limited, 109 Meadow Heights Drive, Bracebridge, Ontario, P1L1A4. I'm here representing John Tames and Lee Stevenson. John is actually the son of Lee, and he's actually seeking to obtain the title to the proposed severed lot, and he wants to build on that property in the future, hopefully. Thanks for the detailed report that Caitlin provided and her support of the application. If I could just have my PowerPoint presentation come up, and I will address in my presentation the objections, at least in my view. Next. So again, the lot being created, the vacant lot being created is 1.5 acres, but it has very sizable frontage. And I think, as we know, when we're dealing with density on the waterfront, actually the frontage is the more or better determinant than the lot area. And it has 454 feet straight line. Its actual frontage is probably about 550 to 600 feet. The retained lot, which currently has development on it, is 300 feet of frontage and 2.4 acres. Next. And in terms of the lot addition itself, it's a relatively small lot addition to clear up existing encroachments of existing shoreline structures. 75 feet of frontage is being provided in almost 3,000 square feet of lot area. Next. So this is just an outline of the entire lot. And you can see the proposed severed lot to the northwest. That's the vacant one, and the retained with development. And the next slide will focus in on the small lot addition. Next. So I just want to point out here, the current lot line itself goes right through the boathouse. It's where the red and the blue line join. The blue is the abutting lot. And you can see the docks on the left-hand side, in fact, are not even on the property right now, even though they do use them. There is the cabin there. You'll see that in pictures, and that was mentioned in the objection as well. It's kind of the subject cabin, if you will. That has been used by both families. It's not exclusively to the family to the south. And in fact, my clients want to refurbish that cabin and update it, and it'll be for everyone to use, not just for their use. Next. So in terms of the site itself, this is the north shore of the proposed severed lot. Next. This is the point of land at the northwest corner, and this extends into the bay to the right as well. Next. This is the frontage in the bay. Again, the actual frontage is at least 550 feet on this. Next. And this is just taken on the property, and certainly Caitlin did walk about the property, and it's fairly level actually for Muskoka standards. Many access points for construction and numerous building sites on the property. Next. This is the photograph of the, on the north side, this is the retained lot and the existing dwelling that's on the property. Next. It's a very modest cottage. In fact, it only has one bedroom in it. So one of the reasons why the severance is occurring is it's a little bit crammed for John and his family in there, as well as Lee. Next. This is one sleeping cabin near the North Shore, really just the size of a shed, quite frankly. Next. And this is the sleeping cabin down near the lot addition. Again, they're both very, very small. Next. This is the boathouse in question, taken obviously from the water, and you can actually see the sleeping cabin off to the right, the small one that was in the previous picture. Next. And this, again, you can see the sleeping cabin better. We're going to be 15 feet off of that flat dock to the right there, and the boathouse will be almost 30 feet off of that side lot line when we're done. And that actually complies with the setback for non-complying structures. New structures, it's 45 feet, but these structures are obviously existing. Next. This is again, the boathouse in question. Next. And this is the ramp dock beside it, and we are going to be 15 feet to the left of that dock with the new proposed lot line. Next. Just another picture of that ramp dock. Next. And this is looking at the other shore on the other side, and you can see the docks in the middle of the picture. Right now, those are not even on the lot, the abutting lot, but after the severance, they will be. There is a chair or settee there you can see in front of the rock. That's the proposed lot line will be just immediately to the left of that, actually, right in line with that pine tree. Next.
Mr. Fonner, you are at your 5 minutes, but I'll let you go over.
Okay.
To address
Well,
yeah,
let's just carry on. Next. I'll get to the objection, Jess. Next. Next. And we do have a water access agreement with Mortimer's Point Marina. Next. And anyways, okay, so getting to the objections, it must be noted that there's more than one owner of the abutting lot. One of them is objecting, but not the other. It's clear there's no objection to the vacant lot being created. The sleeping cabin, as I mentioned, is used by both families and will continue that way. And my clients wish to restore the cabin at the same size. The primary reason for the lot addition was to clear up encroachments, but not to remedy overdevelopment of the abutting lot. It is over lot coverage, but that wasn't the aim of this. It's to clear up the encroachments. Next. One of the things I really want to emphasize is that the applications are a balance of remedying the encroachments, but retaining enough lot area for the new lot creation. We're really at a very minimal size for the lot creation. Overall, we're almost at the 4 acres required for the severance. We're at 3.9. So anyways, it's really a balance. So if more land is being added, it must come at a cost. There's no cost for the land being conveyed in this application to the abutting landowners, but there's been no offer to purchase any more either. So I would say it's a bit of a family matter, unfortunately, that we're caught up in. It's my opinion the decision should be based on the application that's in front of committee. It's up to my clients to clear up their family situation. Next. In terms of the other objection, the proposed vacant lot is 1.5 acres. The 1.3 acres was put in the bylaw just to allow for a little bit of leeway when creating, but the overall property is just over 4 acres. And in my opinion, it's within the intent of the official plan. And the distribution of the land is really a secondary matter as to who gets a little bit more acres than another. As long as you meet that overall number of 4 acres or close to it, then you should be able to divide. And planning staff has been to the property and agreed that the vacant severed lot is a viable lot. Next. And just one thing I want to point out too is that I'm requesting there be 2 decisions, and Caitlin said there would be. I would also, one piece of information that you may not have is that the church is going to be removing their docks, at least at the shoreline. It's my opinion that really that exemption should be deleted out of the bylaw regarding the cumulative dock width, and that my clients will have to comply with 75 feet. That's something for a committee to consider. And the 2 applications should not be tied together in any way, just in case for some reason the lot addition doesn't go in the end. And currently, I think now you've tied them together. Next. So I won't go through my conclusions. I think you've probably heard enough from me, and I appreciate the extra time, Mr. Chairman.
Thank you very much. Do we have anybody wishing to speak in support of this application?
Yes, I'll speak.
Yes. If you could give us your name and address, and you get 5 minutes or a couple of minutes. Yep.
316 Nairn Avenue, Toronto, Ontario, and it's P.
I think you'll have to turn your mic on. Sorry. Yeah, it's all right.
John Tames, 316 Nairn Avenue, Toronto, Ontario. I'm 60 4H8. My mother and I own the retained lot, and I just wanted to say, you know, on the basis of our application, other than the severance, our main intent is really to deal with the encroachment and set the lot line out from underneath the boathouse. And that's why we're putting the application forwards. The challenge obviously is bringing this forward to the other members of the family is taking a little bit of time, and I putting the application forward to resolve the issue. I had to take it upon myself to get an agreement. I put this offer to them a little while ago in writing. I was able to get agreement from one of the owners. Obviously, the other owner is objecting. I think, as Stephen has said, really, it's a balance between all of the different parties involved, the bylaws as well. I think the main challenge is that from a planning perspective, it does meet all of the guidelines. There's a lot of merit to dealing with the encroachment issue. I think the nature of the objection really boils down to the fact that it doesn't demonstrate a clear agreement amongst all of the parties, and that's sort of the basis of sort of the family dispute. So I really, you know, on the boundary adjustment, hope that you would approve the application on the basis that, from a planning perspective, it's the right position, and with respect to the dispute, it's really a matter for the family to deal with, and I think that you know, making that change is still a benefit to their side as well. With respect to the severance of the point, I think there was one objection, so I'll just mention on that basis that the division of the land is sort of set at a natural boundary, and the way that the lot is sort of defined is doesn't give the appearance of density. So I think that in the basis of the severance, it shouldn't really be a major concern, and I think it should also be approved too. So that's all I have to say.
Thank you very much. Is there anybody else wishing to speak in favor of this application? If you could state your name and address, please.
We're still on, yes.
Yeah.
My name is Brian Casey. My address is 1392 East Bay Road, Torrance. And I am the friend and partner of Lee Stevenson, the other owner. And she's asked me just to speak on her behalf very briefly. With respect to the first application, which is the division of the 4 acres into 2 lots, it would be nice if they were equal and you get almost 2 acres on both, but the topography is such that we've done the best we can, taking the advice of the professionals. And the topography is what it is. And you've heard from the professionals, and we certainly defer to them. This is the second lot that's being created is for John, Lee's son. With respect to the objection on that property, the division, the complaint is that this would set a precedent, but as you know, we don't set precedents here. And this is under the old legislation, not the new legislation. So there's no precedent being set. With respect to the offer to correct the boathouse encroachment, again, family property going back years, we're told this is the proper planning solution, that it will comply. The fact that one of the owners would like to get more land to solve their problem of their overbuilt is not something that's a planning issue. And so again, we've taken the advice and we think that what's put before you is a proper planning solution. Thank you.
Thank you. Thank you very much. Do we have anybody else wishing to speak in favor of this application? And do we have anybody wishing to speak against this application? You could bring them in.
Cynthia Carsley. I'm a co-owner of the benefiting property at 2096 Lake Muskoka. I live at 18A College View Avenue, Toronto. And I would like to speak to say that we've had many discussions over the years. We're here today because the proposed property line on the application doesn't reflect the intent of what's been discussed in the past and doesn't set the property up for proper enjoyment in the future. I would like to defer to my 2 sons, but before that, I'd like to say that my sister, the other owner of the property, has had a death in her family. Her husband died, and her son is online and is in agreement with my 2 sons who are here today to speak against the proposed property line. Here are my sons to speak, Louis Carsley and Douglas Carsley.
Hi. So thank you for reading out the letter. Obviously, it's fairly detailed. I guess I would add, as my mother did, there have been many discussions to try to bring this issue to a close. We've talked to Stephen, obviously to John, to Lee, et cetera. And we really, we don't want to trying not to bring this down to a family matter. Rather, we look at it as an opportunity for the committee to bring this side of the property, the benefiting lot, into closer compliance at this point, and to create a regularized lot. I would also note just a couple things. We also have a real estate opinion from Jamie Blair, oddly enough, as to where the natural lot line should be, which we've, is in that older proposal, which we submitted as well. And I would also note that the 30-foot dock setback is being applied to the other part of the application too. And we realize that the boathouse was built some time ago, but again, we look at this as an opportunity, to bring this forward into closer compliance and to follow today's rules versus what was set out some time ago. And I think that that's our main comment. We have no issue with John's lots, and in fact, John and Leanne's lot proposal. And in fact, I would note that it seems like on the lot with the 2.4 acres, should more property come to the benefiting lot or the, I guess, severed lot 2, that acreage would still be well in compliance with the 2-acre requirement for today. Thank you.
Thank you very much. Do we have anybody else wishing to speak against this? Mr. Cooper, if you could. Morning, Mr. Cooper, if you could state your name, address, and you have 5 minutes.
Okay, thank you. George Cooper. I'm calling in from 37 Bayview Heights, Conception Bay South. I'm the son of Alice Cooper, the co-owner of the benefiting lot, and also the cousin of John Tames and nephew of Cynthia Carsley and Lee Stevenson. And I just want to clarify that I'm not here to speak against the application. Overall, in terms of the severance, there's certainly history where my father had been working on potential planning for that severance in the past when the 2 different lots were co-owned family properties. So to us, it makes a lot of sense to give flexibility to that property and also preserve the historic cottage that's on the retained lot. And in terms of the boundary adjustment to address the encroachment issue, my mother had indicated her acceptance of that issue. And I certainly hear the concerns and objections of my family members, and I'm really here to hear feedback from the committee and help take that back to my mother and help the family work through the solution and decision following the outcome of this hearing. So just wanted to clarify that as well in my position. That's all I had. And thank you for the opportunity to speak.
Thank you very much. Is there anybody else wishing to speak against that? All right, let me turn it over to committee for questions. Councillor Zavitz.
Thank you. I know this area very well. Thank you for that opportunity to speak. And I guess I would look to Mr. Fauner, if I might. First question of 2. First question would be, was reference that the Kettles Church is removing their docks. Now, is that hearsay or is that a known thing? And if they are, that may have some impact on this close proximity. I mean, the properties next door. It's the first I've heard of that. So is it all of the docks that would be removed from there? And I'm wondering why.
Mr. Fauner?
Yeah, through the chair to Councillor Zavitz. Yes, it's been direct communication by Lee Stevenson, one of the applicants in this case, to the church, and they have indicated that they will be removing at least the shore dock, which is the one that actually provides the most width, if you will, in front of my client's property. I'm not sure about the other dock that goes over the projected lot line, but certainly the shore dock, they've indicated that they will be removing sometime in the future, and I take it that the future, it's not going to be too far down the road. We're not talking 20 years. I think it's going to happen fairly soon. And one of the reasons being is that there's a liability concern for my clients if something happened on that dock in particular. And of course, she would like it removed. And given the fact that it's 20 meters over onto her property, that's pretty significant. And but anyways, it's been direct communication between my client and the church.
Good, thank you. I guess my second question would be maybe more of a statement to you, but we in this committee over the years have dealt with the situations like this in the past where there's familial discord, if you will. And it certainly would be my impression that I'm wondering if this would be deferred for further discussion between the family, some here, some on screen, to come to a better, if there is such a thing as a better solution, such that then this committee could contemplate that. I guess my question would be, and I'm not sure if it's fair to even ask you or mention it to you, but can there be any movement? Is there any latitude for discussion so that the family could come back here in 30 days, 60 days with I hate to say it, but a more viable, reasonable to more people, to all solution? Thank you.
Mr. Fauner, if you could comment on that.
Yeah, thank you once again. Yeah, may be difficult for me to answer. I guess, I have to answer from the planning point of view and as a professional planner, trying to balance the size of the property and the new lot being created here. We're just under the 4 acres, and that's sort of the minimum for a water access property. And we're also still able to clear up the encroachments. That's, to me, is the key thing anyways of the existing boathouse. I think the owners of the abutting property would have difficulties if they ever wanted to sell or ever wanted to mortgage the property in its current state because of the encroachments. So we're clearing that up. So I'm emphasizing it's a balance. I would be concerned about reducing the retained lot and reducing that, because is it then someone's going to say, well, you're not within the intent of the official plan for the new vacant lot creation? It's a balancing act here. And so from a planning perspective, that's where I come from. If you want to get into the family perspective, quite frankly, you're best to ask my clients that.
Councillor Edwards.
Yes, somebody in the planning department. So if this lot addition did not go through, I think I heard Mr. Fauner say that the benefiting lot at this time would not be saleable because there's an encroachment. So, maybe the family should talk about it, because they said there was no charge or anything else like that. I think this is a good compromise, but I just want to know, would it be saleable if there is an encroachment, if this did not go through?
Ms. Walker, perhaps you could give your opinion, or
through you, Chair Bosenworth. Thank you for your question, Councillor Edwards. I'm not an expert. I'm not a lawyer or a real estate agent, and I'm hesitant to say, what the repercussions or complexities could be of trying to sell a property with encroachments. But I think, obviously that is one of the benefits of this application is the lot addition would resolve the encroachment. So I don't think I can answer your question, unfortunately.
Mayor Kelly.
Thank you, and through you. I'm going to key off something that Councillor Zavitz said. I'm going to take it right to the family rather than to Mr. Fauner. I'm very uncomfortable being put in a role where making a decision based on good planning also acts as, I will say, an almost irrevocable decision as to some family dispute. And so the question to the family, and I'll be honest with you, I've lost track of who's on what side of whom, but to the group who represented both sides on the family, I did hear from Mr. Fauner, I heard from Mr. Tames, and I was writing as fast as I could. I think I heard from Mr. Casey something along the lines of, don't worry about this matter. It's really a matter for the family to deal with. I couldn't agree more. It is a matter for the family to deal with. And so my question is the fact that we're here today dealing with this issue as a Planning Act matter to be interpreted that the family can't come to a resolution, and you're just going to let the planning committee of the Township of Muskoka Lakes make that decision for you? Because if it is, I think we need to know that.
Mr. Tames, would you like to comment on that? I think we're looking for an opportunity where perhaps you could solve your family problems before we have to solve them for you.
Well, I think the main point was the intent was never to raise them here. And based on, I guess, to answer the question directly, could we come to a better more mutual agreement? The challenge has been that the negotiations haven't flown very smoothly. And I think as a testament of that, it's been raised here. I've been very open. I've been always open to having as many hours of discussions as needed to try to solve it. I think the concern is not that I wouldn't continue to try to come to a better agreement. I think the concern is just based on the length of time that we've been working on this, and the fact that during all this time there is an issue with the property. My concern is that I don't know how long it would take to address it, and I think in fairness to all of the owners, not just the ones disagreeing, it makes sense to at least restore the property to a state where it's compliant to the regulation. There's, as Brian said, the way the property is divided, it doesn't preclude any further changes in the future if we are ever to agree to offer them more than we are currently offering. Because we have a little bit more space. Stephen mentioned that now is not the time for that because of the severance. So that's my thought on that.
Thank you very much. Supplemental?
Yeah, quick comment back, and that's fair comment. I mean, my concern, quite frankly, comes from the fact that everyone who's on title and everyone who has a familial relationship with somebody on title, or maybe a beneficiary under a will, or I don't have any idea how we're all related, has rights. And I got the impression from some of the comments that some people aren't aware that they might have rights. And so my concern is we're dabbling into a decision that looks easy, or not easy, but that pity perspective, we're going to walk into all sorts of mess and litigation and potential litigation when people wake up and realize, geez, I should have done something differently. So coming here with this fixed, and I know it's hard and I know it takes time, but coming here with that family side fixed and allowing us to focus on what we do best, which is not family relations, everything to do with rights under the Planning Act and planning applications, would make this the source of considerably less indigestion for us, I think. And I think, frankly, it will lead to peace of mind. This property is going to end up being a perpetual wedge. You know, if you can't fix it now, wait till we figure out how to sever it up and then try to fix it. I'm not lecturing. I'm telling you right now, I'm uncomfortable dealing with something in the guise of a planning application that feels a lot more like, well, we'll just give it to them to figure out our family situation. That's it.
Councillor Nishikawa.
Thank you. Much along the same line that the mayor and Councillor Zavitz had raised, I just wanted to confirm with staff that they feel that the people that applied for this application are the owners of the land that they're requesting to have severed. If you understand so where I'm going is that, in fact, the municipality has done their role in dealing with the people that own the property. That the application came under. So you got signatures from all of those ownerships under that application. I'm still going to be requesting a deferral, but in fact, I do believe that the municipality, when they receive an application and that ownership is under the people that applied for it, that we should be moving forward regardless, because those family disputes there's always some family disputes in the background, but we'll never get it. It's not our place to get involved with any of that. But in reality, if the people that have applied for this have the legal right to do so, I believe we need to have an understanding at this committee that we need to act on it or not. So I would still ask for a deferral today, but I would like confirmation that those that had applied do have the legal right to do so.
Ms. Walker, can you comment on that?
Through you, Chair. So I think what I can say, in circumstances where a lot addition is being contemplated, the application is made by the owners of the retained lot. So there's no signatures given by the owners of the benefiting lot. I don't know if that helps clarify anything.
Interesting. Thank you.
Mr. Sharp.
Thank you, Chair Bosenworth. Just to add to that, I am looking at two consent applications that have been on Tames and Lee Stevenson, one for the lot creation, one for the lot addition. Mr. Fawner is identified as the authorized agent, and they look like they've been appropriately signed. So, and as Miss Walker had correctly pointed out, it's these owners that are applying to sever their lands and add them to a benefiting lot and to create a new lot. So I think we're covered. Thank you.
Councillor Zavitz.
Thank you, and through you. So I think as a Ward 8 councillor with my fellow councillor Nishikawa, I certainly wouldn't be supporting this today and would suggest a deferral to the committee. The mayor is correct. I mean, we don't just contemplate this can be a very philosophical place. We see it every day. Councillor Nishikawa pointed out, there's a lot of familial challenges behind the scenes. This one is right in front of us. And we have on many occasions sent folks away with their fingers crossed for 30 days, 60 days, hoping that there is a way. I mean, you now know you're in front of us, and there seems to be an appetite to set this aside legally, politically, planning wise. Yeah, all the dots are there and the T's are crossed, but it doesn't feel right to me. So for that regard, I would be recommend a deferral.
Committee member, I'm getting a sense here that deferral might be the idea. Just get a general idea. Does everybody? You can, yes, one.
Just to clarify, deferral would be just for the boundary adjustment?
It would be for the whole case.
But they're two distinct applications, so I just would like to know why.
Well, because they're dependent, I think. The size of your retained lots will be changed as the boundaries changed. Councillor Edwards.
I would like to ask, because I think that the actual severance could go through, and that's a severance. As far as the lot addition, they did say that this was something they were giving, they weren't selling. And that, so why would we hold them up on that? Because if they could come back and say this, they don't want the severance.
Mr. Sharp,
with the lot addition.
Can you comment?
And that is the case that they're really in a muddle. So I would prefer to go ahead with the application of the severance, but not the lot addition. We can defer that if like.
Mr. to do.
Through you, Chair Bosenworth. So as Ms. Walker had noted in her introductory presentation, we've broken basically the resolutions that you have in front of you today into two separate resolutions. And the one resolution dealing with the lot creation application, there's a condition that requires the lot addition to be finalized first, which I know that Mr. Fauner had indicated that he disagrees with. But the reason that we've done that is because there are docks and boathouses on what is the severed lot. And there's an exemption, a zoning exemption in front of you today to recognize the dock widths. So if we don't proceed with the lot addition, it means that there's more dock on the retained lot that's required to be recognized. So I think from an administrative standpoint, from a compliance standpoint, I think staff's preference would likely be to, if we're going to defer, is just to defer the matter in its entirety. And part of the reason I mentioned that is because I've just been speaking with Ms. Walker here just briefly, and I don't recall, or I don't believe that there's been discussion with staff regarding the addition of some of the lands surrounding the sleeping cabin that's at issue here to the benefiting lot. And there may be some opportunity regarding that. It's just that I don't think it's been explored with staff. So, a deferral may be helpful, and staff would certainly, be happy to speak with Mr. Fauner and see if there's something that we can if there's a solution that can be arrived at here. So I just make those comments. Thank you.
Thank you very much. Mr. Fauner, a comment?
Yeah, just very briefly, and I certainly understand Mr. Sharp's comments about deferring maybe the whole matter. I'm wondering, with the indulgence of committee, whether, Mr. Chair, you could maybe take a straw vote maybe on the severance itself, the vacant lot, because I think my clients are quite concerned that if you defer the whole matter, they're really concerned that they may lose that severance. And for them, actually, that's their number one priority. So I don't know if there's any thought of just getting an idea of if there's any concerns about the severance, and if everything's okay there, at least we kind of know in principle that you're okay with that part of it, and we'll work things out on the lot addition. Just a suggestion. Thank you.
Committee, how does anybody feel about that? All right. I think it's fair to say that committee would like this whole case deferred, and we will see you as soon as you can come back with an improved plan. Do we need a resolution for confer?
Instruction for staff.
All right.
Perhaps from David or from.
David, you got any suggestions on wording? You know what? Let's take a we got a 15-minute break anyway, and we'll come back at that. Councillor Roberts, sorry, thank you very much. Councillor Roberts.
Sorry, Chair, and I don't know who to present this to, but I understand the deferral was going back for the two parties to get together to see if they can come up with a better compromise or a compromise on this, not an improved application. I don't even understand my difference. Like I agree with Councillor Nishikawa. We could go forward right now with the Planning Act. In my understanding, but I'm looking for a deferral. Like specifically, tell me why we would do a deferral. How's it? Why are we asking for a deferral?
I think certainly my experience is we often make deferrals because neighbors have to work. People have to work things out with their neighbors. I think this is exactly the same thing with perhaps a little more intensity because it's not neighbors, it's family.
Okay. So I'm okay with that, Chair. I'm okay with that explanation.
With that?
Yeah.
Councillor Nishikawa.
I'm also interested in finding out, I'm just giving some direction for the clerk too. I'm also interested in looking at the alternatives because it was mentioned that they could possibly change some lot lines to accommodate the cabin and different things like that. So I'm looking at the further alternatives for this application.
I think that's fair to say that might be part of the discussion. All right, so let us take a 15-minute break. We'll be back at 11:15. We'll have a nature break, and by that time we will have the revised resolution.
Just like, yeah,
All right.
I know.
Welcome back at 10:45. We now have a resolution to postpone the case we were speaking about. I'm going to read it. We can have a quick discussion and then we can move on to the next case. Moved by Mayor Kelly, seconded by Councillor Roberts. Be it resolved that Planning Committee postpone consideration of consent application B/62/53/22/ML and ZBA 55/22, bylaw 2022-190 to permit examination of alternative lot lines and further consultation between the applicants and neighboring property owners. Any discussion? Seeing none, I will call vote. All those in favor? Carried. Thank you very much. Our next application is B/16/17/18/19/375, no, /20/21/22/23, ZBA 1023 and bylaw 2023-04. This is Baker, and Mr. Soya is going to tell us about this case.
Thank you, Chair Bosemorth. So the next applications to be heard are the applications that you've listed. Those are consent applications B16 through to B22 of 2023 and concurrent zoning bylaw amendment application ZBA 1023 and bylaw 2023-040 in the name of Baker. And the subject properties the subject property includes 7 existing lots, all of which are in the waterfront designation and either front onto Lake Muskoka or are located in close proximity to Hamels Point Road. Close proximity to the lake. There's a couple existing lots that don't actually front on the lake. The primary intention of these applications is to improve the configurations of the existing lots, and these applications are quite technical. I would direct committee's attention to the sketches starting on page 246 of today's agenda package. The first sketch shows the existing lots, and the second sketch shows on page 247 shows the resultant lots. And a comparison of these two sketches provides a good overview of what these applications intend to accomplish. The 6 sketches that follow, they show the proposed severed, retained, and benefiting lots of each consent application. While the details of each consent application and the sequencing of this series of consents is important from a registration and conveyancing perspective, the important planning considerations are most easily considered by referring to the before and after sketches on pages 246 and 247. With regards to understanding the purpose of the consent applications, it is important to note that existing lot 5 currently cuts through the subject lands and thereby prevents the shoreline lots from having direct access onto Innisfree Road. The consent applications intend to divide most of existing lot 5 and all of existing lot 7 and combine these lands with existing lots 1, 2, and 3. So the purpose of this change is to provide lots 1, 2, and 3 with direct frontage on Innisfree Road. Although driveway access to lot 3 is still provided by a right-of-way. As the applicants do not intend to completely eliminate existing lot 5, this is the one that cuts through the center, the shoreline portion of this lot is to be connected to Innisfree Road by the creation of what's shown as resultant lot 5. So the only resultant lot that would still not directly abut Innisfree Road is resultant lot 4. However, its size is intended to be increased. The proposed zoning bylaw amendment has several purposes. Firstly, an exemption has been requested to permit the creation of resultant lot 5, which would be an undersized lot in the waterfront residential zone. but it would not be deemed as a building lot. It should be noted that resultant lot 5 is essentially replacing existing lot 5, which today is also an undersized lot. Secondly, exemptions have been requested to permit the lot frontages of resultant lots 1 and 2 on Lake Muskoka. Here it should be noted that these frontages are the same as those that exist today, and only the configuration of those lots away from the shoreline is changing. 2 site-specific bylaws apply to portions of the subject lands today, and as these bylaws will not be directly applicable to the proposed new resultant lot configuration, these existing bylaws are to be repealed. Exemptions have also been requested to permit the shoreline structures on resultant lot 4. A boathouse with a rooftop sun deck is required to have a side yard setback of 45 feet. In this case, it is proposed that the existing boathouse, which has a rooftop sun deck, will be set back 30 feet from the proposed lot line between resultant lots 3 and 4. Therefore, an exemption is requested. Resultant lot 4 also has a proposed lot frontage of 253 feet, and docks would be typically permitted to have a width of 25% of this frontage, which in this case would be 63.3 feet. However, the proposed cumulative width of the existing docks is 70 feet, and therefore an exemption is requested. Notice of the public meeting was circulated 20 days in advance of today's meeting in accordance with the Planning Act, and 6 submissions have been received to date, all of which have been forwarded to committee in advance of today's meeting. The District of Muskoka has submitted comments advising that district staff would not be opposed to the approval of the applications. The Township's Development Services staff had advised they have no objections, and also the Public Works Department has requested a condition of consent requiring confirmation that entrance permits are available. Bell Canada has submitted comments requesting that an easement be granted along the route of the existing facilities in favor of Bell. And the letter explains that since the easement is required in order to provide and sustain service, all costs associated with this transaction would be at the responsibility of the owners. 2 submissions have been received from members of the public. James and Joanne Watkinson, owners of the shoreline property directly to the south of resultant lot 5, have advised they are in favor of the applications and have no concerns. Nathan Watkinson, the owner of the property further to the south of the James and Joanne Watkinson property, have also advised that, or he has also advised that he is in favor of the applications and has no concerns. Staff have prepared a detailed planning report for committee's consideration and have recommended that the consent applications be approved, subject to several conditions of consent, to require the submission of registrable descriptions of the severed lots and any required rights of way and easements to be submitted to the township. Several conditions are also recommended that will ensure the proposed severances will be finalized in their intended order. And conditions are recommended to require confirmation that the resultant lots can be appropriately serviced by sewage disposal systems, and to require confirmation that entrance permits are available. And a condition is recommended that requires approval of the proposed zoning bylaw amendment. And staff have also recommended that the zoning bylaw amendment be approved, subject to a minor amendment to the draft bylaw. A review of floodplain mapping data revealed that a significant portion of the subject lands is identified as being within the floodway of Lake Muskoka. To address these flooding concerns and the associated policies that would apply, staff have recommended a minor amendment to the draft bylaw. It currently, in the resolution currently before committee today and in the staff report, it reads to prohibit construction or enlargement of any land-based buildings and structures, with the exception of shoreline structures below a static floodline elevation of 226.7 meters above sea level. So on this matter, the applicant's agent, Mr. Fauner, has recently advised that his client is hopeful that this wording, as described in today's resolution, could be elaborated on a little to make it clear that the permissions that typically would apply to existing legal non-complying development in the township would still apply. And by this, I mean the permissions to rebuild existing buildings and structures. So based on this feedback received from Mr. Fauner, I've drafted some revised wording for consideration in today's resolution. And Mr. Fauner has viewed that wording this morning, and I believe he's here to speak next. So I'll leave it at that, and I'm available for any questions, but he might be able to speak to that matter. And if committee would like that revised wording shared, then that can be shared for everyone to have a quick look at if Mr. Fauner agrees with how it's worded. Thank you.
Thank you, Mr. Soya, for that very well covering what is clearly a very complex case. Mr. Fauner, if you'd like to please keep this to 5 minutes.
Good morning, Mr. Chair. Once again, Stephen Fauner, Northern Vision Planning Limited, 109 Meadow Heights Drive, Bracebridge, Ontario, P1L1A4. I'll try to do my best to keep the timing quick, although I do have 8 applications in total here that have been rolled into one. So I wish I could do 8 times 10 minutes or 5 minutes, but anyways, I know that's unreasonable. So thank you, Sam, for the detailed report, and certainly the table was excellent in there. If you could just put up my PowerPoint presentation, that would be great. And I'll try to stay away from the process. I will say that in terms of the process itself, John Hiley was the one that sort of initiated how the applications would be done, and Melissa Cope and myself did review them. So they know more about these things than I do. So that's where the process came from, and it's the way to deal with these applications. Next. I'm going to try and keep this sort of at a high level, but it's really just a series of lot additions and consents on resultant lots. And it's really, as Sam had said, it's important to note the start and the finish because the process is very complicated. Next. And Sam did a really good job of going through some of this and indicating the ham lands that run basically from northwest to southeast, cut through the Baker lands right now. And we're trying to amalgamate that all. So this is the before. Next. And then we have the after. And again, I could spend a lot of time on this, but I won't. So if we could just click through the next series of slides very quickly, this is the way my photos are going to go. So we're going to start down near the water and then carry on to the north side and then around just as shown there. So, okay, so the first photo is, this is what's called the beach lot and the dwelling that's on there. And you can see that's the Hams plane that is there that they use as a waterfront landing. That landing, the land is going to pivot from the current, well, I'll call it right of way. That's what it's called on a plan of subdivision. It's going to pivot from going sort of straight back behind here to around to the left, and the Hams are okay with that. Next. And this is at the shore where the plane is. And next. And this is the beach cottage itself. Anyways, next. So, and this is beside the beach cottage, and you can't see it, but there is a peg back there. You can see the rise in land. That's the septic system, and the current lot line goes right through the septic system. Next. And this is the area of land that's going to now become the Ham right-of-way, if you will. It goes back up through the woods, and there will be a new driveway constructed into that so they can get to the waterfront. Next. And this is this is now along the north side of the property, and this is a lot addition at the back of the current vacant lot again, at the north side of the property. Next. This is the same lot at the waterfront. I'm looking at the vacant lot, and that's the shoreline. Next. And this is the interior of that property, the vacant lot. Next. And that's the neighbor to the northwest. I'm standing on the subject vacant lot. Next. And this is a piece that's to be added to the rear of the next lot, which has a dwelling on it. Next. Oh, that's the dwelling there taken from the dock. Next. And that's the dock itself. Next. And this is another portion of the land that would be added onto it next. This is the Point property. This is a dwelling on the Point property taken from the waterfront side next. And this is the entrance from the rear of that particular one next. And this is looking from the boathouse to the beach dwelling, if you will, and the boathouse will be added to the beach lot next. And this is the boathouse itself next. And this is the sleeping cabin that is on the property. And you'll note in these photographs, this is the area that is shown as floodplain. It is very dry here. This was actually in April of this year. Sam went out later than I did, and the water was even higher, which I know is a little unusual. Next.
Mr. Fonner, you're approaching 5 minutes.
Okay. Let's carry on then. Next. Next. Yeah, let's go through the photos. Next. And next. The floodplain condition. Right now, the way Sam had indicated, and I'm glad he brought it up, was it says to prohibit development. And of course, that would totally devalue the beach lot from probably a $2 to $3 million property down to very, very low. So anyways, we've come up with some wording about existing buildings can be reconstructed. I was hoping that it would include any additions, small additions could be done without impact of flows and flood elevations. And I request the proposed condition be amended, and I think Sam agrees. So I think we're fairly close on wording. Next. And I think I've gone through some of the planning rationale. I think if anybody's read my report, they'll see a number of reasons why we're doing this. Next. And that's it, I think. And hopefully we don't have any objections to this one. And I think all in the family are all agreeing with this one.
Thank you very much.
I'm here to answer any questions.
Yep, thank you. Before we get to councillors, I'll ask, is there anybody who wants to speak in favor of this application? Yes? If you could state your name and address, and you've got 5 minutes.
My name is Melissa Cope. I'm a lawyer.
Is the microphone on? Yep,
okay,
thank you.
Maybe that's better. Sorry, not very tall. My name is Melissa Cope. I'm a lawyer. Stephen mentioned my name. I was watching at my office. I thought maybe I should come over if there's questions. The office is located at 61 Joseph Street, Port Carling, Ontario, POB 1J0. And we're here if there's questions, technical nature, because Steve started off saying that, and maybe why we did lot creations versus lot additions, or if there's any questions about the makeup that I might be helpful to answer. So that's why I'm here. I don't really have anything to add to Steve's presentation, just more if there's concerns or questions that I'm available.
Thank you very much. We may have some questions from council or committee. Anybody else wishing to speak in favor of this application? Mr. Baker, if you're listening and you would like to speak in favor of this application, can you please turn on your Zoom? Any messages? All right. Yeah, we'll ask. Anybody, so is there anybody else speaking in favor? And is there anybody speaking against it? Mr. Baker. Very well. All right. So there's nobody else. Mr. Zavitz, I believe you have a question. So we're time for questions for
Mr. Fonner.
Mr. Fonner, for the Fonner or anybody who's
Yes, thank you. And through you, it's funny after all the work that's been done that this is largely a housekeeping matter. But I might say, I did see in one of your original photos, Mr. Fawner, that a septic bed, and obviously relating to the floodway. Could you speak to that? I mean, is that property that was illustrated as a septic system within the floodway, and is it obviously at a low level in terms of that part of the lot?
Mr. Fawner?
Yes, through the chair. Yes, that is part of that property. That septic system is approximately 10 years old. It has been replaced. It's not the original. You can see how it's raised. And I don't know with the raising of that, how that relates to the flood level. We'd have to have a detailed topo map done by a surveyor to actually determine that. I think the fortunate thing, because it's still relatively new, it won't be replaced for some time. And it, I guess I really can't say much more than that. To my knowledge, my client has indicated that the cottage has never been a concern in terms of flooding in the 65 years that he's been involved with the property, and he's much older than that, actually. And I know the probabilities and so forth that maybe they were just lucky, but they had no problems in 2019, and they had no problems with the septic system in 2019. So it's really all the information I can volunteer for you.
Substitute?
Supplemental, if I might, to staff, wasn't indicated in the report. Do you have any concerns of that implication of the system in proximity to the floodway?
Thank you, Mr. Chair. So I did speak to our chief building official about that. I had the same question, and he advised that that a replacement system could be constructed. There's requirements in the building code to anchor tanks to make sure that there's not enough water to lift these tanks or move them. But that it is, other than that, it is something that can be replaced. Although there might be some requirements built in to make it more acceptable to be in an area that potentially could flood. Thank you.
Councillor Roberts.
Thank you, Chair, and through you to Mr. Fawner and possibly staff. I would like to bring the photograph up of the two photographs from Mr. Fawner's presentation. The one that referred to is the beach, and the one subsequently, the one that's referred to, Mr. Fawner referred to as the sleeping cabin. Could you first of all bring up the beach photo? And Mr. Fawner, maybe you can help staff get you the right one.
Yeah, I guess they'd have to put it back on the screen.
Yeah.
Yeah, that's coming.
Yeah, it's
Go.
there. Probably that one. Is that the one?
That go back to that one.
Okay, just go back there.
Would you look at that? And then if you go down, just take the mental image of that. And staff, would you go down to the one that was referred to as the sleeping cabin?
Yeah, it's quite a bit down. There we go there. Yeah.
Okay.
Yeah.
So you can take the presentation. All right, go ahead, Steve, just for a second.
I was just going to say the dwelling is to the left of this photograph.
Okay, if you could now take down the presentation. The question I have, probably the staff or whatever, on the beach property, I would assume the water, it's called the beach property because that's right at the water. And is there a road allowance in front of that? Is it owned by the township?
No, there's no original shore road allowance in front of this particular property.
Okay, and on the where I guess the sleeping cabin is right before it. Okay, so that's just I just wanted to see those and confirm that. And during questions, I'll bring up something. Thank you.
Any other questions from committee members? Mr. Sawyer, I want to make sure we're dealing with the right resolutions here. So because there's been some, I think there's some suggested rewording or an additional to one.
That's correct. I do have that additional word, that alternate wording that could be shared just on the screen.
All right.
Or if I think that might be.
Why don't you do that?
Step.
Maybe you could take us through that. Can you zoom in on that a little bit more?
No. That's the wrong one. Yeah. Give me 1 second.
Sawyer, could you read it to us? Oh, we've got it. All right.
Yeah, we've got it.
Can we?
That's still the.
Can we zoom in a little bit?
Maybe can you just close it?
This has to do with allowing them to rebuild the word. He wants to tweak this word.
Yeah.
There we go.
All right.
Would it be possible to make that a bit bigger?
Just increase the size of the font.
That's good, better.
So the first part is as it's worded currently, and then the second part is the wording that Mr. Fauner reviewed just before the matter today. And he's advised that I believe that he's in agreement with how it's worded. He had mentioned that his client would prefer to have minor additions still to be permitted. However, the way that the flooding policies are worded, there is some leniency with regards to minor additions. However, they need to be not impacting the flood flows or anything like that in the floodway. And it's difficult to word something that covers off all situations. So I think there's if the future owner of this, or if the owner of this property were to have a certain proposal sometime in the future, they could apply at that time for it to be considered by staff and by council for consideration if it is appropriate. Thank you.
All right, so we have two resolutions to meet. What the first one is a long one, and I will read that one.
That's those changes if committee is agreeable. I would have to make that change.
Oh, you would have to change this as well. I see. All right, so is committee. So we can't leave that in and then have that.
Well, Mr. Funder's opposed to that wording.
So do we just take that out? Can we take that out?
I can replace it with that. I just need time to
Okay.
write it out if committee agrees.
So committee generally agree, and I think this is what staff is recommending, and it's addressing a request by the applicant.
Can you email that to me, Sam? Yeah. I say this. Soon.
I'm just gonna get him some balls to juggle while we do it. Get the sideshow going.
Absolutely, Councillor Nishikawa.
I was not concerned. I guess a question came to my mind, and we had this discussion yesterday. There was a request from the Public Works about having entrance permits to these lots. But I believe that they're water access lots as well. And again, as I raised yesterday, I'm just not sure why the request for entrance permits is being put in this case, because they do have the ability to be water access only.
Mr. Sharp?
But, and then I know there's something else that goes along with that, where you're going to park, but.
Through you, Chair Bosenworth. You know, I think you could say that for any waterfront property that's a mainland property, they can be accessed both by water. I suppose if you had a plane, you could fly your plane there and moor it to a dock, or you could access it via the public road network. And in this case, new entrances will be required off of Industry Road for vehicular access off the road itself, and Public Works and planning staff feel it's appropriate to include a condition just to make sure that entrance permits are available. And I'm not hearing any concerns that they won't be, but it's included as a condition. So that's why.
Thank you.
Thank you.
And read the other resolution. Nothing wrong.
This one?
You want to amend the price? It's not the main one. This is just the zoning amendment. I think it can. You want to change it?
This is correct, or you want to change it? All right. Cue music.
Yeah.
Can I just cut and paste what you have there, and put it in that resolution, you send it to him? And then David doesn't write it.
Just mostly done.
Existing.
This one. Press out this?
Yep.
And then this one is being revised, right? Yeah. All right. Let me read this. Which one's this? This is
That's
the,
for the applicable, the consent.
this is a consent application. All right. It's long. Moved by Mayor Kelly, seconded by Councillor Nishikawa. Be it resolved that Planning Committee recommend to Township Council that consent applications B162223 ML be approved, subject to the following conditions: that a registrable description bracket deed of the severed lots and the required rights of way and easements to be submitted to the township along with a registered copy of the reference plan. The legal undertaking be submitted in order to submit that severed lots A and B and applications B16, 17, 23 ML be merged in title to the lots that they are being added to upon registration of the transfer / deeds. That application B/16, 18/23/ML be finalized prior to application B/19-22/23 ML. That subsections 3 of section 50 of the Planning Act applies to any subsequent conveyance of severed lots A and B in applications B/16/17/23 ML. The confirmations we received that the resultant lots are satisfactory for on-site sewage disposal, and that any problems identified with existing sewage systems be corrected to the satisfaction of the township. The confirmation we received that any necessary entrance permits are available from the township's Public Works Department for entrances onto Innisfree Road, and that a zoning bylaw amendment be approved to allow severed lot C to be formalized, permit exemptions from a minimum lot requirements for severed lots D and E, repeal bylaws 2021-130 and 2017-043, permit overwidth docks and a reduced side yard setback for a single-story boathouse with a rooftop sun deck on severed lots G, and to restrict the construction of new land-based buildings and structures and the enlargement of existing land-based buildings and structures below a static flood elevation of 226.7 meters of sea level, bracket MALS, any bylaw or any building or structure to be restored, replaced, or reconstructed shall be in the same location and have the same and have equivalent or reduced dimensions. All right. Any discussions on that? All those in favor? Any opposed? Carried. Next one is moved by Councillor Mazin, seconded by Councillor Roberts. Be it resolved that Planning Committee recommend to Township Council the zoning bylaw amendment ZBA 10/23 bylaw 2023-040 be approved subject to the following minor amendment: to restrict the construction of new land-based dwellings and structures and the enlargement of existing land-based structures, buildings and structures below a static flood line elevation of 226.7 meters above sea level, bracket MASL, bracket. Any buildings or structures to be restored, replaced, or reconstructed shall be in the same location and have the equivalent or reduced dimensions. Any discussions? All those in favor? Any opposed? Carried. All right, we'll get on to the next application. The next application is a zoning bylaw amendment application ZBA 57/22 and bylaw 2022-192 Averbuch, and that is Ms. Walker.
ZBA 57/22 bylaw 2022-192 in the name of Averbuch. The subject property is known relatively as 1683 Brackenridge Road.
Here, the mic's not on.
Sounds like it's on.
Oh, is that better? Okay, I'll start again. The next application to be heard is zoning bylaw amendment ZBA 57/22 bylaw 2022-192 in the name of Averbuch. The subject property is known municipally as 1683 Brackenridge Road. I would direct committee's attention to the submitted site plan and drawings beginning on page 333 of the agenda package. The purpose and effect of the application is summarized as follows. Bylaw 2022-192 will have the effect of recognizing various as-built buildings and structures on the subject property. It will provide an exemption from bylaw 2010-107, which requires a minimum westerly side yard setback requirement of 115 feet. The as-built dwelling, sleeping cabin, and sun deck are 76 feet, 40 feet, and 62 feet from the westerly side lot line respectively. It will also provide an exemption from the minimum front yard setback requirement of 66 feet. The as-built dwelling and unroofed trellis / pergola are 64 feet and 52 feet from the high water mark respectively. An exemption is also required from the minimum front yard setback of 50 feet for the sun deck. The as-built sun deck is set back 36 feet from the high water mark. It will permit the maximum permitted lot coverage, which is required to be 10% within 200 feet of the high water mark, and the as-built lot coverage is 10.2%. So in summary, it will have the effect of permitting and recognizing an as-built dwelling, an as-built sleeping cabin, an as-built sun deck, and an as-built unroofed trellis / pergola. Notice of this public meeting under the Planning Act was circulated 20 days in advance, and 3 submissions have been received to date. These comments are summarized as follows. Comments have been received from Nick Snyder, the Township's Chief Building Official, Tim Sopko, the Township's Public Works Technician, and a letter of objection has also been submitted by Brian and Elaine Hansen, neighboring property owners to the east. These submissions were each circulated to committee prior to today's meeting, and I'm happy to read any submission in full at the request of committee. After the comments were circulated, comments were received from Curtis Everett, planner at the District of Muskoka, stating that the district has no objection to the application. I've prepared a detailed planning report for committee's consideration. Staff have recommended that zoning bylaw amendment application ZBA-57/22 bylaw 2022-192 be approved, subject to third reading being withheld until the recommendations of the Phase 2 Water Quality Impact Assessment dated September 12th, 2022, and the peer review response dated April 6th, 2023 by McNelsky Nielsen and Associates Limited, including all required restoration and renaturalization works, are completed to the satisfaction of the township. Staff would also note that if site plan control were to be reinstated by the province prior to third reading, staff's recommendation to withhold third reading could be replaced by a requirement for the restoration and renaturalization works to be completed through a site plan agreement with securities to the satisfaction of the township. I have no further comments, but I'm happy to assist committee with any questions. Thank you.
Thank you very much. Sorry, Mr. Hungerford, I believe you are the applicant's agent. Please go ahead. You have 5 minutes.
Yes. Good morning, Mr. Chairman, committee members and staff. My name is Peter Hungerford. I'm a senior planner with Murray Poirier Planning and Associates, and our address is 44 King William Street, Unit A, Huntsville, P1H 1G3. We are appearing this morning on behalf of our clients, Arnold Averbuch and his wife Shelley, who own the property at 1683 Breckenridge Road. As Caitlin has stated, the purpose and effect of this application for rezoning is basically to recognize existing non-complying setbacks for the existing structures on the property. And these details have been outlined in Caitlin's report that was prepared and endorsed by herself and the other township planners. The application and supporting materials that have been provided to the committee set out at length the planning merits of these applications, and again, recommending the applications for approval. Of note, the property was acquired by our clients after the lot was developed. And having inherited these issues, this application seeks to bring the property into conformity with the zoning bylaw by adjusting the required setbacks and recognizing the somewhat slight existing overage and coverage. In support of the application, our clients undertook to have an environmental report prepared, which was subsequently reviewed and endorsed by a peer review completed by a second environmental consultant acting on behalf of the township. Both of those reports recommended that remediating works be undertaken to address shortcomings in the area of the shoreline buffer. And subject to the completion of those environmental evaluations, our client took steps to have a landscaping plan prepared to illustrate how the shoreline buffer area could be revegetated and restored. Those plans are included in the materials provided to the committee, which I believe Caitlin made reference to in her brief presentation. The recommendation is conditional upon the restoration and renaturalization of the property to the satisfaction of the township. And we believe that the landscaping plans that have been prepared illustrate how this can be achieved. We're aware that a lengthy letter of objection was received from a neighbor, and in large measure, those comments refer to matters that occurred in the past. However, this application is focused on correcting the non-complying aspects of the property, for which considerable planning justification has been offered to the committee for its consideration. So I would conclude by saying that on the basis of the merits of the application set forth in our planning justification report and the township staff reports and all supplementary materials, that this application be approved. And I would thank the committee for its consideration. Thank you, Mr. Chairman.
Thank you very much. Is there any parties wishing to speak in support of this application? Please. Name, address, and you have 5 minutes.
We acquired our college 6 years ago. At that time, we had no.
Sorry, Chair, we can't hear.
Yeah. No, it needs, yeah. Let's, can we leave that mic on? I think might be a good idea. Okay.
I'll start from
I have to start again.
Yeah.
As will your 5 minutes.
Arnold Averbuch, 37 Vaughan Boulevard in Thornhill, Ontario. We purchased our cottage about 6 years ago. Prior to the purchase, we had no prior knowledge about any zoning bylaw violations or issues. We found out about these issues about 2 years ago. We immediately engaged with the township. We started working on it. It's taking time, but I wanted to make a statement and say that we are fully committed to continue to do what needs to be done and to comply and fully cooperate with the township and get all the issues resolved. And we hope to put this issue to bed. Thank you for your time.
Thank you very much. Are there any other parties wishing to speak in favor of this application? Do we have any parties wishing to speak against this application? I think we do.
Granddaughter about to be born, so that's why Lane's on.
Ms. Hanson, if you could unmute yourself and turn your Zoom on. There we are. All right, we can see you, but we can't hear you.
Okay, can you hear me now?
Yeah, if you could state your name, address, and you have 5 minutes, and I ask if you could just keep to the topic at hand.
Thank you. Elaine Hanson, 333 Balsam Drive, Oakville, Ontario. Good morning, Mr. Chair, councillors, and Muskoka Lakes region. I'm here today to ask that you deny the recommendations issued by staff concerning the Averbuch application at 1683 Brackenridge Road, Unit 4, Port Carling. You've heard you will be hearing a fairly lengthy technical view and explanation from my husband, along with all the materials and pictures you've received. All at this point, in my view, say that the town has handled both the Jennings, which were the previous owners, and the Averbuch files in a way that betrays the sense of trust of its citizens. Neither Brian or I have anything to gain through this process, except that we've lived through a 10-year process of inaction, which has led us to where we are today, and strongly believe that the town should now turn this around and move forward with the most significant and science-based restoration project the region has ever undertaken. I say science-based because your proposed landscape layout show a few trees on a property with no overall integrated goals and few connections to ecosystem services that are required for overall land and health. Reminder that a clear cutting causes immense erosion and contamination of water supplies with sediment, compacting the ground and decreasing our soil's ability to retain water. Your impact report is very light, is based on beliefs, not scientific rigor. And I feel very strongly that it was used to protect the town's non-activity for a decade. Once you say everything is fine, then you can pass through a decade.
Ms. Hanson, Ms. Hanson, if I can interrupt, we don't want to have a discussion about township actions in the past. We are here to talk about the application. And I would prefer if you just did not talk about that, please. This is not the forum.
It's very interesting. Am I speaking to the chair right now?
You are.
Okay, so I will make a comment to that, which will not be part of this 5-minute delegation, but
I'm sorry, you have 5 minutes and you only got 2 minutes left, and
you interrupted me.
Well aware of that.
So I'm going to continue to say that that is how cultural change does not happen when you disallow the history of inactivity on this lot by the town to occur. So I understand it is about this application, but it's actually, we must consider the history and the non-activity in order to render a judgment. So I sit on governance committees. I have had a long career in technology. I've spent 8 years advocating for the Ontario pesticide bylaw, the Oakville bylaw, and I have moved a large energy and climate projects through public institutions. I can tell you, and I can say without a word of a doubt here, that I understand process. I do know how it works. I understand the issues of transparency and the crucial tools that are required to alter behavior. And I see the ones that we still require. It's for this reason that I can tell you that we mishandle these two sets of owners. And what's happening today is, in fact, a moment of innovation that drives cultural change. If you allow these exemptions to pass, you are allowing a decision without information that you still—
Ms. Hanson, you have 30 seconds left.
I would like to also point out the chair never interrupted anybody else on any of the other delegations or on this as well. So recall that Port Carling had a tree bylaw in place in 2008. We pushed through this, and if
Ms.
we
Hanson,
push through,
your 5 minutes is up. Thank you very much. Mr. Hanson, I think you would like to speak on this as well. How's it get turned off? There we are. All set.
Okay, I find it odd that Steve Fauner has 8 minutes and we're allowed 5 minutes. So the Averbuchs are asking for forgiveness rather than permission. Accepting this is not a responsible way to govern a township or protect the environment. The Averbuchs and Jennings' behavior is the poster example for what we need to stop in Muskoka. They have shown a complete disregard for township development process and the environment. Our concerns: very significant non-compliance. These are not minor variations. Dangerous precedent for the future abuse by other residents. Township policy says council shall consider, and I quote, impact of decisions on future developments, i.e. precedent. We've already seen this with the Averbuchs, who we informed about the non-compliant building before they purchased the property. I'm happy to provide the emails that negate the statement he just made, which says they were not aware. I sent emails to him informing that. They then knowingly purchased a non-compliant property, built a non-compliant hot tub sun deck without a building permit, and continued to clear trees without permits. There's already excessive disturbance to the property, which is a quote from the planning staff report. The Riverstone report discusses the presence of type 1 fish habitat. The Nielsen report does not. Why is that? I think we know why. The reports are heavy on form, light on substance, pale in comparison to the Riverstone report in terms of thoroughness of analysis, fact, and science-based reasoning. Nielsen.
If you could keep the accusatory aspects out of your, we are dealing with an application. We're not dealing with either township.
I'm trying to set the facts and the record straight.
And yeah, we need some respect here. We are dealing with an application.
We do need to have the facts known.
Facts do not include accusations against people. Those are not facts. Those are accusations, and I don't.
Nielsen's rationale is partially based on, to quote them, if a building permit was issued, then it should be allowed to exist. That is not a responsible and moral way to govern development. If a building permit is not compliant with the site plan, then the township and the resident need to take moral and economic responsibility to rectify to achieve compliance. Why wasn't Riverstone used by the Averbuchs? I think we know the answer to that. They didn't like what they heard.
I asked you to not make those kinds of accusatory tones, please. You can just continue on, or else I'll ask you to stop.
Why was the Riverstone report in the site plan agreement not sent to the planning committee? Nielsen states natural form should dominate the character of the waterfront. Here, built form dominates it and is visually unattractive. There's gazebos, trellis, sun deck, hot tub, excessive stonework, retaining walls, 2 massive granite walkways to the lake. Overbuilt substantially. Character. Hello? Hello? Okay.
Yep. Please continue on. You've got about a minute and a half.
The property is not in character with Portage Bay. It stands out. It's known as the rock property in our lake community. Anyone taking a boat ride from the lake can see this. Planting trees and shrubs only solves part of the problem. The small size of planted trees will take decades to screen. Small plantings incentivize owners to cut down big trees and then plant smaller ones, which will not affect their view for decades. So what we believe is a fair, responsible plan. Retain Riverstone to conduct a thorough update of the report, reduce the size of the dwelling, move the structure. The Nielsen report states that relocation will have more negative environmental consequences. A landscaper can modify this property without any material destabilization, according to our advisors. Even if there were, this is a short-term view. A long-term view is what's important here to eliminate the environmental damage. Increase tree size to 10 feet so they can start to have a visual impact immediately. Reforestation for behind the cottage, which was not addressed by planning. 1 path to the lake, not 2, and replace granite with permeable materials as per the Nielsen report. We do not understand the compressed timeline here. We just received a letter late last week. This is not sufficient time for us to consult with our advisors, read all the town documents just posted on the website, and prepare our position. We are requesting a denial or deferral until we have time to properly prepare. This is when morality and ethics come to the forefront. The council has an opportunity to change the culture of residents and stop the abuse of the development process and environment and set an example so others don't follow. This is not in the best interest of current and future residents to rush this decision. We have a legacy to pass on to future generations. This legacy is at risk when we deny ourselves the truth
Mr.
and
Hanson,
allow development to occur properly and
5
in a
minutes
manner
is
that
up,
is not
please.
transparent.
Thank you very much. Is there anybody else wishing to speak against this application? Very well. Let me read the bylaw. Moved by Councillor Zavitz. Oh, I'm sorry. Before that, are there any questions? Any questions from Committee? Councillor Mazan, thank you.
Thank you, and through you gave me a start there. I thought I'd missed it. I have two questions for staff, and the first is centered around, clearly there's a long history here. I'm not looking to rehash the history at this point, but just trying to understand, I believe that there was a request for the applicant to have engaged with Riverstone, and if they, the environmental company, if staff could just give us an overview about the process and an understanding as to how to link that report from 2010 potentially into this current application. I think it would be helpful for all of us to understand that.
Ms. Walker or Mr. Sharp, whoever wants to reply to that.
Through you, Chair, and thank you, Councillor Mazan, for your question. This property has a long history of planning approvals. In 2010, there was a consent application in the name of Jennings that was approved. And that application was a lot addition. And the severed lot in that application was added to a benefiting lot. And that benefiting lot, together with the severed lot, is the property that forms the subject property, the Averbuch property that we're dealing with today. As part of that process, Portage Bay of Lake Rosso at that time was considered a highly sensitive and over threshold water body from a water quality standpoint. And that's under the district's former lake system health program, which has, I would note, which has since been updated. Portage Bay of Lake Rosso is no longer considered over threshold or highly sensitive to phosphorus inputs under the current lake system health program. But that's an aside. I just wanted to make that clarification. But because of its former status, there was a requirement for a water quality impact assessment to be undertaken as part of the consent application. And that water quality impact assessment was undertaken by Riverstone Environmental, who is a local environmental consultant. And as part of that process, that study was implemented through consent agreement and through site plan applications involving the redevelopment or the development, I should say, of the subject property with a dwelling and a sleeping cabin. And those applications were all undertaken, it's my understanding, by former landowners. And Councillor Mazan, maybe if you could just remind me what the second aspect of your question was. I think it had something to do with the peer review process.
Correct. I think there was a comment, and I'm trying to remember exactly where I saw this from the planning justification report, just that township staff had requested to have Riverstone be the organization to have a look, and it would have seemed like a natural ask. So I just wanted to understand that, please.
Right. Thank you for the reminder. So yes, when we dug into this application, we realized that we needed to request an environmental report in part to address some of the background and history related to the water quality impact assessment that had been done. And I believe Ms. Walker had requested that Riverstone undertake that review. However, I would note that the township really doesn't have any authority to be the gatekeeper, so to speak, with respect to who a landowner decides to retain as their qualified environmental consultant. In this case, Mr. Hungerford and his team at Marie Poirier and Associates chose to retain Mikulski Nielsen and Associates, also a local environmental consultant. Mikulski Nielsen undertook, as we know, a review of Riverstone's report and made recommendations. Upon receipt of that report, staff decided that it would be appropriate in this case to have a peer review undertaken of Mikulski Nielsen's work. And, I think in my opinion, looking at the situation and who had been involved in the past, we felt it prudent not to retain Riverstone. The township retains environmental consultants to undertake peer reviews. It's a it's a process where there's no involvement on behalf of the applicant. The municipality administers the peer review process. And I think my concern was largely, it could put Riverstone in a position potentially of bias, or at least perceived bias. So I think we opted to go with Hutchinson Environmental. And I would note that, we don't have a clear policy on how we handle these matters, but we really do try and aim to cycle through environmental consultants. So we're not favoring one over the other. So in this case, it was Hutchinson Environmental who undertook the peer review work. And just as another aside, I would note that Hutchinson Environmental was the district's sole source contractor with respect to the development of its lake system health program, and is very qualified, in my opinion, with respect to environmental considerations. Thank you.
Thank you very much, Mr. Sharp. I believe Councillor Zavitz has a question. Oh, sorry, subsequent from Councillor Mazin.
Sorry, just one other question. Thank you. I note that the sun deck was constructed, and I'm just trying to get a sense as to when that was constructed, please.
Ms. Walker.
Through you, there's no building permit for that sun deck, so I would look to the owners to maybe provide some context on when that was installed on their property. My understanding was it's the, I would look to the owners to kind of add some clarity to that.
Thank you. If the owner could respond, please.
Mr. Averbuch.
So we believe it was around 2018. So we have this retaining wall encompassing our patio facing the lake. And we incorporated the hot tub inside inside behind the retaining wall in order to allow easy access to the hot tub. We have a little deck around the hot tub. The hot tub itself is not visible from the lake. It's behind the retaining wall.
Just for my clarity, I think I heard you say 2019. Is that correct?
We think so. I can go back to my records and give you the exact year, but I believe it was 2019.
Okay, thank you.
Thank you.
Councillor Zavitz.
Thank you. It's for you. Just a thought, maybe a 10,000-foot view looking down on this. Am I to understand, and now of course I can't find it in the copy here, that the boathouse is it possible the boathouse was the most recent structure built, and it was built with the benefit of a permit from the township? Is that?
Ms. Walker?
Through you, Chair. I'm just going to confirm here. I believe that is correct. There is a building permit for the dock and the boathouse from 2020. So that would be the most recent.
Thank you for that. Yeah, as I rather assumed. I guess the interesting thing about this particular file, and I do absolutely hate, viewing neighbors against neighbors. I mean, that's one of the things we just inevitably deal with, I suppose, as a piece of this puzzle. But it seems a shame to me that that there's a neighbor who's complaining about all this, when in fact the last activity on this property was the request of a permit and then the subsequent construction of a boathouse. And so this is, to all of us, it would seem to me that, on a go forward basis, somehow, had we, the township, had eyes on this and gone to this property when the building permit was granted, perhaps we would have seen and noticed that there were 5 or 6 transgressions. I mean, I think that's what's happening here is we're seeing the amplification of neighbors' concern, taxpayers' concern about this property, when in fact, I don't see any recourse but to approve it based on what the staff is saying. Nothing in amongst here is anything I can get my teeth into beyond our good staff's recommendation to approve it. So I just wonder, we as an entity could be looking at some sort of a format where when we grant a permit for a large, whatever the size of structure, to a point, we get on that property and we do notice these things. And I know we're not allowed to be on the property, et cetera, but to me, this smacks of insight. Thank you.
Director Pink, if you'd like to comment on that, although it's not directly related, let's just.
Thank you. I'd like to add, thank you through you. I think certainly one of my goals and one of the benefits I believe of the merger of the department's planning, building and bylaw is to be more proactive in that nature, and that those groups do communicate and would take note during a building inspection if they see bylaw contraventions, and they do forward that information on to bylaw enforcement staff. I don't believe any of the existing staff, including myself, were involved in these applications in 2011, 2010 to 2012. So we can't speak to the activity there, but what I can say is I believe when the building permit was issued for the boathouse circa 2020 was when roughly around the time that a complaint was received about the work that had occurred on the property, and bylaw enforcement staff have been working on that matter since that time. And what the application you have in front of you is a result of that investigation and that ongoing work with the property owners to bring the property into compliance with the site plan. We're unable to bring to update the site plan because we found these non-compliances. So there is a process. Unfortunately, it's taken some time due to the studies and peer reviews. But again, we during that construction, those transgressions were noted, and we are currently dealing with it. I hope that helps clarify some of the background.
Councillor Nishikawa.
Thank you. Along with what David had just mentioned, while I can see the pictures about the hot tub and all of the stone patios, when I look at the landscape plan, I'm a little concerned that we're not actually taking away some of those hard surfaces. I'm very concerned actually, because it's the hard surfaces that create so many other issues. So I'm not sure who to ask the question of, but was that when looking over this landscape plan, was there any further discussion about removing those hard surfaces?
Ms. Walker.
Through you, I would note that the landscaping plan that is attached is for reference purposes at this point. It still needs to be reviewed by staff and by both the environmental consultants in this matter to finalize it. But it is based off of the environmental feedback we got from both consultants that recommended we keep the existing landscaping as is and focus on the revegetation of the open areas.
Sorry. If I could further though, I would request that, sorry, should I wait till you read the, but I'm just a little concerned that, I don't want to miss an opportunity to say we want more than what has been put out in the report.
All right, let we hold that thought and we'll continue on it. Councillor Mazin, and then you have another question, and then let's, if we have no more questions and we want to debate it, I can read the resolution.
I think
is yours.
It's probably following on the comments that Councillor Nishikawa was just making, but a question for staff: is there an opportunity for us to strengthen? If we just take this from a lens of strengthening that first 50-foot buffer that we have been talking quite a bit about, can we take it beyond what has been recommended by the environmental consultants, i.e. what Councillor Nishikawa is just referring to?
Ms. Walker.
I think there would be an opportunity if you feel necessary to amend that. Maybe Mr. Sharp can speak to that further. Currently, the environmental studies recommended 38 trees and 126 shrubs be planted, and they've divided the first 50 feet into about 6 sections and specifically recommended a number of trees and shrubs be planted in those specific sections. So there may be an opportunity to increase the number of trees, but I would note that staff is basing this off of the opinion of the environmental consultants that both looked at this.
Mr. Sharp.
Thank you. And just to further elaborate on what Ms. Walker said, the recommendation that staff has put forward that's in front of you today is to withhold third reading, for council to withhold third reading until the required renaturalization and revegetation works are required. As Ms. Walker noted, a fairly substantial amount of vegetation is proposed, but certainly we could go back to the environmental consultants with committee's direction that you would like more. And we could go with that. Thank you.
All right. If we have no more questions, I'd like to read resolution so that we can have a fulsome discussion on this. Is that Fair with everybody? No more questions? Moved by Councillor Zavitz, seconded by Councillor McIntyre. Be it resolved that Planning Committee recommended Township Council that zoning bylaw amendment ZBA 57/22 bylaw 2022-192 be approved, subject to third reading, that being withheld until the recommendations of the Phase 2 Water Quality Impact Assessment dated September 12th, 2022, and the peer review response dated April 6, 2023 by Michalowski Nelson Associates Limited, including all required restorations and renaturalizations works are completed to the satisfaction of the township. All right, so let's have there was some discussion. I think we have some discussion about whether we want to give guidance to staff and perhaps discuss with the environmental consultant about their current plan. So any comments from anybody in your discussion? Mr. Roberts.
Thank you. So I do want more. My tag team and my tagline on my personal mail is protect the ribbon of life. The district promotes that. We've had them come and talk to us. This is a great example of someone, maybe all three parties, not honoring what we wanted to do on that shoreline buffer. So I know the consultants have presented something, but I think we need more. And there was no regard to the environment when it was put in, and now we're taking regard for the environment and saying let's fix it now, and Mother Nature will take care of itself. So I'm going to I don't know, I definitely can't support this the way it is now. I need to see that landscape plan. And that landscape plan, I've seen landscape plans where they say replace 8 trees and they put 8 cedars in, and the deer eat them. So I really want to get into understanding that our ribbon of life on our lakes is protected. Thank you.
Councillor Mazin, I think you had your hand up then Councillor Zavitz, then Councillor Nishikawa. Councillor Mazin.
Thank you, and through you. I think I'm picking up on where Councillor Nishikawa started and wondering if we could send, I don't know if it's a deferral at this point, to have an understanding. My biggest concern actually is around the sun deck, and that it was built in our front yard setback without permit, without permission. And I recognize that this is part of the process that is now unfolding. But my question around, can we go beyond what the environmental groups are suggesting and strengthen it? And I think what we owe it to ourselves in this particular situation to actually have the experts come back to us with a plan that has a reduction or an improvement on that sun deck that was built kind of without permit and illegally. And so I would like to ask a committee to contemplate that. Thank you.
Councillor Zavitz.
Thank you. Through you, I guess to staff, if I might, through you, the regeneration plan, revitalization plan that I see on pages 1 and 2 seems very extensive to me. I mean, I understand, asking for more, wanting this to somehow, be better, to Councillor Roberts' point of the ribbon of life. I might ask staff and whoever that is, this appears to be a relatively extensive plan. Is it, in your opinion, given what you see daily?
Who would like to reply to that? Mr. Sharp, perhaps?
Through you, Chair, and thank you for your question, Councillor Zavitz. I think it's a good plan, but I think, there's always perhaps some room for improvement. If I'm hearing from Ms. Walker, we need to get the input from the environmental consultants on this plan itself and get their confirmation that it meets all of their objectives. And I would just remind committee that, again, the recommendation that's in front of you is to withhold third reading, and that third reading would be withheld until these plantings are completed. If committee wants to see the landscape plan after it's been certified by the consultants, it's likely that a deferral at this point is best, and we can bring that plan back. Certainly, if to Councillor Mazan's point, if committee is looking at having the sun deck removed, that could be a requirement prior to third reading as well, and the related exemptions removed from the bylaw. Thank you.
Director Pink, I think you had some comments.
Thank you. Through you. I think to summarize, I wouldn't have reviewed the plan as closely as Mr. Sharp and his team, but I think it's a fairly robust plan. I think the impression I get from Councillor Nishikawa's questions and Councillor Mazan's is perhaps a desire to reduce some of the flagstone patio area. I don't know if it's necessarily looking to squeeze more trees in. It looks, again, they need space to grow, and I think it's a fairly decent looking plan. However, again, whether it's a deferral or a recommendation, council had looked at the applicants if it's possible to do that in that short time, whether they'd be if we could get a revised plan that looks to reduce either some of the sun deck / flagstone patio area to be closer to that 50-foot setback and renaturalize that as well. I think the concern I think we have is the consultant's recommendations of, the work has been done and it's best to leave it at this stage. That might be the case in the immediate short term, but in the long term, I think some vegetation in that area, as opposed to a flagstone patio, is likely the beneficial on a long-term basis. But again, I'd like to get the input from the consultants on that, and likely best for a deferral. I don't know if that's possible by the time this goes to council. If again, committee is looking for firm answers before making a decision on that aspect.
Councillor Burry.
Thank you, Chair, and I would support a deferral. I think everybody knows that I'm pretty adamant against building without building permits. The building permit process allows our staff to be able to take a look at what's being proposed before it gets done. And in this case, there's way too much hardscaping on this particular property. And our staff didn't have the benefit of looking at it before it was done, so it's done. Building without a building permit is a risk. And anybody that does it should understand that there's a risk that the municipality will ask you to take it out because it's not legal. This is not a legal structure right now. That's what we're trying to do. But I'd like to see a deferral because I do think there's too much hardscaping here. I'd love to see what the environmental folks, the consultants say, and to have a properly tested landscape plan to make it look more in keeping with what we're trying to do to protect our environment.
Councillor Zavitz.
Thank you. And through you, I'm wondering, I guess, to David Pink, how is what you've just said, David, different than what Councillor Burry has said? I mean, in terms of a deferral or accepting the staff recommendation, is it not really the same thing? I mean, what we're saying, what Councillor Burry is saying is we want eyes on. We don't want this to end today. It can't end today. It needs more. If we were to approve it today by withholding third reading, do we not get to the same end result?
Director Pink.
Thank you. Through you. I mean, you do largely. There's a lot of options there. Keep in mind, this is a committee. You're making a recommendation to council. So no final decision will be made until 30 days. And the staff recommendation is to not make that final decision, as Mr. Sharp pointed out, at council in 30 days. So it's really just a question of timing, really more for the applicants. But I think there's clear direction for staff to re-engage the consultants and see if there's a possibility to reduce some of the hardscape. It's just a question as to process, whether you'd like a full stop at this point to review that at a committee level, or whether you wish to more leave that to staff and we can provide you updates at a future council meeting.
Mayor Kelly.
Thank you. And through you.
And then Councillor Roberts.
Thank you. Through you. I would prefer to deal with it today, withhold third, and just bring it back to council once we have a more comprehensive understanding of hardscape mitigation and what the final landscape plan is going to look like.
Mr. Sharp, and then Councillor Roberts.
Thank you, and apologies to interject. I think what I'm hearing in line with Mayor Kelly's suggestion, I think likely what would occur if you wanted to proceed today is that we'd likely come back for first and second, and we would provide you with some updates with respect to the plan. And then we could, make a decision at that point on how best to proceed at the council level.
Including specifically dealing with the, what is a general seems to be concern about excessive hardscaping and removal of the hot tub.
Correct.
Director, Councillor Roberts, sorry.
Thank you. Just a comment. I like to do the heavy lifting at committee rather than down to council. Because if we're not, if the majority of us are not in favor of this thing gets defeated. So I would rather have it come back to committee that we can is there a significant rush why we have to get this done in a very short period of time? I guess that's the question. Is there something that really is needed to force this to go to the council next month? And what would it be?
Mayor Kelly, comments?
Thank you. And to specifically to Councillor Roberts' question, I think we've done a lot of heavy lifting here. The heavy lifting really is the responsibility of staff. I think we've given clear direction to staff as to what we would like to see come back. And I think in the normal course, we should let things move along as expeditiously as it can, bearing in mind that there's risk of moving too quickly, but we have to have faith that staff have understood the direction. We've thought it through, talked it through, and I'm ready to deal with it at council when it gets finalized.
Councillor Nishikawa, and I have a comment.
Sorry, thank you. I'd heard you mention the removal of the hot tub.
Yeah, I was just going to ask clarification of.
Yeah, I wanted, because that was my whole, for me, and the amount of hardscape and things. And I can't imagine what it would have been like when we had that pouring rain on Monday or Tuesday, whatever it was. But, and literally everything, it appears from the pictures I've seen, will go directly to the lake. And in fact, when anyone is sitting in the hot tub and splashing about and things, that will go directly to the lake because it's going to follow these paths. And so, but I wasn't clear about having the hot tub removed.
Well, that was the point. I was going to ask for clarification. Does this committee want to direct staff to include having the hot tub removed? Yes.
So I'm sorry, but I'm trying to understand the timing of things and when we, for instance, were having this discussion about, for me, it's been many years we've discussed hot tubs too close to the water, but I'm trying to think through what it was prior to our changing the OP. And do you know where I'm going, David? Like I'm a little bit, I'm trying to understand how much further I can push that hot tub back or what we're asking them to do is what I want to clarify.
And I agree. We need to get clarification on that. David, can you comment on that? And then I want to get a sense from committee about the hot tub, please.
I guess it would look somewhat to Ms. Walker and Mr. Sharp, but my understanding, and I stand to be corrected, is the majority of the buildings before you in the application were constructed many years ago. What's more recently constructed, and I think could be more dealt with in an enforcement matter, is the hot tub sun deck and the pergola. I don't believe those obtain building permits. Again.
All right, so we want to ask them to remove the hot tub. That's really a question. And again, I get a sense, Councillor Zavitz?
If I might thank you, through you, a sub question to what David has just said. Staff did not recommend in any way, shape or form taking those things out.
No, they didn't. But there's been some suggestion here. I was just trying to get a sense.
No, fair enough.
Yeah.
Thank you for that. But I guess my question is why? Why did staff not recommend? I mean, again, that is in our toolbox. I suppose we could say we would like to, get rid of these things. But to my point, here we are now saying, let's get rid of a hot tub that's been there 6 years. I kind of don't understand that.
Director Pink.
I think Thank you. Through you, in a nutshell, you have two qualified professionals, with all due respect to council and neighbors, are not qualified to take the stand under oath and speak at a tribunal, that what's been built has no implications to water quality or the environment, and suggested leaving it. Hence, staff struggles as planners to recommend something in contravention that someone qualified that we look to for advice is advising us. Now, nonetheless, council, you have the prerogative to request more and look for a reduction in the size of the flagstone patio, and that's within your prerogative.
I'm going to allow 3 more comments here.
Thank you, Director Pink, and I think that's very clear. So my question to you is, where in the process do we catch people that build things without building permits? It doesn't matter when it was. There's no statute of limitations to building without a building permit, I don't think.
Well, through you, and that's, I guess, to my earlier comments, the majority of the buildings before you, the side yard setbacks of the dwelling, the bunkie, those all received building permits. Those were unfortunately missed by prior staff, possibly. What you have, like I said before you, that we could potentially deal with is the hot tub deck and the pergola. Those were obtained, from my understanding, without building permits, and those could potentially be dealt with. I think on the grand scheme of things, the pergola does not appear to me to be creating a great, visual blight on the landscape. It's on a patio that's beyond 50 feet from the lake. I think, in fairness, I can appreciate council's concern with the flagstone patio within 50 feet, and that seems to be the brunt of the discussion.
Councillor Mazin. Then Councillor Roberts.
Thank you, and through you. And I just want to clarify my comments. I was trying to remove from a specific to put the onus back on the experts, the planners, the applicant, to say, listen, there's, rules were broken. That aside, I'm focused on that first 50 feet to say, how do we go beyond what has been recommended by our environmental consultants to reduce the built form, the patio sections. But I was not being specific about a hot tub. I mean, there's different ways you can incorporate a hot tub. So in my comments, I was asking for this to go back to the drawing board from, I guess it's the landscaping and understanding. Here's what we want in our first 50 feet, and let's get to a better space. That includes the deck, but quite honestly, like, we haven't even touched on it. There's also some further stuff right at the waterfront with the gazebo. So there's a holistic look that I'm looking at this. And I think it's important that you put that back into the hands of the applicant and the staff to work at and say, how do we improve this even further? That's kind of my overarching statement, not specific to a hot tub. And I don't know if that is helpful for staff and the applicant, if they understand my thinking.
Councillor Mazin, would you prefer to do that through approving it now and having it come back for reading at council? And then then there's a further delay. You don't have third reading until it's finally, we've had full implementation. Is that a process? Is that appealing to you?
Well, so now you've asked me about the process to get to that goal. And I guess I'm just getting clarification from staff. Do they feel they have enough information, if that was my guiding principle to them, to come back with a further and more strength and beyond just the tree plantings? If they understand it's the hardscaping and it's that first 50 feet, does that give them enough to go on to have meaningful conversations? And if that's the case, then I'm fine with the process of coming forward to council. If it needs to have further heavy lifting at planning, then I would suggest that way.
Councillor Roberts.
Thank you. And as far as the question about removing the hot tub, there's got to be a way that the applicant can retain the hot tub, and mitigate any environmental issues with the hot tub, as far as the cleaning and the emptying, and buffer it somehow so that it could mitigate any of the water and getting into the surrounding 50 feet. So that's just a comment. So that's for staff to consider.
I'm going to suggest that we add to the bylaw, some directions to the staff about our desire to see more work being done specifically around the hardscape, I don't get a sense that there's enough people around the room wanting the hot tub removed, so I suggest we leave that out. And that we enhance this bylaw and pass it now. We've got 2 more chances before we actually approve the bylaw. The first chance being at council and the second chance being at 3rd reading 2 council meetings from now. So
Just want to ask David. Wording.
if we could just get some wording for that. So Councillor Edwards.
Yes, thank you very much. I'd like to see the hardscaping reduced basically from the house to where the pergola is there. And the lower level, the big oval down there. And I think we should have the district come out and do a presentation to us, which they will do on native plants and everything else like that. So everyone on the committee and the council can learn why they're doing this. I think that's important. And I'd like to see that all the plantings are native plantings because the rooting is deeper and that, and I can go for 1st and 2nd reading at this time, as long as they, and that I would like to, as much of that hardscape removed as possible. Thank you.
Thank you very much. Councillor McIntyre.
I just want to step in here and say my biggest concern is that we have an environmental assessment and then a peer review of an environmental assessment. Those people are all experts. They know what they're doing. We've got all kinds of experts giving their opinion on this. And somehow we feel that we have the qualifications to step in and interfere with that. And I have a concern with that.
Mayor Kelly.
I absolutely echo that. And to add to the list of experts, we have our own staff reviewing the environmental assessment, the peer review to the environmental assessment and applying their combined knowledge. So I just think we're on the wrong side of the line again, where we're actually writing an environmental plan instead of approving.
All right, I think I need a straw poll around the table because we're just about divided on this. I think this is a straw poll. How many want this addition to the bylaw to ask staff to go back and look specifically at hardscaping? How many are in support of it? No, sorry, let me state it the right way. Do we want staff to go back and add to what the environmentalists have told us specifically do with hardscaping? How many want that? 2, you do. All right. 3, 4, 5. Okay, so I think we're on the right agenda then. And just wait for those. No, we're not doing it. We're not doing it. Yeah, no, it's just, go back.
So just hardscaping.
Well, we're going to hold it for 3rd reading anyway. We have to do it. No, essentially.
It's to denote these in amending resolutions.
Yeah. And I promise everybody after this case, we're going to have lunch. Gentlemen, we will probably come back at 1:30 if you don't want to stay around any much longer. You can go out and do your things. We'll be back at 1:30 and then we have what do we have? You know, at the latest 2 o'clock, I would say. Although I could be surprised. Leave your telephone numbers with somebody. All right. Let's see what you got.
Just give me my computer to read it off and then I'll print it for you to sign.
Let me read it and then you can have your comment. Is that all right? I'll just read it off of David's.
Yeah, he's got mine. So I'm just reading that and then I'll print it. Have you sign it after?
Just press print.
Yeah, he can read it off that.
Find this word. It's on the fly.
So you've read the main resolution, so now you need to read the.
All right,
amending
so.
one.
Is that just
No, this is an amending. Oh, yeah, sorry, this is, all right, so. Councillor Zavitz. You had a question. This is just an amending one, so just before we have the amending one.
I did, thank you, and through you, of course, I guess I'm wondering when the hardscape, all of it, which seems to be a big topic of discussion here. When was that placed where it is? Do we know that? Like, is this 5 years ago, 8 years ago, or a year and a half ago? Thank you.
Mr. Sharp or Ms. Walker?
Through you, Chair. Essentially, the lot was vacant. My understanding in reading some of the past reports is that there was an old dwelling foundation on the property. But it was redeveloped subsequent to the 2010 planning application. So I think all of this work has occurred sometime between 2010 or 11 up until the present time, but I can't say exactly when. We're looking at air photos from 2013, and it looks like that there's been some site alteration in and around the dwelling at that point.
There were some pictures in the report on 2017 and then afterwards, and it looks like there was some work done afterwards, in my recollection. All right, let me read this. Moved by Councillor Burry, seconded by Mayor Kelly. Be it resolved that Planning Committee amend the resolution to add a review and consideration by qualified professionals of reduction in the stone patio size and other hardscape works within the shoreline buffer as a component of the renaturalization plan.
So now you need points for any questions.
Okay, any questions on the amendment? Good. Right, so now we're going to call a vote on that amendment. All those in favor? Any opposed? That's carried.
It passed, so then we need to know if there's
Any more further question? Debate on the motion as amended. So that's these two together. Any more further discussion on that? And so all,
you don't have to read it, you can just call the question.
yeah, call a question on the original one. All those in favor? All those opposed? Carried. Right. That's,
So let me print that.
you have to print that. I'll sign it. We will adjourn now for lunch and we'll be back at 1:30. Okay, folks. Are we ready? Thank you. All right, I'd like to call the meeting back to order.
Chair, we can't see anything on the screen.
That's the way we like.
We're
Okay.
just disappeared. All right, I'm going to struggle to get control of this meeting here. It is 1:32 and we are starting this meeting up again. The next item, I believe, is long-range planning special projects. It is the sorry. So which one is that? Westbury International, yeah. That's part of the long-range planning and special projects. B0405, not one of these again. B04050621, change of conditions, Westbury International, amended parts 27 and 28 concession, 4 lots 1 and 2, 5, plan 35R 1458, and it's Mr. Soya.
Thank you, Chair Bosenworth. So back in July 2021, Council approved consent applications B04050621 ML in the name of Westbury International Corporation to create 3 new lots plus 1 retained lot, subject to conditions of consent. And in August of 2021, this approval was amended to add standard conditions required by the District of Muskoka to protect the district's interest related to District Road 7. And then now on May 30th of this year, the applicant's agent requested a further amendment to add a condition requiring long-term site monitoring the proposed waterfront residential lots for a period of 10 years. And the applicant's agent has also explained that the applicant has experienced unanticipated delays in preparing the required survey and reference plan. And the provisional consent approval granted by council is now due to expire in August. If the requested amendment to the conditions is approved, the 2-year Planning Act timeframe to fulfill the conditions of consent would be reset, and thereby the applicant would be provided with additional time to fulfill the conditions and have the surveys completed that are required. Planning staff have prepared a detailed planning report and have recommended that the change to the conditions be approved, as the proposed addition for the requirement of long-term monitoring would assist with ensuring the recommendations of the environmental impact study are properly implemented over the long term, especially in the absence of the now defunct site plan approval process. This monitoring would be required through the consent agreement, and the monitoring period would be for a period of 10 years. And I have no further comments at this time, but would be happy to answer any questions from committee. Thank you.
Thank you very much, Mr. Soya. I believe Mr. Fauner is the applicant's agent. Good afternoon, Mr. Fauner.
Good afternoon. Sorry to bore you again. Steve Fauner, Northern Vision Planning Limited, 109 Meadow Heights Drive, Bracebridge, Ontario, P1L 184. Westbury International is actually the owners of the Port Carling Golf and Country Club. This is for 3 lots on the south side of Marion Lake that was approved in 2021 that's coming up now and potentially lapsing. I just received actually the registered survey the 3rd week of May. So just quite frankly, about 3 weeks ago. So it shows you how long that has taken. And there still are, we had to wait for the registered survey to be able to have a registered number of that survey so that the consent agreement could be completed by the township and the agreement for the district for well locations. And that's going to take a little bit of time yet. And because we're dealing with the deadline of August, then, we've got to do it now because of the timing of the meeting. So to do that, to effect that and have the 2-year time frame start again, you have to have a change of conditions. I felt maybe long-term site monitoring was a good thing to put in, actually, and especially in the absence of site plan control. So anyways, I'm just really here to answer any questions, and I'm sorry I don't have a PowerPoint presentation, but anyways, I'll save everybody the grief. And anyways, hopefully you'll see where through. It's been a long process. It was a long process to get approval, and we certainly would like to see it continue on. We have completed the archaeological study, which was required, and that's been registered with the province. We have done the environmental study, the zoning bylaws in place. So again, it just took a long time for the survey, and that was really COVID related things. There were some surveying issues on the property, and that's why it took so long. So be greatly appreciated if you would pass the resolution to make an amendment to the conditions. Thank you.
Thank you very much, Mr. Fawner. Are there any questions from committee? Councillor Zavitz.
Thank you through you to I guess staff. Just a clarification on that third sentence there, agrees to a restriction on motorized watercraft on Marion Lake. Is that to a specific horsepower or no motorized watercraft whatsoever? Question. Thank you.
Through you,
Mr. Sawyer.
Chair. I believe it's a restriction on no motorized watercraft whatsoever. I'm not, I might turn to Mr. Fawner just to confirm that if it wasn't just a limit on the motor size, but I believe it's just no motorized vehicles. Thank you.
Mr. Fawner, do you know the answer to that?
Yes, thank you. Yes, that is my understanding as well. It was actually really, restriction was really in that case, meaning no powerboats allowed from the property.
Are there any other questions from committee? Very well, seeing none, let me read the resolution. Moved by Councillor Edwards, seconded by Councillor Zavitz, be it resolved that the provisional approval of consent application B 040506/21 ML Westbury International be amended by replacing condition number 2 with the following: that a consent agreement be entered into with the township pursuant to section 51(26) of the Planning Act and registered on title, wherein the owners agree to a restriction on motorized watercraft on Marion Lake, to require an investigation to confirm that any trees to be removed in the building envelopes do not consist of bat roosting habitat, to implement the recommendations of the environmental impact study prepared by Beacon Environmental, dated December 2020, to implement appropriate construction mitigation processes and mitigation during the access road / driveway construction, and to complete the annual site disturbance monitoring reporting to the township of severed lots A, B, and C for a period of 10 years. Any discussion? All those in favor? Any opposed? Carried.
Thank you very much. Have a great day.
Our next is under the subject of heritage and attainable housing. This is a report from Mr. Soya on a heritage designation application at in Port Sandfield.
Thank you, Chair Bosemuth. This next application is to be heard is an application to designate a property under the Heritage Act. The subject land is located at 1333 Peninsula Road and has shoreline frontage on Lake Joseph. This property contains a church and a small cemetery and is known locally as St. George's Church. It is owned by the Incorporated Synod of the Diocese of Algoma, and the applicants are Judith Bodum and Rosemary Reed, and they do not, and just noting that they do not own the subject property. The Heritage Act provides municipalities with a framework to conserve heritage resources for the public interest, and this subject property is currently identified as a listed property under the Heritage Act. Listed properties have been identified by the township as potentially having a cultural value or interest, and under the Act, an owner of a listed property must give 60 days notice in writing to the township prior to the demolition or removal of a building or structure. So this 60-day delay provides the township with an opportunity to formally designate such a property under the Heritage Act if the township deems it to be appropriate. And once a property is designated, the owner is required to receive written consent from council before making alterations that may affect the property's heritage attributes. It's the understanding of staff that the applicants are predominantly interested in ensuring the long-term preservation of the cemetery that is located on the property. And I believe they're here today. They have a representative here today to talk about that. And so when the designation of a property is being considered, it is common practice in Ontario for a heritage evaluation report to be completed. The purpose of such an evaluation is to determine if cultural heritage values do exist and to assist the township in determining whether they warrant protection. And staff have recommended in the staff report, therefore, that a decision on the heritage designation application be deferred to allow for the completion of a satisfactory heritage evaluation report by a qualified professional. And I'd also like to note that there are some financial implications for committee to consider in cases where applications to designate a property have been received directly from the landowners of the property. The township has usually retained a consultant to complete a heritage evaluation report, and it has been funded through the Heritage Committee expense line in the Planning Division budget. In this case, the applicants do not own the subject property. Therefore, if committee is looking to potentially pursue designation, it would be helpful to receive direction as to whether the cost of the evaluation should be incurred either by the township or by the applicants. And so it's my understanding that the owner, there's two delegates here today, one being to represent the owners and the other one to represent the applicants. And I'd be happy to answer any questions. Thank you.
Thank you very much. So we do, as just mentioned, we have two delegates. One is Peter Roy, and perhaps we could go with Mr. Roy first. Good afternoon, Mr. Roy. You have 5 minutes.
Well, thank you very much. I don't think I'll need that much time. There are a number of steps that are going to be required if anything is going to be done with that cemetery. We have to get approval from the Bereavement Authority of Ontario. And what I suggest, having reviewed Mr. Soya's report and the limited finances available with respect to the heritage report and the cost of a heritage report, and we will be opposing the application on behalf of the Synod of the Diocese of Algoma. But before we get to that stage, I'm going to suggest that the matter be deferred, the whole consideration of the heritage application be deferred until the Bereavement Authority of Ontario expresses its opinion as to whether or not anything can be done with this cemetery. It would then, assuming if the Bereavement Authority were to rule against it, that it's not going to be moved. So I think I'm just urging upon the committee a step process, beginning first with that application. And those are my submissions. Thank you.
Thank you. Thank you very much. It's Mrs. Judith Bottom is the applicant. We could bring her in, please. There we are. Yes.
Good afternoon.
Miss Autumn, state your name and address, and you have 5 minutes. Thank you.
Judy Bowden, 580 Union Street East, Fergus, Ontario. And thank you for giving the opportunity to speak this afternoon. I'd like to speak about the historical cemetery. I've applied to have designated a heritage site. I'd like to provide some background history of the family before I move on to the cemetery. I've also provided some photos that throughout the presentation or afterwards maybe could be shown. The Cox property began at the original schoolhouse, which is located at 1472 Peninsula Road and extended into Port Sandfield, which is where Prospect House was located. My great-great-grandfather, Enoch Butwell Cox, and his wife Sarah built Prospect House in 1882, which was one of the first hotels in Muskoka. Over the years, many photographs and the history of Prospect House have been documented in magazines and written about in books by local authors and historians. Fanny Cox, the daughter of Enoch and Sarah, is the author of Muskoka Memories, written under the name Anne Hathaway. Enoch Cox donated the land and built St. George's Anglican Church in August of 1883, 1 year after the hotel was constructed. Prospect House housed the first post office in Port Sandfield, and St. George's Church was an adjunct to the hotel until the church was consecrated in 1907. Upon Enoch's death in 1898, his son Edward, along with his wife Christina, my mistake, took over the management of the hotel. The cemetery is located to the southwest of the church and was built in the late 1800s overlooking Cox Bay, which was mapped in 1878, on Lake Joseph, where there are headstones within memorializing the founding family and descendants. As you can see, the headstones. We believe that Jane Taylor, a niece on Christina's side, died in 1865 or 1867, and is possibly the first to be interred here. Enoch and Sarah's daughter Edith died on October 16, 1895, and is interred here along with their son Edward and daughter-in-law Christina, as well as their niece Jane, we believe, an infant son Charles, and possibly one more infant is interred here. We are unsure of the infant's dates of death, but we do know that Charles was born in 1896 and assume he died in infancy, as there's no further records or information on him that we can locate. My mother, Rosemary Cox Reed, being one of the last remaining members of the Cox family, would like to have her ashes interred here alongside her husband's, William Reed, which was interred here in 2006. The cemetery has a small wall handcrafted from hand-hewn local granite and has a hand-forged iron gate made by the smithy, a blacksmith located in Glen Orchard, Ontario. It is our understanding a local cottager that attended the church services organized acquiring the gate. As a side note, the funds to build the church came from hotel guests and local cottagers. The Cox family home was located on the property to the west of the cemetery on the shore of Cox Bay, and also had an identical stone wall bordering the roadside. Our family has always cared for and maintained the cemetery and will continue to do so. My grandparents, Enoch Buell Cox and his wife Daisy, settled on the property adjoining the church and cemetery. The cemetery has always been a great source of interest for people traveling in the area. To this day, many stop to take photographs due to its history and beautiful location. This is the first and only cemetery in Port Sandfield and has historical significance to the area. And I believe the property is currently listed under the Heritage Act. I also believe that once a burial has taken place, this should be one's final resting place, not something to disturb for monetary gain. I have included an email from the Bereavement Authority of Ontario in which they state that cemeteries are meant to be kept and protected in perpetuity, and heritage designation will act as an extra layer of protection for the cemetery. You are welcome to contact Jillian Glover, and she can be reached using information provided in her email. Thank you for your time.
Well, thank you very much. Exactly within 5 minutes. All right, thank you. Let me turn it over to committee for questions to either the owner, the applicant, or staff. Mayor Kelly, start.
Thank you, and through you, and a question for Mr. Roy. The application to, I forget what it's called, Bereavement Authority, is that something that's done without any cost to the church?
I don't know whether there'll be no cost to the church, but there would be no cost to the family. The cemetery, by the way, is inactive, so no further burials can take place on that property. including the interment of ashes.
Thank you.
Any other questions? Councillor Nishikawa.
I'm just thinking through the steps of the heritage designation and the fact that we have this property listed. Is there a concern from the applicant that 60 days is not enough to know what's going to go on? Should an application come forward, or I actually don't understand that's the separation between the cemetery and the church. Like, so when we're talking about heritage designation, we need to do like pick out the attributes that we like about a particular structure and or property. And so I'm trying to understand that part of it. But more importantly, I want to understand, do you feel there's a threat, or that in fact what the municipality has in place currently would not protect you if something was to come forward, an application of whatever that looks like? And I can't see what that application would ever be considered from the Anglican Church, but I'm just not sure what the concern is.
Ms. Bottom, if you could respond, what your concerns are specifically?
Yes, my understanding is that the diocese plans on selling the property, which is so their plan is to have the cemetery, a disinterment take place and the remains removed to another cemetery.
That's
Mr. Roy, could you comment on that?
Well, that's all subject to getting the various approvals. Nothing's going to take place unless the approvals are given, and that would include the Bereavement Authority of Ontario. And if you then decide to revive this application for heritage designation, we would then be into an exchange of expert reports and deal with the matter at that time.
Councillor Nishikawa.
Mr. Roy, I'm just trying to have an understanding of, if you're representing the diocese, I assume.
Yes, I am.
And so, and they're aware that this application is here today. But did they not have, it feels like there's some information lacking. And now I'm hearing that there's a possibility that you're going to be trying to sever this property, or there's going to be other planning applications that would come forward on this property. And I'm just wondering where the diocese sits right now with some of that information.
Well, we're just in limbo at this stage. We learned about this application. I had to get a copy of it through the Freedom of Information Act, and I've discussed it with the Archbishop and the diocese. And this comes at the tail end of a good deal of litigation that went on with respect to a right-of-way from a neighboring property that used to belong to Mrs. Reed that she sold a number of years ago. And family was nice enough to participate in supporting our application in that litigation. So nobody, I don't think anybody's surprised with respect to the steps that are being taken. We're a little bit short on notice about it. Mr. Soya was very helpful in terms of guiding me, but as I said, the steps are the Bereavement Authority, and if that goes nowhere, then this won't go anywhere, this current application. So, I mean, the diocese is not going to scurry in there and do anything improper. That's not going to happen. So I'm just asking for the entire matter to be deferred, and then if it comes up again, we would like to have notice of it.
Councillor Zavitz.
Thank you, through you. I wonder if we could, to staff, could we know the size of this property? This is lakefront property in Port Sandfield on Cox Bay. Could we know the size of it? I don't know the lakefront, et cetera. Acreage, thank you.
Mr. Sawyer, do you know the dimensions of the lot, dimensions and area of the lot? Mr. Sharp seems to have the answer first.
And our winner is.
Thank you, Chair Bosworth. I just happened to have the property pulled up on our digital mapping system, but it's 0.57 acres. And it's 230 feet of lot frontage, and that's assessed. So Municipal Property Assessment Corporation data.
Is that would disqualify it from being a building lot then? Director Pink.
The property is zoned institutional currently, being a church. However, it does exceed our existing lot of record criteria. It would not exceed the size we would look for new lot creation. But if it were rezoned to waterfront residential at that size, it would have building rights.
Very well. Any other questions from council? Committee, sorry. So there is a suggestion of a deferral. Could we get some idea from committee about whether we should defer or not? Mayor Kelly, do you have a comment?
And it's a comment and it's to make sure that I understand correctly. If I understand correctly, the deferral simply buys time for the diocese to make the application under the bereavement authority. And if the decision, which I have no idea how long that takes, but if the decision comes back preventing any disinterment, then this is kind of a moot issue, isn't it? Really, we don't have to worry about it anymore, or do we? It seems to me that it takes the conflict out of this. That whoever is opposing it no longer has anything to oppose because they've been told under the bereavement authority that you have to leave this thing in situ. And all I'm trying to say is that may be the most efficient way to deal with it.
Councillor Nishikawa.
Sorry, some may know that I've had a history in trying to preserve heritage in the township of Muskoka Lakes. And so my past experience led me to believe that you don't have to be the property owner to ask for a designation on a site.
No.
And so I recognize that this particular application could and should be heard, not based on whatever the diocese does, but in fact, there's still a protection that is being asked for, if I'm correct. And so having said that, I'm not comfortable with deferring this based on giving the diocese an opportunity to correct or anything, because it's still not dealing with the heritage ask at this point. That's my understanding. And so I'm not sure, David, if you want to correct me on the Heritage Act, but I do believe that the applicant put an application forward and has the right and ability to have it heard and deferred, if that be. But and I just don't want, where are we stepping and what we're allowed to do, I guess.
Mr. Pink.
Thank you. Through you. Yes, Councillor Nishikawa is correct. The property owner does not have to be the applicant. However, I guess I would look to the applicant whether such a decision from the bereavement authority would render this situation moot. But I think also council does have an application in front of itself. They could choose to designate the property nonetheless. You still have that option. But I guess I would look to, again, the applicant whether confirmation that the remains could not be disinterred, whether that she would withdraw the application, I think is in essence what Mayor Kelly is asking.
I just want to remind council, though, that past councils approved this property to be designated in the future, to more or less be on the watch list. Right. So we had already recognized this property as having heritage attributes.
Ms. Bottom, the question from Director Pink to you was, if the authorities in charge of cemeteries would not allow any disinterment, would that be satisfied to you and you would withdraw your application?
So you mean it would not be designated heritage, is that correct?
Well, it would not be designated. There wouldn't be a need to designate. We want to know if there's no need to designate it heritage because the cemetery could not be disturbed. If your objective is to ensure the cemetery is not disturbed, and the authorities in charge of cemeteries come back and says you cannot disturb it, has your need been met?
I would say yes. But as long as that would be like nothing could happen beyond that. I just want to make sure that nothing can happen. That's my main concern as far as the cemetery goes, that nothing can be removed or relocated. I feel it should be heritage because of the history. But if it comes down to nothing being disturbed and I have to remove my application.
You wouldn't have to, just would you?
Oh, that's a tough question.
All right, fair enough. And how do you feel about the deferment? Yeah, it's a good question. If we deferred it, just to get that information.
I don't feel it should be deferred, no.
Thank you. Councillor Zavitz.
Thank you, through you. So who pulls the bereavement board trigger? Is it the township? Is it which with these two parties? I think to my mind, before we decide whether it's heritageable, we should decide, I think to the mayor's good point, whether in fact it's a moot point because the property will be fallow forever. If that's the decision. If it's not the decision, then we as a committee can sit here and talk about heritage and all the other aspects to which way to go forward.
Mayor Kelly.
Thank you. And just one more question for Ms. Bottom. I may have misunderstood, but if I got it clearly, the cost of determining whether it's heritageable or not falls to the applicant, which would be you.
Yes.
And I'm wondering if your answer to the question changes at all, if you find out that as opposed to going through a hopefully relatively inexpensive undertaking that gets you to the same goal, you're going to bear the cost of going through the heritage assessment and not, from my perspective anyhow, get anything more.
Okay. My understanding was there's $2,500 allocated towards having the report done, the evaluation done. And beyond that, it would be up to me whether I want to carry on, I believe. So this is not the situation then?
Yeah, I was going to say, Director Pink, can you comment about the funding for this?
Thank you. Through the approval of the 2023 budget, council did put aside it was approximately $2,500, which is typical under the assumption that a heritage committee may be formed, and that would give them a small amount of funds to pursue initiatives. So yes, there are funds there. However, council did not identify a specific purpose or intent for those funds.
And if I could ask
other than, sorry to interrupt.
I could ask a question. Do we have an idea of how much a heritage report costs?
So through you, in my experience, it's been some time, and as we know, inflation has been rampant recently, but it was approximately $2,000, but it will depend on the property in question. Keep in mind also there's a legislative process to go through. There are advertising costs in the local paper for and after registration fees. I think all in all, you're looking in the range of 2 to 5, probably today's dollars for the whole process.
May I speak to that?
Yes, Mr. Roy.
My information from a lawyer at Eric Burles who specializes in these applications is that the cost would range between $5,000 to $7,000 in today's terms. And that lawyer parks on the church property to buy her ice cream. So she's quite familiar with the property and the area. So just to put the magnitude of the potential expense in perspective.
Councillor Edwards.
Yes, thank you. This is to David. Hope he can answer it. in Ufford, there's a little cemetery right beside a house there. It's been fenced off. It was the old Anglican church. Was that ever designated, or was it like, what was the status of that? Could that be compared to this? I would hate to force the diocese to a Heritage Act if there's something else can be done. And if the applicant wants to go forward with it, I think the applicant should be paying for it. And I would also say I'd like to see this actually deferred until we get all the answers. Thank you.
Mr. Pink.
Thank you. Through you. I'm fairly certain the property's not been designated. I'm familiar with these 12 or 13 properties we have designated in the township. However, we have approximately 70 to 80 properties on a list, and it's quite likely that that cemetery is on that list. I can confirm that if council wishes, but it's likely on a list similar to the subject property.
Councillor McIntyre.
I have a question, because I remember way back when we started and I knew nothing. They were talking about the new legislation for Mr. Ford that was going to deregister all heritage properties.
There was a time limit.
Okay. So that doesn't feed in here at all. In other words, if she wants to protect herself, even if it was, she would have to file another application now anyway. Is that right?
Director Pink, if you could comment on that.
Thank you. Through you, that is correct. Forget the bill off the top of my head, but recent changes to provincial legislation have been made to the Ontario Heritage Act. And essentially, I believe it's 2 years, starting might have been this past January, where properties on the township or any municipalities register, which is the list, will be removed after 2 years if it is not designated. So that would implicate the subject property, it would implicate all the 70 to 80 properties the township has on its register. And it would remove what's referred to as the interim protection. So just for committee's edification, the registry or register or the list, what that does is if the diocese were to come forward and apply for a demolition permit for the church, the municipality would not be obligated to issue that demolition permit for 60 days while you could contemplate whether you wish to initiate a designation. What the designation does is then identify very specific attributes of the property that you're looking to preserve, and then the property owner would no longer be permitted to modify those without council permission.
Okay.
So unfortunately, as a result of the legislation, that interim protection will be lost if the municipality doesn't move on the 70 or 80 or so properties we have.
Can I just throw in? There's a really good working group thing.
All right, so Councillor Nishikawa.
Thank you. I'm just going to request that we move forward with the deferral. And I agree with Councillor Edwards that there's more information that should come forward. I'm also, again, I'm going to be very protective of that list that we established over the years. And the reality is that we didn't have the committees in place and things to move some of that forward. But it was pretty important. Like those properties were very important to this township. And, you know, again, the discussion, people travel all the way to Europe to look at old stuff. But in Muskoka Lakes, we bulldoze old stuff. And so I want to really make sure that we pay attention to what we had on the list and not throw it, you know, just throw it away, because there was important reasons why that. And apparently it came up today. So I would hope that we're going to move forward with the deferral that allows both parties. It's not just one-sided that we're only waiting for information from Mr. Roy, but also further information that the applicant may want to bring forward.
Including possibly paying for the study. Yeah.
Sure.
I get a sense from around the room that we might want a deferral. Good. I think we will defer it, and we will ask Mr. Roy to go away to speak to what was the name of the organization? The Bereavement Authority.
Oh, the Bereavement Authority, yes. I'll get instructions from the diocese, and it is their intention to move forward with the application to the diocese. We're not just using it to delay. Right. Sorry, the Bereavement Authority.
Okay, that's fine. We need to, Councillor Zavitz.
Thank you, through you. I guess as I read the recommendation, my only concern is with what you've just said is that the recommendation certainly says it recommends that this be deferred for the submission of a satisfactory heritage evaluation report completed by a qualified professional. So we are not asking for that. So in fact, would we just simply be deferring this, or would we have to have a separate
No,
resolution?
we're doing resolution to defer
Perfect,
with
thank you.
instructions. Thank you. Councillor Edwards?
Maybe Mr. Pink knows this. Can't remember which church it was and that, but there was a United Church. And I believe there was a cemetery beside it. And it was turned into affordable housing. And I can't remember which church it is now, sorry.
Director Pink?
Footsbay, that's right, yeah. So what happened to that cemetery?
Still there, as far as I know.
Pardon?
Through the chair, it's still there. I think, as we've heard, quite difficult to receive permission to allow remains to be disturbed. But as far as I know, I'm not an expert.
Well, this is one of the things I was thinking, but it was just a case that it just popped in my mind that we let the church be sold, but we kept the cemetery part. And I guess the township then would have to take over the cemetery. Is that right?
Through the chair. From what I recall, there were discussions during the rezoning of the church to allow housing. It was more allowing the appropriate fencing and buffering between the two. But as far as I know, the cemetery remains, and I don't believe it's in our ownership.
Okay, thank you.
All right, we have a new resolution. All right. I'm going to read the resolution. Moved by Councillor McIntyre, seconded by Councillor Nishikawa. Be resolved that Planning Committee recommend to Council that a decision on the heritage designation application Diocese of Algoma Road number 4-9-051 be postponed in order to permit the incorporation synod and of the Diocese of Algoma to make applications with the Bereavement Authority of Ontario regarding disinterring and closing the cemetery on site. Any discussion? Did we get the wording right? All those in favor? Any opposed? That's passed. Thank you.
Thank you very much.
The next, thank you, Ms. Bottom, and thank you, Mr. Roy.
Thank you.
The next application is number 12A under unfinished business. And I think Mr. Simpson is trying to compete with Mr. Fauner about how many numbers we can get in the. This is B32/33/34/35/36/21. I think Mr. Simpson's winning. ML zoning bylaw 17/21, OPA 57-12, and bylaw 2021-047. This is Donaldson and Sift and relates to Meta Island in Lake Muskoka. Mr. Soya, please proceed.
Thank you, Chair Bosenworth. So that's correct. The next applications are official plan. It's an official plan amendment application, a zoning bylaw amendment application, and 5 consent applications in the name of Donaldson and Sift. And the subject property is one of 2 existing lots on Meta Island on Lake Muskoka. A public meeting for these applications was held in July of 2021, and approval was considered by a planning committee at that time. I would direct committee's attention to the sketches starting on page 481 of today's agenda package. And the first sketch shows the proposed resulting lots, and the remainder of the sketches show the retained and severed lots in each sequential severance application. Similar to the Baker applications that we heard earlier today, the manner in which these consent applications are sequenced is quite technical. But the resulting lot sketch on page 481 provides a good overview of the ultimate proposed result. The purpose and effect of the applications is summarized as follows. The applicant proposes to divide the subject lands into a total of 6 lots. 5 of the proposed lots are currently vacant and are naturally vegetated, and the proposed 6th lot is developed for residential purposes. The official plan amendment has been submitted to permit the division of the island into 6 lots instead of 5. The township's official plan explains that lot creation on an island may be considered provided that adequate long-term parking and docking facilities are secured to the satisfaction of the township, and less than 5 lots are proposed. In this case, however, 5 new lots plus 1 retained lot are proposed, and therefore the official plan amendment application has been submitted. The zoning bylaw amendment is required to implement the recommendations of an environmental impact study by placing a portion of the subject lands into the environmental protection EP1 zone, by restricting the location of buildings and structures to within identified development envelopes, and by permitting certain existing structures to remain on resultant lot 6, and to permit the proposed cumulative dock width of existing docks to be 95 feet instead of 75 feet on resultant lot 6. In response to the circulation of the notice of public meeting in 2021, and at the public meeting, concerns were raised by members of the public, with the predominant concerns being related to the securement of long-term mainland docking and parking facilities, primarily to ensure that the future owners of the proposed lots would not use public parking and public boat launches and docks as their means of access. And potential impacts on the environment was also raised as a concern, including potential impacts to fish habitat and wildlife habitat, loss of forest cover, and impacts on water quality. Increases in marine activity, marine traffic, and potential safety concerns, and concerns about potential increases in noise from additional residential development were also raised. So in 2021, Planning Committee had deferred decisions on these applications and had requested that a license agreement that secures mainland boat slips and parking spaces be submitted for review, and that the lease agreement secure more than 1 mainland parking space for each proposed resultant lot, and also that the environmental impact study undergo a peer review by a qualified environmental consultant, and for it to be updated if necessary. So to satisfy these requests from committee, the applicants have submitted additional documentation. They have entered into a significantly more robust lease agreement than was provided in 2021. This agreement identifies the landlords as the owners of Mortimer's Marina and the owners of the neighboring property, which operates as Mortimer's Point Landing. And the tenants are described as the owners of the subject property on Mita Island. This lease agreement provides 1 boat slip and 2 motor vehicle parking spaces for each proposed island lot. And the agreement has been entered into for an initial term of 5 years, after which the tenants have the right of first refusal for up to 3 additional 5-year terms for a maximum rental period of 20 years. And the agreement includes provisions for the assignment of rights from the current tenants to future purchasers of the 6 proposed lots. And staff are thereby satisfied that the requirement of the township's official plan to provide adequate long-term parking and docking facilities is adequately addressed through this agreement. So as requested by Planning Committee, a peer review of the environmental impact study has been completed. And as a result of the peer review process, additional information was provided about the methodology of the study, and the primary change resulting from the review was that the boundary of an area that is zoned, or that is to be zoned, to environmental protection EP1 now accurately matches the boundary of the identified wetland in that location, which is located on the northwesterly side of the subject property. It's also would also note that planning staff had originally recommended a condition of consent requiring the number of existing sleeping cabins on resultant lot number 6 to be reduced in accordance with policies of the township's official plan. However, the applicants recently requested that the existing sleeping cabins be permitted to remain on the property until a redevelopment plan for resultant lot 6 is proposed. Staff in this case would agree that some flexibility can be considered in recognition of the fact that these buildings are legal non-complying. While staff continue to recommend that the number of sleeping cabins ultimately be reduced, staff have recommended a minor amendment to bylaw 2021-047, as well as a requirement through a consent agreement to permit the sleeping cabins to remain, the land-based sleeping cabins to remain until an application for a building permit on resultant lot 6 is submitted. At that time, only a single cabin is, the recommendation is that only a single cabin is to be permitted to remain, or 2 sleeping cabins with a combined maximum floor area of 661 square feet. In addition to the previous staff report, staff have prepared an additional report to provide an update and have recommended that the applications be approved, subject to minor amendments to the draft bylaw and subject to conditions of consent. And the recommended minor amendments involve a replacement of Schedule 2 to the bylaw with a revised site plan showing the revised boundary of the proposed environmental impact, environmental protection zone, and an amendment to only permit, as I've mentioned, the existing 3 land-based sleeping cabins to remain until a building permit for redevelopment on resultant lot 6 is applied for, after which only a single sleeping cabin is to be permitted, or as an alternative, 2 sleeping cabins with a combined maximum floor area of 661 square feet. The proposed or the recommended conditions of consent include requirements for submission of registrable descriptions of resultant lots and easements, along with a registered copy of the reference plan, that a consent agreement be entered into and registered on title, wherein the owner agrees to implement the recommendations of the environmental impact study, the associated peer review, and the stage 2 archaeological assessment that was completed. Also, wherein the owner also agrees to not utilize public parking and docking facilities as the principal means of access, and to demonstrate that sufficient long-term mainland parking and docking has been secured, and wherein the owner agrees to reduce the number of sleeping cabins. Staff also recommend a condition that requires the resultant lots to be made subject to site plan control in the event that the province does reinstate the site plan control process prior to the issuance of a consent certificate. Further, staff have recommended that an existing sauna building and bedrooms in boathouse number 1 be removed as had been intended by the applicant, and that confirmation be received that each of the resultant lots can be serviced with individual septic systems, that cash in lieu of parkland be dedicated to the township, and that the zoning bylaw amendment be approved, and also that the official plan amendment be adopted by the township and approved by the District of Muskoka. And I have no further comments at this time, but I'd be happy to answer any questions. Thank you.
Thank you very much, Mr. Sawyer, for that fulsome report. We have a total of 6 delegations today. All but one of them have 2 minutes, and the first one is Mr. Simpson, who I believe is the agent for the applicant. You have a couple of minutes, Mr. Simpson.
Thank you, Madam. I was going to say, Madam, I'm used to dealing with the municipal council. I'm really apologizing for that.
Better looking. I agree.
I appreciate what Sam said, and I have to say something because my clients are here and they're going to get a bill. But the reality of it all is what the staff report is excellent. All the conditions that have been recommended as conditions of the approval, including the 5126 agreement and the implementation of all the recommendations in the technical reports are totally satisfactory. I would comment that the lease agreements are in effect. It's the agreements that are included in the package are not the intention of the owner to enter into an agreement. Those agreements are already executed, and my clients are currently paying the rental rates, the seasonal rates for those docks and parking spaces now. So it's not an agreement or a promise to enter an agreement. The agreement is there, and that gets back to Councillor Nishikawa's comments earlier today, but the old standard of writing a letter. So I really appreciate it. I think the principal concerns that were addressed by council at that time were, as Sam said, the requirement for boat slips on mainland and parking spaces, and the municipality required 2 for each lot, and that's been affected through the agreements and arrangements with Mortimer. And the environmental impact study, it was subsequently peer reviewed after the public meeting, and again the agreements and conditions will require the implementation of all those recommendations. So I do thank the committee for the opportunity to speak, and I'm available should there be any questions. Thank you very much.
Thank you very much. Next delegate is Mr. Donaldson. If you could keep to your 2 minutes. Thank you very much.
Thank you very much to the planning staff for their support in this, and for us being able to pull it back to this time. One thing that Wayne Simpson said that he didn't entirely know, we're not actually going to pay the Mortimers until it's all passed. So as soon as we're passed, kind of the day after it's passed, the 21-day wait period is done, then we will be paying the Mortimers, I believe, for 6 slips. We'd be to pay them for 6 slips for 5 years, 6 dock slips. So that's our agreement with them, that we will pay for those 6 slips upfront, and then as we need them, then the lease will start whenever the services are complete. So that's our agreement. Anyway, that's what I've told them. So anyway, so thank you very much. I think that Bill and I have done everything that needed to be done. The archaeological study's been done, the environmental, the lease agreement, I think, is the best lease agreement that's ever happened in the township of Skoke Lakes before. And we thank Melissa for that, and also the township lawyer who had the lease, but Melissa actually made the lease better than the township lawyer wanted. So anyway.
Thank you very much, Mr. Donaldson. Mr. Sift. Nothing to add. Very well. Thank you very much. Ms. Cope. On behalf of the agent, I believe.
So I was just coming today to make sure if there was questions about the lease or questions that come up from anyone else that was delegating, that I could possibly try to answer them for people. So I have nothing new to add, just I'm here in case there was questions that I might be able to help.
Thank you very much. Christopher Morgan, I believe is he? Or it's Rhoda, right? Need his name and
yes.
I'm here.
Hello, Mr. Morgan. Welcome. If you could start with your name and address, and then you have 5 minutes.
My name is Christopher Morgan. I live at 1045 East Rankin Road, Port Carling, POB 1JO. Can I have the slides be put up, please?
Do we have the slides? Put it on.
The lease agreement provides for 6 slips at Mortimer's Marina, 6 parking spots at Mortimer's Marina, 6 parking spots at Mortimer's Point, which is under different ownership. The lease presented to the planning committee in connection with this application has 3 schedules, A, B, and C, with drawings of the properties. I will be speaking to parking and docking on these schedules. Next slide, please. I am recommending that the applicant.
I know you're limited to 5 minutes, but if you could get a little closer to your microphone and speak just a little bit slower, then otherwise your 5 minutes will be of little value to us.
There's a lot to get through. I'm recommending that the application be deferred. The township should commission independent parking study paid for by the applicants to determine capacity and adequacy of parking under bylaw 3.28 and policy 5.24D. Next slide, please. I will first deal with parking at Mortimer's Marina. Next slide, please. Here is Schedule A to the lease agreement. It's a plan view of Mortimer's Marina as it is today. You can see that it's a rather narrow property. There's 2 retail buildings outlined in purple with about 1,000 square feet of space, 35,000 liter fuel tank for the retail marine gas pumps outlined in red, a large building housing service bays, the workshop and the main office outlined in blue, and a number of existing boat slips, some numbered, some not. Next slide, please. There are 2 rules.
Sorry, could you just pause for a minute? We're having a little trouble getting this slide up full size, and we'll put your time on hold. Don't worry.
I'm sorry. Thank you very much.
No, it's not your problem. We just can't get the thing to be big enough that anybody can see. It's your.
There are 2 rules that determine parking requirements. Bylaw 328.
No, hold on. We're not ready yet. We can't see your slides, so.
I'm sorry.
We're having trouble getting to go full size. So nobody can see it.
Okay, I'll wait. Thank you.
Today seems to be our day for technical challenges.
Let me know.
All right, so we now have the slide called 25 parking, 6 needed.
Right.
So
Okay.
start there again.
Oh, all right, thank you. There are 2 rules that determine parking requirements. Bylaw 328 says a marina has to have 1 parking space for 215 square feet of retail and 1 parking space for each slip provided. And the official plan, as you know, it puts out requirements for long-term parking and docking. Last summer, the committee made it clear that 1 parking spot was not enough, and hence the offer by the applicants for 2 parking spots. On this slide, you can see that there are 15 number slips in red, 6 other slips in blue, and the 1,000 feet of square retail space for a total of 25 required parking spaces. In the lower right-hand corner, marked in green, you will see that clearly there are not enough to meet this requirement. Next slide, please. Now let's look at Schedule B to the lease agreement. This shows proposed redeveloped docks, 6 of which would be allocated to the applicants if the redevelopment is approved. There are 13 number slips, 6 unnumbered slips, and the retail operations requiring a total of 23 parking spaces under Bylaw 328. As you can see from the red dots on the drawing, these 23 spaces are sprinkled throughout the narrow property at the entry on the right, in front of the service bays and office where the marina operations are conducted, and up near the retail space and sandwiching the above ground fuel tank. Next slide, please. This slide shows that some of the proposed parking spots are currently used for marina operations. Where will those operations be relocated on this narrow property? Next slide, please. Of particular concern is the 2 sets of parking that sandwich the above ground fuel tank, which is crosshatched in red on the drawing. There are 3 parallel parking spots behind the tank marked in blue, numbered 1, and there are 3 parallel parking spots in front of the tank, numbered 2. These spots are right up against the tank, especially those in area number 2. People will be getting in and out of their cars, loading and unloading, watching their kids right next to the fuel tank. I also marked on the drawing in yellow possible locations of the tanker trucks that would come in to replenish the fuel tank. Immediately, you can see that the driver will have a challenge navigating this space. During refueling, many of the parking spots, both 1 and 2, and perhaps the angled parking nearby, will not be accessible to persons in those spots. This is dangerous because people will become impatient. Next slide, please. Next slide. On the left, in area numbered 1, are 3 spaces. Oh, sorry, you've gone 1 too far. On the left, area number 1, there are 3 spaces behind the fuel tank. This does not look suitable for parking, let alone parallel parking. Kids could get out of the car and tumble into the tank. On the right photo, the 3 spaces on this side of the tank would be far too close To the tank, the safety posts would inhibit egress from the automobiles, and people will be flinging around luggage and equipment, unloading their kayaks from the car, and so on. Marina operations, as you can see, currently block access to this space. There is an operational reason why this equipment has been placed there. The introduction of parking in this space will not make that reason go away. Will this congestion continue to be present, making access to this parking difficult or impossible? I don't know the answers to these questions. It's likely that no one in this room does. We need an expert. Next slide, please. This slide shows location of the 7 angled parking
Mr. Morgan,
spots.
if you could wrap it up, please. You've got just a little under a minute left.
Okay, let's go to slide 13, 14. This is Mortimer's. Next slide, please. You can see that it's already, Mortimer's Point, you can see that it's already packed up. Next slide, please. Next slide, please. This shows the 2 docks which are on the schedule as shown to the committee. Next slide, please. But there's a 3rd dock, which is not in the record. The facts on the ground are different from those represented in the record presented to this panel. This new dock may be a result of a proposed severance of large islands in the area, but I've not been able to confirm that. But regardless, the dock is there for something. Next slide, please. There are 8 slips on this dock, which on the 2-to-1, two parking spots per slip would require an additional 16 spots, but the parking lot on the other side is already maxed out. Next slide, please. For both properties, there are not enough available parking, and we know what happens then. Cars will spill out onto the adjacent streets. Next slide, please. So there's not enough parking at Mortimer's Marina, as I've shown. There's not enough parking at Mortimer's Point. Also, bylaw 3.28 says that parking area for the marina must be in the same ownership if there's off-site. That's
Mr. Morgan, do you have a conclusion page? Because I'd like to move to that.
Yes, next page.
I think your points are becoming quite clear.
So I think the application should be deferred. The township should commission an independent parking study paid for by the applicants to determine capacity and adequacy of parking under bylaw 328 and bylaw and policy 5B, the policy. Thank you.
Thank you very much. Next delegate is Mr. Ken Pierce. And Mr. Pierce, you have 2 minutes. Then we'll.
Well, I thought I had 5. I'll speak faster. Ken Pierce, Muskoka Lakes Association, 65 Joseph Street, Port Carling, POB 1JO. Our primary concern was the requirement for mainland parking and docking. I think that lease agreement is much improved over what we had before. I had a handout, if we could hand those out, a marina letter from Gravenhurst for a 14-unit resort on an island, Taylor Island, and this is what they provided. And also handing out the previous lease agreement, the 1-pager that the applicants had for Mortimer's Point Marina, which don't include anything about rent or anything like that. The 13-page lease now that is in place certainly addresses that. And as Mr. Soya said, it's got not renewal terms, but it's got rights of first refusal for 5 years each for 3 additional terms. So a total of 20 years. That is certainly heading in a very good direction. I think puts us in a much better place. The old OP required this. The new official plan adopted also requires long-term docking and mainland parking. You heard that there's 6 boat slips, but a total of 12 parking spaces. So 2 for each proposed additional lot, which is great. That's what council previously spoke to, and I think that's also heading in the right direction. The most important conditions of approval, I know this will go into a lease agreement, but the parties could amend that lease agreement at any time. It's an agreement that is with the township, and that's going to be part of either the consent agreement, or if there's site plan control again for waterfront properties, it'll be in the site plan agreement, which is great. And the key condition, as I see it, of those conditions that were mentioned, the critical one is the 4th bullet point, which reads, demonstrate secured means of long-term mainland parking and docking access for the resultant lots at all times. And the key words in my view are at all times, because a marina can go out of business. There's things that can happen. They can get sold, changes. But the point is that that will be an enforceable agreement registered on title that the township can rely on. And we're very pleased to hear that. The third bullet point that was mentioned that will be a condition notes that public parking and docking facilities are not to be used as the principal means of access. And so that's the corollary point to that. This condition and this requirement for mainland parking should be part of every severance application going forward. And we heard two this morning. One for one more parking spot at Mortimer's Point, and I think the other one is Gordon Bay Marina as well. So this is great news as far as the MLA is concerned. Heard the comment from councillors Nishikawa, I think it was Zavitz, that this is something that's top of mind to council, which is great to hear. Also heard it's going to be difficult to track this and make sure that it's being enforced and that these arrangements are long-term. But the good news is that it isn't a binding agreement and it will be registered on title. Thank you.
Thank you very much, Mr. Pierce. So let me turn it over to committee for questions of the applicants or any of the delegates. Start with Councillor Zavitz.
Thank you. I guess a question for staff. These 6 properties, are these 7,500 square foot cottages and double slip 2-story boathouses we're looking at times 6? Yes. To anyone?
Mr. Ping. Mr. Sharp.
Through you, Chair. So if approved, these lots will be permitted to be developed in accordance with the township's zoning bylaw provisions. So, you know, as we know that there's lot coverage caps of 10% both over the area of the entire lot within 200 feet. There's specific setback requirements in the zoning bylaw. There's a maximum permitted habitable floor area in the zoning bylaw of 7,500 square feet. If you could develop a dwelling that large and still comply with lot coverage and the other constraints imposed by the zoning, these lots have fairly significant frontage. So they will be permitted a dock and a 2-story boathouse each. So, you know, I don't know if that helps answer your questions, but I think, you know, the main thing is you know, once these applications are approved, just like any other lot, there would be a requirement to comply with zoning.
Okay, thank you. If I might have a secondary.
Yes.
Yeah, so to my mind, and again, this is a new frontier with the island development of this scale. And it's to me, the word massive comes to mind. I mean, it's large. Although I do believe, and I guess it's a statement, I do believe that they've complied with our requirements at the marina, you know, so I can see them doing everything they can as a developer. I just I look at this and I think this is a lot, to be quite honest, just a matter for the record. I think that this is a lot of development on a little island on Lake Muskoka, to be honest. Thank you.
Mayor Kelly.
Thank you. And through you, I want to focus on the parking issue because it seems to have a cloud thrown over it, notwithstanding the MLA's happy disposition about it. Let's just, let me ask a couple of questions, and I think probably to Ms. Cope, if I may. We saw Mr. Morgan's analysis of the parking situation. I personally don't think we can look into that quite as far, and I think we're making big assumptions. My question to you, quite simply, is there 2 boat parking spaces? Is somebody, one of these 2 landlords, obligated to make 2 car parking spaces and 1 boat space available for each of these 6 lots? That's good. And notwithstanding that, there is also an overriding prohibition.
I didn't hear the reply there. Sorry.
If you could come up.
Oh, sorry.
Come up to the microphone, Michael.
They've
I don't know.
No, it's on.
They've contracted to provide the 1 slip and the 2 parking spots over those 2 properties, which is why we included both of those property owners as the landlords, to ensure there was enough parking because they didn't have enough just with the one landlord. So it took negotiation to make sure that we could satisfy this one slip and 2 spots for each of the lots being proposed. So that took a while, but that was what they negotiated, and they're contractually, that's what they agreed to.
Thank you. And just a quick follow-up. There are 5-year term plus 3 renewals of 5 years.
Yeah, so we kept it under 20 years. We kept it at 20 years. I don't want to be foul of any idea of Planning Act violations, if it would or not, but that was a long amount of time. If you looked at the contract we had prepared, we included a schedule that was the format of what an assumption agreement would look like, assuming that at some point, one of the lots would be either transferred possibly to a family member or eventually sold or dealt with, to ensure that there was already a mechanism in place that the landlords had approved in terms of getting it to the next person that might own it within that 20-year period. So the idea to ensure as much as possible the contract could be extended to further purchasers, notwithstanding understanding that at any time it's a contract between 2 commercial parties privately. They could change it. Future owner could own a landing or own shares in Stills Bay or have one of those other options that are in the new official plan as a different parking option. They don't have to stay with this contract, but there's a option available if they want to, and they're going to pay that they could continue to do that.
Perfect. Thank you. And notwithstanding the ongoing existence of either or both of those landlords or parking agents or whatever they're called, there is still an obligation not to use public space that is
In addition to
runs in perpetuity. It just runs with the title to the land.
Yeah, my understanding is on the title, there's this lease agreement that was required to fulfill the application so that they could even come here today to speak with you. And then on top of that, one of the conditions of the severance will be that consent agreement that's going to require that they're confirming that they have parking and that if it changes, they have to secure parking. And I'm assuming the township, I don't think you have a mechanism currently, but maybe it's one of those, when you apply for a building permit, where's your proof of parking? I don't know if that would be the time to check in with people if they're getting other stuff done. I don't know if it can be, but maybe that would be the way. Do you still have parking when you want to build that house and follow up that way?
One last really small technical one. Mr. Donaldson mentioned that I think there were 6 parking spaces already engaged. The rest would be tripped at some point when they were needed. Just a first 5-year term run from that date or run from today?
So now, because one of the conditions I think that was my understanding is we had to have an agreement signed. So it had to have a start date to be able to come here. So we had something firm, because one of the arguments I believe at the last hearing was that they only had an agreement to agree to possibly do something. So we have a firm contract that they could start renting now. I think how they've determined what they will pay or not, that's between the parties. But the reality I think today is even if this is passed, the lots aren't being created today. So they don't need 6 boat slips and 12 parking spaces. Today, it's still just, it's one lot today. There's going to be a period of time, but they've done all the securing. They've agreed what they're going to pay. And they might be starting to pay for 6 spots and 12, like when this is passed, so that they could come here to do this. So I know they're trying, and they've been working with the marina to make sure that we had the 2 spots, 1 slip, different variations if the marina had changes, which is why there's the multiple schedules that are being talked about, because what it might look like today, what they've done, I believe in other hearings, their own planning and stuff, what it might look like, and that either way, one of those slips is assigned to these guys and 2 of the parking spots if we're in this configuration or whatever the new configuration. And that's, we use the sketches in terms of the best kind of we have. They're not part of the application, so the schedules aren't part of what the severance is. This is an idea of, we are to show council, hey, we're in this spot and this spot. This is what the contract was to be promised. I don't know if there's additional dock at that one location. It's the parking spot, and we're trying to do our best. So here's what exists. Here's what they are proposed. Either way, we have one of those flips, and 2 of the parking spots is between those different plans. That was the goal, to try to include it, to show you.
And I suppose there's always a possibility that a lot of those cars and boats we saw in the pictures would be excluded from mean, they could be moved off or they could move away by another place, whatever it is. I mean, they've got an obligation to provide you parking and dockage.
Yes.
Thank you.
Any other questions? Sure.
So they already have new permits in place for 6 docks. They're already, and so as soon as we pay them and sign the agreement, they can start to build those other 6 docks for us. So right now there's 6 docks that are appointed to us. Okay, but this winter, as soon as it's done, they have the permits in place to build the other 6 docks for us. And on those 6 docks is where they're going to build the boathouses. And our contract says we are going to buy probably 6. First of all, we're going to buy 2 of the boathouses. We're committed to 6 of the docks, but we can't have the option for 6 of the boathouses. And additionally, for $1,000 per year, we can have another parking spot. So if we want 4 parking spots, it would be our original contract plus $1,000 for each parking spot over that. So that's part of our contract.
Thank you very much.
Thank you.
Most helpful. Ms. Coe, you want to add? You have to need to be on the microphone.
I think when Paul says boathouse, I think there's slips. I think there might be covered slips in one of their permit plans, but they're not boathouses like those 2-story boat. I just want to clarify that's not what we're talking about.
Covered slip is a boathouse. Are there any other questions or comments from committee? Thank you. You're right. Questions? Councillor Zabitz, no? Nobody online? Very well. Let me read. Mr. Soy, I can't remember. Do we have an amendment to this one as well? We do. Okay. How many amendments do we have? All right. So let me read the main one. Moved by Councillor Zabitz, seconded by Councillor Mazin. Be resolved that Planning Committee recommends to Township Council that consent application B 32, 33, 34, 35, 36/21/ML Donaldson and Sift be approved subject to the following conditions. The registrable descriptions of the resultant lots number 1 through 5 and any required rights of way and easements be submitted to the township along with a registered copy of the reference plan. That a consent agreement with the township under section 51(26) of the Planning Act be entered into and registered on title wherein the owner agrees to implement in all respects the recommendations of and advice of the environmental impact study dated March 2nd, 2021, and the response to peer review comments dated June 8th, 2022, both prepared by McClaskey, Nielsen and Associates. Implement in all aspects the stage 2 archaeological property assessment prepared by Amic Consultants Limited dated 2020. Not utilize public and docking facilities as the principal means of access to the resultant lots. Demonstrate secured long-term mainland parking and docking accesses for the resultant lots at all times and reduce the number of sleeping cabins to 1 cabin or 2 cabins with a combined maximum floor area of no greater than 661 square feet. That the resultant lots be subject to the site plan controls should the authority to impose the process be reinstated by the province of Ontario prior to the issuance of a consent certificate, or in the absence of a site plan control, that a consent agreement under section 51(26) of the Planning Act be entered into as detailed in consent condition 2. Number 4, that a sauna building and bedrooms in both house number 1 on retained lot number 5, resultant lot number 6 in application B 36/21 ML be removed as intended. The confirmation be received that the township is satisfied that the resultant lots can be serviced by individual on-site septic systems to the satisfaction of the township, and that any problems with the existing septic systems be corrected to the satisfaction of the township. The cash in lieu of parkland be dedicated to the township in amount of 5% of the assessed value of the 5 vacant resultant lots or the entire lands, whichever is left. That a zoning bylaw amendment be approved to rezone the portion of the subject's lands from waterfront residential's WR3 to environmental protection EP1 to define development elements for the land-based buildings and structures, excluding sun decks, and shoreline structures to require reductions in the number of existing sleeping cabins and to permit a maximum cumulative dock width of 95 feet on the retained lot number 5 and resultant lot number 6 in application B 36/21 ML. And finally, the official plan amendment 57 be adopted by town council and approved by the district of Muskoka, district municipality of Muskoka. Now I have to read this amendment. Right? No?
No.
All right.
That's the consent.
Oh, I'm sorry. Okay, I thought there was a movement. This one. All right. So any questions or any comments on that? Seeing none. All those in favor? Any opposed? Thank you. What's next, clerk?
No, you read the zoning amendment.
Here's the zoning amendment. Let's take that. This is a zoning amendment moved by Councillor McIntyre, seconded by Councillor Edwards. Be it resolved that Planning Committee recommends to Township Council the zoning bylaw amendment application ZBA 17/21 Donaldson and Sift be approved, subject to the following minor amendments: that Schedule 2 be replaced with a revised site plan showing a revised boundary of the proposed environmental EP1 zone, that Section 2 III be amended to only permit the existing 3 land-based sleeping cabins on retained lot number 5 and resultant lot number 6 in application B 36/21 ML until such time as an application is filed for a building permit for redevelopment of the existing dwelling or sleeping cabins. Thereafter, only permit a single sleeping cabin or 2 sleeping cabins combined with a maximum floor area of 661 square feet. Any discussions? All those in favor? Any opposed? Carried. What's this? What do I call this?
Okay, that's the official plan amendment.
Thank you. This is the official plan amendment, because remember, we had to change the official plan. Moved by Councillor Roberts, seconded by Mayor Kelly. Be it resolved that Planning Committee recommends to Township Council that official plan amendment application OPA 57/21 Donaldson and Sift be adopted by the townships through the approval of bylaw 2021-101 and the record be forwarded to the district municipality of Muskoka for approval. Any discussion? All those in favor? All those opposed? Carried. Okay. What time is it? How long have we been at this? An hour and a half? Is it time for the break? Keep going. All right, we'll go on to the next one. What are we on here?
Thank you very much.
The next one could
Thank
be.
you.
All right. All right, next one is. This is the right one. Is this the right one? Next one is zoning bylaw amendment 46/22 bylaw 2022-159 SIFT. And this is Mr. Soya is going to do this to us.
Remind me to get a cordless mouse. I like the mouse. Okay, so thank you, Chair Posemworth. The next application is ZBA 4622, the name of SIFT. This property is located at 1155 Hamills Point Road. And committee will recall this application from the committee meeting on January 20th, at which time committee deferred the application at the request of the applicants to provide time to consider concerns raised by neighbors, township staff and committee, and to prepare a revised proposal. I would direct committee's attention to the submitted site plans and drawings starting on page 650 of the agenda package. The purpose and effect of the originally submitted application was to provide exemptions to permit a two-story boathouse designed with a sleeping cabin in the second story. And the primary concerns raised by members of the public were related to the protection of fish habitat, shoreline density, the impact on the appearance of built form, and the proposed lifting of restrictions that apply to the property today as a result of former approvals. The Township's Public Works Department and Development Services Division submitted comments advising that they would recommend against the approval of any proposal involving the installation of private septic lines within the road allowance of Hamels Point Road. And the applicants have now submitted an amended proposal for a one-story boathouse with a width of 34 feet and without plumbing. And the updated proposal also includes a dock with a width of 64 feet. Since the site specific bylaw 2001-21 only permits docks to have a cumulative width of 50 feet, an additional exemption is required based on this new plan to permit the proposed dock. In response to the amended proposal, the Township's Public Works Department and Development Services Division have advised that they would no longer object to the approval of the application. Additional comments have also been received from 3 members of the public. I will summarize these submissions and can read them in full if committee would like me to do so. There's a submission received from Wayne Gibson from 1025 Christie Point Road, which is a road in close proximity located to the west. And he has advised that he is pleased with the amended proposal, but has asked that prohibitions be put in place to only allow tree cutting in the location of the proposed 6-foot wide ramp that will be used to access the dock and boathouse. Also that the existing floating dock be removed and that the existing original driveway on the backlot portion of the subject property be replanted and converted to only a footpath. Robert Silcox from 1037 Christie Point Road has submitted comments advising that he continues to object to the proposal and specifically objects to the proposed dock. He states that there is no compelling reason to allow development in excess of the permissions granted in the 2001 site-specific bylaw, and states that the size of the proposed dock is excessive and that there is no need for the additional boat slip proposed within the dock. Mr. Silcox states that if the outside boat slip is eliminated, he will have no objection to the 34-foot wide single-story boathouse, but he does object to the dock having a cumulative width of 64 feet, and he of docks having a cumulative width of 64 feet, and he would have no objection to the future construction of a garage on the backlot. And just pointing out, there is no, as part of this proposal, there is no garage that's currently being considered. Barry and Janet Brackley from 1183 Hamels Point Road, unit number 2, have advised that they are generally pleased with the amended proposal. However, they have requested that the boathouse be set back an additional 5 feet from the shoreline, that the existing dock be removed, that parking restrictions be put in place along Hamels Point Road, and that signage be installed along the road to encourage slower speeds at the locations where pedestrians cross. And they state that this would also minimize the township's liability in case of an accident. Staff have prepared an additional planning report for committee's consideration that provides a description and analysis of the revised proposal. And staff have recommended that bylaw 2022-159 be approved, subject to the following minor amendments. That the exemption to permit a 2-story boathouse with first and second story widths of 34 feet be replaced with an exemption to permit a 1-story boathouse with a width of 34 feet in the location and extent shown on the revised site plan. That an exemption be added to permit a cumulative dock width of 64 feet in the location and extent shown on the revised site plan. that the site plan forming Schedule 2 be replaced with the revised plan. And lastly, as has been included in the resolution before committee today, and is recommended in the initial staff report, staff recommend that the existing dock be removed prior to third reading of the bylaw. And I have no further comments at this time. Thank you. Happy to answer any questions.
Thank you very much, Mr. Sawyer. We have 3 delegates, possibly only 2. The first one is the applicant's agent, Mr. Sean Donaldson. And Mr. Donaldson, you get 5 minutes.
Sounds good. Good afternoon, committee. Thank you for the opportunity to speak today. First of all, I'd like to speak to the fact that this lot is to be considered one lot for planning purposes. The only documentation that planning staff or town staff has been able to share with me as to why this took effect was due to fish habitat. We have hired, as per the conversation of the last committee hearing, that we needed to get a fish habitat assessment done in which it showed where fish habitat was and where it was not, to be able to outline to us where the structure of both the dock and boathouse could go. We have carefully designed where the boathouse and dock will be, resulting in a dock that is 64 feet wide, where the bylaw currently allows up to 75 feet. So we are 11 feet short of what the zoning bylaw actually would allow. The boathouse could be 49 feet wide as per the bylaw, and we're only 34 feet wide. Currently, the boathouse is 36 feet in depth, which is not abundantly big considering lots of docks or boathouses can be 50 feet from shore. To the Brackley's point of reducing the setback from the shoreline by 5 feet, it becomes a little bit difficult because the boathouse is already rather small, being that by the time you frame your boathouse, you have your garage doors on the inside, boat lifts, everything. It's already rather tight, as you can see from the design there. I can't speak to every point that was laid by every person in opposition, but if you have any questions, I'm happy to answer those as much as I can. You know, when we first came to you in January, it became quite clear what you as committee members did not want to see. That was a 2-story boathouse, so we cut it. You did not want to see plumbing, so we cut it. We're here just to essentially get rid of this old fish habitat assessment that was not, you know, there for any reason as it relates to today. So that's all I have to say for now. If you have anything else, please let me know.
Thank you very much. Mr. Pierce, you are next. And you have a couple of minutes.
I had 5 for this one too.
Well, it appears you have to ask 7 days ahead of time to get 5 business days, apparently.
Okay, not a problem. I will speak quickly. Ken Pierce on behalf of the MLA again. Our main concern was the 2-story boathouse and the at least 8 plumbing fixtures and the additional utilities under the road. Glad to see that is no longer the case. The revised application shows no second story. In fact, there's a small peak roof, so you probably won't even have a deck on top, and no plumbing fixtures. This is the page out of the in the materials, and you'll see that there's a reference here. It says proposed single-story boathouse and dock, and then underneath it, it says no plumbing. So we draw some comfort from that. The dock is proposed to be increased to 64 feet wide. The old bylaw said 24-foot wide boathouse and a 50-foot wide dock. So basically a single slip, and then you probably put a boat on either side, so 3 boats. The next proposal was for a 2-slip, 34-foot boathouse, 50-foot dock. So 2 slips in the boathouse and a boat on either side, so 4 boats. Now we've got 2 slips in the boathouse, a 3rd open slip, and then 2 boats on either side, so a total of 5 boats. And why does this become important? This property is zoned residential waterfront. It's not zoned commercial. It's not a contractor's yard or a contractor's landing. As of yesterday, I drove by and there is a barge in front of the tied up to the floating dock that we were heard was going to be removed. And further to that, you say why 5 boats? Well, I think it's because they're maybe used for contractor barges as well as regular recreational boats. Further evidence of this is the temporary access road that I understand was supposed to be filled in. It was mentioned in some of the other materials. You'll see on this drawing, there's a little curved portion there, and it's defined as path to water. It's not a path to water for the portion that I could see from the road yesterday. It was fully drivable. I understand from neighbors that sometimes there's contractors' trucks parked there. I guess they're using that to access the barges that are there. Again, this should be reduced to 6 feet wide, revegetated as I think it was supposed to be, so that it's not ended up being commercial. Each property is only to have one entranceway, and you'll see the entranceway now is this back loop here. They purchased some additional land and come in the back, which is great. So this entranceway here, and it's a pretty steep slope anyway, so I don't know that it is really necessary.
Mr. Pierce, if you can wrap it up soon, thanks.
Yep. So per the sketch, yeah, I've said back to the water. Nothing really to say on this except that, please keep an eye on this, and we were pleased to see that the existing dock will be removed. Thank you.
Thank you very much. Are Janet and Barry Brackley in the waiting room at all? Don't see them. Mr. Donaldson, could you address some of the concerns that are raised by the MLA?
Yeah, absolutely.
Mr. Pierce?
Sure. And I'd also like to speak to Mr. Silcox's letter as well. I was able to pull up in my email as to what was said. There's been talk about the size of the dock, how much dock slippage one person needs. I'm not in a position to say that one person is limited to X amount of boats. I know that dock or barge that is currently on the property and tied up to that dock is not actually used for construction use at all. That boat is not owned by Caleb and Jillian Sift. That boat is owned by their friend who has an island lot, who's been able to come and go, and that's what he uses to get back and forth from his island. He likes to have a launch craft so that he can get on and off the boat very easily. As it relates to the finger dock that Mr. Silcox outlined to be as, according to him, too wide, being 14 feet, being that most of you or all of you have been longtime Muskoka goers, I can imagine that you've been on a dock before where you can feel that it kind of shakes and whatever else. We've had great success with docks that are a similar size where we can have an adequate amount of piles and X bracing to provide rigidity for the dock as boats come and go from that dock. If there's 3 docks tied up or 3 boats tied up around that finger dock, that's quite a bit of weight that wind can pull that dock around. So a little bit more clarity as to why the dock needed to go a little bit bigger. And also, we are conforming to the bylaw. This isn't some over width application where we're looking to increase the size over and above what the zoning bylaw allows for. We're very much inside of all of the regulations as outlined in the comprehensive zoning bylaw. And the old driveway. I've got Caleb here in my office. He reminded me. That old driveway was put in before Caleb was able to attain the property that is his current access. That driveway was put in so that was originally going to be his driveway. Hasn't gotten around to closing it off, but definitely plans to. He's more than happy to keep the vegetation there along the shoreline. He's more than happy to clean up that driveway so it becomes a footpath as outlined by Mr. Pierce. And yeah, I mean, ultimately we're trying to appease neighbors. We're trying to appease, I guess, the MLA and you as committee members as well.
Thank you. Being no more delegates, questions from committee. Councillor Nishikawa.
Sometimes it's hard for me to figure out how to ask it in a question. So I'm just, I think I'm going to direct this to Bryce if I could. Could you confirm with me, are comments or our bylaws when it comes to operating a home business and how that may affect this particular application. But I'm addressing some of the concerns that Mr. Pierce brought forward, but I am also aware that over the years, we've had different discussions around this table about people operating a small business from their home. And that's what I want to have a better understanding of how that may affect this application or not.
Very good question. Thank you. Mr. Sharp, your thoughts?
Yes, thank you, Chair, and thank you for your question, Councillor Nishikawa. The zoning bylaw does regulate home-based businesses within the waterfront zones, and it specifies that only specific uses are permitted. So, for example, professional or personal services, studio, daycare, repair services, and those types of things, and they have to be located in an accessory structure. So I don't know if that helps answer your question, but I'm not really sure. I guess it's hard to gauge what it is you're asking relative to
I'll be more specific.
What may or may not be occurring on the property. 'Cause I'm not really
So for instance, if this happened to be a contractor that owns the property and requires a boat or a barge to get to work, is there a concern or that they would be leaving their work vehicle? I guess I'm not being that clear, but essentially, I'm trying to have a better understanding of what the concerns are of the MLA and what the rights are of the property owner when it comes to having barge, for instance, parked there.
Mr. Sharp?
I may ask Mr. Pink to help me out here, but the property is zoned waterfront residential. So if it's being used for a commercial use, I don't think that would comply, but there may be permissions within the home-based business section of the zoning bylaw that may allow for a certain commercial component, but I maybe look to Mr. Pink to clarify what that would be.
Mr. Pink.
Thank you. Through you. It can be challenging. I think the distinction to me is if a property owner uses a barge as their personal transportation or vehicle to and from their business, albeit as part of their business, I don't think we'd be able to do anything about that. However, if the property is clearly being used as a conduit to access the lake or to function as a waterfront contractor yard, it does not appear the property is zoned for that use. It's zoned waterfront residential. We do allow home-based businesses. However, in the waterfront and in the community, they're quite specifically defined. In the rural area, they're more general. It's really any gainful occupation. In the waterfront, home-based businesses are very limited to a set of uses, one of which is not a waterfront contractor. So again, I think we would need more information as to exactly the use of this barge and a little more details to take action. But I think that's sort of the distinction in my mind.
Are there any other questions from committee? Mr. Donaldson, would you like to make a comment then?
Yeah, again, I think we're getting a little sidetracked on this barge. It's not a barge for commercial use. Caleb is a contractor, but he does not own the boat. He does not use the boat for his work. He has no intention of using that boat for his work. Again, that is a friend of his who has an island lot and uses that boat because it's an enclosed boat, has lots of space to take anything out to the island that he needs. It is not for commercial use.
Resolution. Councilor Nishikawa.
I've gotten a little confused or off base because allowing someone else to have a commercial use, it's not the property owner that is kind of like what I heard, Sean, was that in fact, it's not this property owner, but it's a friend. And again, where do we draw the line, or what ability do we have to even say that? How are we going to deal with that? kind of thing. How is the bylaw department going to deal with it? All of those kind of things I don't understand.
Director Pink.
Again, it's maybe better for an offline discussion to getting more details with respect to an enforcement matter, but I don't think it's relevant as to who. It's what the property is being used for, whether it's an owner or the owner is allowing an acquaintance to do it. The property is owned for a certain use and must be used for that, regardless of who is doing it. So again, perhaps I need more details to dive into it, but that was the reasoning. I don't think that would absolve themselves of compliance with the zoning bylaw.
Okay, I'd like to move on. If David, you had some minor change to the amendment?
I think everyone agreed that the existing document.
Yes, I think so. All right, let me read the resolution. Moved by Councillor Edwards, seconded by Councillor Mazin. Be it resolved, the planning committee recommend to the Township Council, the zoning bylaw amendment ZBA 46/22 bylaw 2022-159 be approved, subject to the following minor amendments. That the exemption to permit a two-story boathouse with the first and second story width of 34 feet be replaced with an exemption to permit a one-story boathouse with a width of 34 feet in the location, the extent shown on the revised site plan. Then an exemption be added to permit an accumulative dock width of 64 feet in the location and extent shown on the revised site plan, and that the site plan forming Schedule 2 be replaced with the revised plan, and that the existing dock be removed prior to the third reading. Any discussion? All those in favor? Any opposed? Carried.
Thank you, committee.
Let's do the next one and then take a break because Mr. Pierce has been here a long time. And if everybody's okay with that, Mr. Pierce, item number C.
Yes.
Muskoka Lakes Association correspondence replanning process.
Yes, thank you, Chair Bosenworth. I would just like to thank Derek Hammond and David Pink for meeting with the MLA to discuss our letter regarding planning processes in TML and preparing the staff report that you have in front of you today. We consider this a work in process and would very much like to continue the dialogue with staff. One key area for us is the timing of staff recommendations. And providing a recommendation prior to the public meeting on a matter can pose challenges, we believe. Sometimes the public brings to light information that will result in a change of staff's recommendation. For example, the Harry Island situation is one of the cases where that happened. And if staff has made a recommendation prior to the public meeting, members of the public often feel that their voices are not being heard, and it's a little bit challenging. We acknowledge staff is trying to refrain from providing recommendations until after a public meeting for significant matters and also for contentious matters. However, sometimes it's challenging and difficult, and it only comes to light that a matter is contentious at the public meeting itself. So we have some further thoughts on how to maintain current timelines, which is of course a concern, and also number of meetings. So as not to delay the process or be required to refund filing fees, as now may be the case, I think as of July 1, with some new legislation that it can be reduced and eventually you don't get your fees. So Gravenhurst provides an interesting example that might be worth looking at. I gather Mr. Pink has advised us that the Township of Muskoka Lakes used to have what was called a planning council instead of planning committee. And so that might be something that can be looked at again. As I said, we would like to continue our discussions with staff. Thank you.
Thank you very much, Mr. Pierce. We do have a resolution in front of us to that basically says that we want to agree with the staff recommendations in the report. So before we go there, let us have any questions of Mr. Pierce. No questions.
Does anyone like me to introduce? Good.
Yeah. Yes. I think that'd be sure. Wasn't on the schedule.
But I'll let you speak. The acting CEO chose to sit here. If that's okay with the committee, if I could do the same today. So I think as we heard, I'm sure committee members recall, I think it was the April 13th meeting, we received correspondence from the MLA on some of the planning committee processes, and staff committed to meeting with the MLA. We did so, it was on shortly after that meeting. It was a excellent constructive discussion, and certainly open to further discussions with the MLA on improving our processes. I can quickly touch on some of the issues they raised, and I think the main one that they continue to wish to further discuss is the timing of our recommendations, and essentially that planning staff are making recommendations on planning applications prior to hearing from the community. Certainly there is merit to that approach, and I'm open to considering changes. I think staff wanted to make sure that council is aware of some of the implications of doing that, either increased timelines or what will be inevitably a very lengthy council meetings if you want to maintain the current schedule. If there's no recommendation at planning committee, there's no staff recommendation or planning committee recommendation, inevitably there's going to be lengthy discussions. And I think, as you witnessed yesterday, and I think at many of our general and finance and council meetings, they run quite lengthy to begin with. I think you're likely looking at spreading those out if you want to attempt to accommodate lengthier planning discussions at council. I think the other thing I would note too, if you look at the council meeting yesterday, there were 5 zoning amendments approved. I don't think there was any or minimal to no public opposition to any of those. And that's not entirely uncommon. So if you want to change processes to potentially lengthen them or add length to your meeting, it's going to impact every applicant, every development, while the majority of them do go through rather smoothly. It is difficult. I fully agree with Mr. Pierce that staff does try to gauge, what applications may be more contentious, and are happy to and do attempt to not make recommendations at those. You would have seen that. For example, the plan of subdivision in Port Carling, obviously a big proposal for our municipality. Staff did not make a recommendation at that public meeting. We wrote a background report, wanted to hear from the community, and then I think have yet to return, but we will return with a recommendation report soon. I think if the concern was mentioned with Harry Island, I think please note when matters are deferred and new information arises, staff can certainly come back with new information and revise its position based on that. If there's new information, if we're misled or we discover new information, we're certainly able to address that. We're not locked in, so to speak. But again, I think whether committee wishes to, discuss a new committee structure or a meeting schedule, that's certainly your prerogative, and staff's here to help you work through that. And I know the clerk is sitting here who's able to answer that as well. We talked quickly about public information and transparency. You would have seen actually, I think at the same meeting, we have worked on online mapping, which was one of the goals in the letter. And it was actually at that meeting, coincidentally, that that request was more or less what we were working on. The next, I know in the correspondence, I do feel I should clarify this publicly as well. It is in the report, but there were a number of concerns regarding the OLT process and sort of an implied assumption that staff is able to enter into minutes of settlement or in effect overturn a council decision. That's certainly not the case. We do bring all OLT matters in camera, and likely the concern or the bit of confusion is that obviously those discussions are not open to the community. But we take our instructions from council puts the case together after receiving instructions from council before any settlement is entered into. I think that largely sums it up. And just lastly, again, very happy to continue to meet with the MLA and always looking for ways to improve the process. So if there's any questions, I'm happy to answer those.
Councillor Zavitz, and then I think Mayor Kelly wanted to.
Thank you. And through you, I guess in a bizarre about face, I wonder if we could ask the MLA through Mr. Pierce what they think of the recommendations in front of us today. I'd be interested in, did this opportunity address their needs, their concerns, their indications, if I might?
Mayor Kelly, do you want to ask a question ahead of that, or shall we engage Mr. Pierce first?
Mine is a comment rather than a question. So
why don't you make it? All
right. And it's not off topic. It's something I want to say, and I got to do it in a public forum because we can't get all together in any other way. One of the happiest discoveries in the 6 months since I was sworn in as mayor is the quality of the people that work in this organization, the staff, and that's every single person in this place. And I know that I'm coming from a different perspective than everyone else, or we all come from, let's put it this way, we all come with our own perspective, but from my perspective, we're all fighting the good fight for the right reasons, and we're making a huge difference. So it needs to be said because of the way we're structured and organized. It's an awkward thing to deal with one-on-one or whatever. I couldn't be happier to be part of this team. I couldn't be happier that the goal is a little bit better every day rather than trying to get, to the end zone before the clock runs out. And that's what's happening. We're getting better. I will honestly tell you, we are joined in that, I think, with MLA. I kind of half jokingly commented on MLA's disposition in the last two submissions, but we, the MLA, most of the people that appear before us all want the same thing. And talking to each other and finding a way to work it out is paying huge dividends. I think Nita Island is a good example of that. I think Sean Donaldson, we're finding a way to get stuff done cooperatively. And I just wanted to get it on the record and let everybody know, because I don't know how else to do this. I can mail you all a letter, I guess, but thanks for that, especially the staff. And the other thing is really obvious, and we see it today, we saw it yesterday. I'm absolutely astounded at the poise and the stamina that a lot of people have. Yesterday was a long day, and there were veiled hostilities, I guess you would call it. There was some grumpiness in the room, and nobody lost their cool, nobody lost their temper, and everybody stayed articulate and on message. So thank you for that, and I'll stop.
Mr. Pierce, your comments on
yeah, just briefly, the timing of recommendations. We would love to discuss some potential approaches that maybe council has used before and maybe Gravenhurst uses now. So that would be one thing. The minutes of meetings, I know, I think you did an excellent job here today of giving staff guidance on sort of where your thinking is and letting applicants know what they need to come back with to address your concerns. Unfortunately, with the Tozer application, I listened to the LPAT hearing, and because it was on consent on a settlement, we only heard the applicant discuss it. And one of the comments was that the minutes and the meeting, they didn't get enough information, and it was too vague and too uncertain, so they couldn't respond, and they didn't respond, and that's why they didn't change a single thing, because it wasn't clear to them what they were expected to change or to deal with. And I think you're just today you did an excellent job on that, and going forward, I just would hope that you would continue to do that. And I know that sometimes you can't put everything into minutes, but if you could put in sort of what the guidance you're giving staff is or what you would expect to see, I think that would be very helpful. And I think that's certainly allowable. And then public information and transparency. I know that heard Mr. Soha and Ms. Walker, just saying what the public's concerns were. And sometimes, and I've seen this in Gravenhurst, it just has, concerns were environmental, height, planning, building, whatever, and very, very general. And so, and they've been addressed. And unfortunately, that leaves the public a little bit cold and concerned that their concerns weren't addressed. And as we heard today, some of the actual letters were read out. The summaries were fairly complete. And so I think that's great to see and to hear. So just applaud you for that. So those were sort of the things that we were top of mind. Thank you.
Thank you very much. Councillor Edwards.
Yes, thank you. I think we could maybe change some of the ways we write reports. If council is considering rather than staff recommend approval. Because then we are basically stuck with it. The MLA had sent letters to everyone, I'm sure. I read them. Other municipalities do things a little different. And I think in the future, we should maybe look at that. I'm not saying we should overhaul it completely, but we should at least be open-minded and look at it. And like I say, other municipalities do not recommend approval, but they can bring it out enough that you know the intention of staff.
All right, let me read this resolution, which we can discuss. Moved by Councillor Roberts, seconded by Councillor Nishikawa, be it resolved that Planning Committee recommend to Council that the recommendations to address the concerns contained in the Muskoka Lakes Association letter dated April 5th, 2023, as outlined in report number Plan 2023-99 be endorsed. Any questions on that? Councilor Zapps.
Thank you. Through you. Not so much a question as a statement, and I'm going to get thrown on the fire here, but I think we as a committee in this particular sense, and certainly as a council, need to stand on our own merits as we tend with staff. And when I hear the way this is read, the way you've read it, it tells me that we're MLA centric. I mean, the MLA is a special interest group, isn't that great? We have many of them in our township communicating with us. My sense is what we should be enacting is what we believe. So my point is, out of the meeting that staff had with the MLA came some good information. That information is being enacted here today. We're embracing that, but that becomes staff and staff worked with them with outside influence, and now it's ours. So to my point, I think it should be, we should own it. I don't really feel comfortable putting out there that the MLA asked us to do 7 things and we said, sure. And here's a resolution to that effect, to be quite honest. Thank you.
Any other comments? Councillor Burry.
To be clear, thank you through you. I don't think it's just the MLA. Certainly, I've been quite vocal with David and with Derek around some people not telling the whole truth and nothing but the truth. And I have full confidence in our staff when they have all of the data that they're going to make the right recommendations to us. That being said, there is a group of people that are our constituents, not large, but some, that'll tell you, they may not lie to you, but they're certainly not going to tell you the whole truth and nothing but the truth. And we've got several examples of that. And I think that that's what caused a reaction that may be too strong, because it is, once again, a sledgehammer trying to put in a finishing nail, potentially. And I get concerned about changing the whole process for a couple of bad actors. I'll pick Harry Island because I think you were lied to, but I'm not allowed to say that, I don't think. Certainly you were not told the whole truth and nothing but the truth by another professional. And I recognize that professionals speaking to professionals are supposed to have that mutual respect. But in that particular case, it was not truthful. The advantage that some of the folks with special interest groups, wherever they may be, is that they know the properties better. Many of us on council have been to many, many, many properties around the lakes and on the lakes. And so we actually, see an application come through and it's like, I know exactly where that property is. I've been there, where staff may not have had that advantage. So I'm trying to figure out a way, and I think what we want to do as a committee is figure out a way to get the combined knowledge of the folks that are on the planning committee to staff if there's something that's not completely 100% truthful. And so I know, and David and I have had this conversation, Derek and I have had this conversation, and it's how do we as council members help staff when it isn't 100% truthful? And those are really the ones where we're getting caught.
Any other comments? Councillor Nishikawa.
Why should I believe your truth? I'm just saying, like, I'm not quite sure where this conversation is going to go, but I do wonder though, essentially about that question.
So I wouldn't say it as that mine is a truth. Mine's another data point for the professionals to put into their decision-making process. And then we've got them being able to make decisions with all of the data, as opposed to some of the obfuscated data. Potentially obfuscated data.
Council, yeah, one more comment, then Councillor Zavitz, and we're gonna have to.
No, I'm just, again, I'm sort of trying to, and it's great that you're Guy Burry, but there may be somebody else sitting in that chair, you know, in 4 years and that sort of thing, and that I'm just not sure if we're asking our staff to believe everything we say and don't do any research on, like, I just don't know what this all looks like. So, yeah, I'm not sure.
You want to comment?
Mike, thank you. And through you, I'm not sure, maybe I'm missing something, but maybe, and perhaps you could read the motion again, if it would be so kind, because, you know, to my mind, we're way up here and then all of a sudden we're way down here. Point being, this isn't about staff, and this is about a meeting that was held, public input. We listened, the township has listened, and this is our response. And so it rankles me a bit to see that the Muskoka Lakes Association called a meeting with us. We go to it, we enact what came out of that meeting, and you know, we're referencing the Muskoka Lakes Association when it's the tax-paying public, to my point.
One more, and then I'd like to make a comment.
So my comments on that particular one is that I feel that they're representing a percentage of the population. But the reality is whatever they did is in front of the public now. Like, there's nothing that's going to be moved forward without it coming to the public forum, which is what we're doing now. So I don't have an issue with staff, because it could be Moon River Cottage Association, but it's just the fact that it comes to the public.
All right. Mr. Edwards, one more comment, then trying to bring some order to this.
This is a question to the staff. When an application comes in, do we check with the planning? Does the planning department check with bylaw and check with building to see if there's any orders against it? If the things haven't been done with the building permit, and that we had one that they were told they were wrong and they completed it, and now they're asking for forgiveness, and this isn't right.
Bryce has his hand up. Thank you.
Through your chair. Thank you, Councillor Edwards. I can assure you that when an application is submitted, that the planning division staff go through that application quite thoroughly, including all the details and history related to the property, building permit issuance. There's correspondence between all of our departments, which I think has been one of the great benefits of merging in bylaw enforcement, building and planning. So there is those checks and balances in place to make sure that we're all informed on what's going on. The odd time we'll visit a property and there'll be a building or structure on the property that's not otherwise shown on the site plan that becomes a surprise to all of us. There's not a whole lot that we can do about that other than try and educate applicants to show all buildings and structures. But I can assure you that the details are looked into quite thoroughly.
Director Pink.
Thank you. Through you, I just really wanted, you're remiss not to echo Mr. Sharp's comments. I would use the term exhaustive. I think if honestly, I think a lot of the applications you see before you are actually more technical and complicated because of what planning staff are discovering in discussions with other divisions and their review of the file. And nothing seems straightforward anymore because of a lot of history to properties. I think what's difficult here, we're not dealing with 100 acres of flat land with subdivisions being built. It's redevelopment, and there's a history to every property here with respect to the development and previous approvals, bylaw matters, etc. And nothing is getting easier because as we continue to redevelop, it complicates things, and certainly from the zoning bylaw down, crafting parameters around that. So I can assure you that planning staff thoroughly review those files and bring those matters forward.
Councillor Mazin. You haven't chimed in yet, so.
Thank you, and through you. I just want to reinforce that to me, and I just want to thank staff for taking the time and going through what were considered issues in our community and making it very transparent to the public in this way. I do believe what I'm hearing is there continues to be a desire for conversation, dialogue around a process. And that was point number one, to see if there are ways to refine this planning process in this situations where we have particularly tricky or sticky situations. And I think the ask, I think I heard this, is could we just continue to have that kind of conversation and dialogue? And given that we are now in the public forum, I would hope that if there are other organizations that are interested in also understanding or perhaps adding their input, that they could do so as well. And, I just want to land on, I think the staff actually do such a detailed and exhaustive process on many of these different things that I think we have to start always with that this has nothing to do with a person or staff. And it's our responsibility to ensure that we have the right process and the right tools and resources in the hands of staff to continue to do the excellent work that they are doing. So I guess at this point, my only comment would be, thank you for doing what you have with the outline of the concerns. And if the request from the community is, could we continue to have conversations with our staff to see if there's other options to continue to refine a process, then I support that. Thank you.
Thank you, Councillor Mazin. You took many of the words out of my mouth. I will just, in that we are really dealing with a problem that I think is not just a challenge sometimes for some of us councillors, but I have had many conversations with constituents, both in my role as on the Committee of Adjustment and as my role as councillor, where our constituents feel very frustrated that council may have a will that at times is different than the planning staff, and which constrains us, appears to certainly there's the perception that it constrains our ability to defend our positions at the OLT, and that is a process question. And I think the MLA has come forward with some discussions, and I like the way Councillor Mazin has put it, that we should continue to be engaging with the community, because I'm sure I wouldn't be surprised if there are some other organizations that may have some thoughts as well. And I don't want this resolution to restrict us from that. I think there's been some clarification in the report that says, planning does occasionally pull these things out and ask for public input before they make recommendations. Doesn't happen very often. Ultimately, though, we could end up with a significant process change, and we want to make sure that's not too disruptive. So I would suggest our directive to staff is that we continue engaging in those dialogues, as this issue really, I don't think, has been successfully brought to conclusion yet. And I think that doubt is certainly in the constituents' mind, that doubt that we, lose some power out of our current process is a very real concern to our constituents, as well as some around this council, which I know. So that said, I think I would suggest the directive to council to staff is to continue to have those dialogues with whoever of the public wants to bring forward, whether it's the MLA or the ratepayers or Friends of Muskoka or individuals. And we should continue to look for opportunities for a little while longer and see where that goes. I don't know. How's everybody feel about that? Does this resolution do that?
I can, and thank you through you. I can certainly amend the resolution. I think perhaps what you're suggesting is perhaps some verbiage and that discussions, continue just to make that clear. But I do want to clarify one thing, because I think further to your comments, and I believe it was Councillor Edwards, I think there's this perception that the process is the issue. And I think as staff has repeated numerous times, the community may not always agree with staff's recommendations, but they're coming from policy. Our role, and I don't think anyone knows our official plan better than our staff, they work with it every day, all day. Your recommendations that you're receiving are coming from that document. If you don't like those recommendations, then change the policies. We've done that, and I'm encouraging and working with the district diligently to try to get our adopted official plan up for approval, and that will certainly be a big step. But again, the process and when we make the recommendation, and again, the process and what the minutes say are not going to win the day at the OLT. What will be what your policies say. So if there's a concern about the development you're seeing, I would suggest again that we look at that official plan. Now, unfortunately, the planning process takes time, and we just went through a 4-year official plan review. It'll be a 4-year zoning bylaw review, hopefully next, and then it'll repeat. So it takes time, but that would be the process, not again, that's the way to really affect meaningful change, not these matters, but just wanted to clarify that.
Any comments? Any suggestions on where we go from here?
Language.
Huh?
I don't know, I've got. Like we've already read that, right? So we need to amend.
All right.
it. Sorry, David.
So how
That's what I chicken scratched, but
So we
you're
read
welcome
that,
to
yeah.
make it planner.
just to keep.
And just to remind you, this is not occurring, and we only have,
Loyalty at the end. We need a
and then
break.
the letter.
We'll take a 5-minute break.
Yeah.
Everybody's gonna need a pee in a minute.
And that's we follow this process again, we did previously.
Did I sign that other one that
Yeah.
you had printed?
Yep. Oh, wait a minute, there is one back.
Yes, I don't think I signed it.
Okay. Better. Get
All
it
right,
back.
let me read this.
Yeah.
So this would amend. This would amend the resolution I read. Moved by Councillor Roberts, seconded by Councillor Nishikawa. Be it resolved that the resolution be amended to add, and that dialogue between township staff and.
Sorry,
ratepayers-
Councillor Chair Bosenworth.
Yes,
I just wanted to note that Councillor Roberts is not here. He has been kicked out technically. So you just read his name as on this resolution. Sorry to interrupt you, but I thought you might want to change.
sorry. Good
That's okay.
catch.
Thank you.
We will wait for him.
Oh, he's coming on now. Okay.
Probably an internet connection issue.
Yeah, he does.
Thank you, Councillor Mazin. We don't always keep an eye on things like this. Councillor Roberts, you able to get back in? We could change this a little bit. There
Thank
we
you,
go.
I'm back. Thank you, I'm back.
Okay, so let me read it again. Moved by Councillor Roberts, seconded by Councillor Nishikawa. Be resolved that the resolution be amended to add, and that dialogue between township staff and ratepayer groups and the community surrounding continuous improvements of planning processes continue. Everybody all right with that? Any discussion? No. All those in favor? Carry. Now I got her. All those opposed? Thank you. I've been trying to do that diligently, mister. Are there any further questions and debate on the motions as amended? Call the question on the main. All right, so now I'm calling the question on the main motion as amended. No, this tells me that after, as amended, as amended, right? So any questions on that? Because we just, sorry, you had this yesterday. All right. This is just between a pee break, all right? So let's go. All those in favor? Any opposed? Thank you. Carried. We will take a break until 5. Does anybody need a physical break? Because we don't have a lot to go. Yeah, we have. We got another 15, 20, 30 minutes. I think we should take a break. Sure. Well, look, it's at 7, 5 after, it's 7. 5 after by that clock. All right, 7-minute break, everyone.
That's why I want to continue the dialogue.
The speaker's still on, someone's mic's still on. Pardon me, have we started again?
I apologize. I had
We do have a hearing scheduled on the Muskoka Trust zoning amendment application next week, actually. Again, I don't know if committee members have any questions on that or previous hearings, but again, it's a placeholder on an agenda. It's an ability for councillors to ask questions should you request an update on any ongoing matter.
Councillor Nishikawa.
Just a very quick comment on, so I was contacted by two different property situations and to actually comment and or give advice on people that wanted to oppose they were I wouldn't say they were trying to gain status, but they were neighboring to the situation and somebody had appealed our decisions. I guess most importantly, I wanted to confirm with David that we can't have conversations with these people once it's at that point.
Director Pink, yes, please.
I don't believe you're permitted. I know, sorry, you are not permitted to disclose or talk about what's discussed in camera, but I don't believe there's anything precluding you from talking about an OLT matter. The fact that instructions may have been given in camera will likely largely tie your hands in a lot of ways, but you can't speak to the matter. I find usually what's best is to direct their questions to staff who understand the process and can explain what is able to be explained. But it is those closed session matters that you certainly wouldn't be able to talk about, but it's still a public process and you can still talk about it in general.
Okay, thank you very much. I think that's any more questions? No, good. We'll go on to the.
Sorry, just at least mention that the delegation's not here. Because it's on the agenda.
Oh, yes, we should. Thank you for that, Director Pink. Item 13A, which was a delegation by Rick Pollard. Mr. Pollard has informed us that he's not going to delegate today, so we didn't mean to skip over that. He's just not going to be here. The Gloucester Pool Association has sent a piece of information, a letter information to us about the floating homes and unregulated floating homes. They've actually requested that we write a letter to Transport Canada and the Minister of Transport to support their case. And I think we have some recommendations of that, but we also have a delegation from Mr. Pierce again.
Thank you again, Chair Bosamworth. I think I've now tied Stephen Fauner for 4 today. So and a question for Director Pink. The MLA is a participant in the Muskoka Trust matter and just wondered if a settlement agreement had been reached, just so I know what's coming on the 20th, if you're able to tell me at least that much, if I might ask.
Really on the
Please go ahead.
Through you, the settlement has not been signed just yet, but should be imminently.
Okay, thank you. Thank you very much. Sorry. The floating homes, they're here. Anecdotally, there's, I gather 3 or 4 families lashing together their units and spending the summer in a bay on Lake Rosso. I've also heard that there's a floating boathouse on Bruce Lake that they put a motor on every May, motored around the lake and then park it, and actually has boats in it. So it's a vessel with vessels inside it. So you've got them here. The Gloucester Pool Cottagers Association has really taken the lead on this. Georgian Bay, there's a builder that's actually building them. They're containers built on barges largely, and coming soon to a bay near you. Can this be regulated? Can TML regulate this? And I think the answer is yes, but there are some challenges. The province, of course, owns the lake and the bed of the lake. the 2015 Glassbell decision, of which Director Pink is very much aware. It's a Supreme Court of Ontario decision about a floating boathouse. And Ontario owns the lake and the bed, but under the Public Lands Act. But the court ruled that that boathouse was subject to the local municipality's bylaws, including building code and bylaws and everything else that from a planning standpoint about the size of the boathouse, how many stories and all the rest of it. And some people are using this as an ability to avoid any regulation by the municipality or by anybody for that matter, because it turns out it's very easy to get a vessel registration from Transport Canada. You basically write them and they send you a number back and said, you've got it. And we're also seeing this with maritime and marine aerodromes where it's governed by Transport Canada again. And there have been some spectacular examples around the lakes of those as well. Ontario did a survey, MNR did a survey, and they had several things in it. It was a couple of months ago, and during the middle of the survey, 3 things that were in there they were asking about got withdrawn. One of them was that you must move your vessel every 7 days, not 21 days is currently the case. You must move your vessel 1 kilometer, not 100 meters. And you must not moor your vessel within 300 meters of a shoreline structure. So a cottage, boathouse, dock, whatever. And for some reason that disappeared. So during the comment period, it was withdrawn. I think it was Sailing Ontario and Boating Ontario, whatever they're called, lobbied. And I totally understand it. If you've got a sailboat with sleeping accommodations or a houseboat and you're going up down the Trent Severn, these probably would be not to your liking. But when you've got situations where you build a giant vessel and a barge and park it all summer in front of somebody's cottage, that I think is a whole different kettle of fish. So I'm not sure why, but again, I think we need to comment to the province, and I think TML already did. And then the third level of government is the federal government, and that's Transport Canada. Navigable Waters is an act. As I said, it's easy to register. The problem happened 20 years ago in Victoria Harbour, and Transport Canada passed rules about that, saying it's not a vessel, it's a float home, and a whole different regime applies to Victoria Harbour. Why that doesn't apply to Ontario, I guess because we haven't asked and it hasn't really been an issue. But as I say, it's going to become an issue. And I think we need to lobby the provincial government and the federal government, in particular Transport Canada, and get rules and regulations much like they have in British Columbia. I think we need to get, Gloucester Pool is taking the lead. I think there's 30 or 40 cottage associations that they're getting on board, including the MLA. And I think we need to get municipalities on board as well. And we need to get 30 or 40 of them to all write in it. So it's not just TML writing a letter. I think it's TML also coordinating with other municipalities. A lot of these are smaller municipalities, don't have the resources to do a lot and also to litigate these things and what have you. And but I think if you team up with other municipalities, I think we have a much better chance of addressing this before it gets goes much farther. And it would be, you're not collecting property taxes, yet if there's EMS or police or fire, this vessel is burning, the fire department's going to respond. If there's a medical emergency, EMS is going to respond, and yet they're not paying any taxes and then for building and zoning, there are no rules. You have no idea whether it's up to building code or whether it's a safe vessel, safe, the septic, there's just no controls whatsoever. So I think it's really something that we need to focus on, and I think the time is now. Thank you.
Thank you very much, Mr. Pierce. Questions and comments from the committee members, please. Mayor Kelly.
Thank you, and through you, I wholeheartedly concur with Mr. Pierce's suggestion that we can't take this lightly, because it is a huge issue, or it's a huge potential issue It's already materialized into a huge issue in certain parts of the Trent Severn Canal in the Gloucester Pool area, parts of Georgian Bay. The reality is, I don't think we're ready to write letters because I don't think we know what we're writing about yet. I think there are huge distinctions to be made between a float home, for instance, and a vessel. The float homes in Victoria are permanently anchored. They're hooked up to sewer, they're hooked up to electrical, and they don't move. I understand why I would think that's a home, but somebody with a beat up, Chris Craft Constellation 70 or 50 foot cabin cruiser without even a motor in it is not a float home, not by the definition that I've seen used by Transport Canada. So relying on having that described as a float home and addressing it municipally through bylaw enforcement, I think we're going to, I don't know how we're going to accomplish that. My fear is that there's about 58 ways to get around the 57 rules that are in place. And if we don't get ahead of it, so just to make it clear, I've read everything I can. I've been working with the mayor and another councillor in Georgian Bay. I've been working with and speaking with Mayor McDermott up in Seguin Township. They had the foresight to pass a resolution. I believe it was a year or two ago. It was in the last 18 months, I believe, dealing with floating accommodations, I think it's called. I actually forwarded it on to the MLA. I don't know if it got through to you because it was just yesterday, but there is a lot we have to figure out. If we're going to, I think the plan is to make sure that people who are taking up residence or operating commercial Airbnbs or whatever, or short-term rentals or whatever you want to call it on our water, have the ability to be regulated. And I'm afraid there's 50 loopholes if we don't figure out how to close them, that we need to address head on. I understand Ontario's claim to the bed of the lake. I don't understand why that isn't trumped by the right to navigate under federal jurisdiction and the right to drop anchor in there and fix yourself at a certain part on a navigable waterway, I think is a right of navigation that by the doctrine of, is it primacy? I forget what it's called now. Paramountcy. Says that federal government's going to override the Ontario's claim to the bottom. Even the situation of moving the boats every 7 days, who's going to keep track of that? It's enforced, as I understand it, by the Minister of Natural Resources. So somebody's going to actually have to keep track of how long that boat's been there, where it's gone, whether they just swapped name boards and what used to be the Mary Ellen is now the Rob, and vice versa. I mean, there's a lot of ways that this can be fairly nefariously defeated. And if there's enough money in play, people will play it. So we need to get a group honestly focused on trying to find, and we can't do it alone. We need to work with groups like MLA, other ratepayer associations. We all have a vested interest in this. We will have to tolerate whatever comes with this, whether it's behavioral issues, whether it's substandard building, whether it's environmental risk through septic/sewage. Something is going to have to be done to stay ahead of this. And as Mr. Pierce quite correctly you have pointed out, if one of these things combusts, and we're going to have to send people out, find it and figure out how to tackle it and put out a fire and maybe save lives. We can't drive by that responsibility. That comes with the territory. So we have to figure out how to get a handle on this. And I'm afraid if we leave it too long or if we take it too lightly, it's going to get way ahead of us.
Councillor
Have one little
McIntyre.
comment. Maybe we need a working group.
Is that Billy?
I honestly believe that that's what you'd have to do.
Councillor Nishikawa.
I just wanted to ask, I'm assuming you're talking with Brian, sorry, in Georgian Bay, but I'm going to suggest that yes, you're about a working group, but in reality, it is a a district type of, like, yes, Muskoka Lakes needs to pay attention, but I think that joining forces with other municipalities, we need to do that. And so I don't sort of see a working group specifically. I'm not saying that another councillor, whether they're a district councillor or not, can't be on that working group, but it should be the larger group of the district because, we're going to need the legal team from the district as well, and all of those other things to come up with. They do check the letters to get sense, so that's why I'm kind of.
And all I'm actually suggesting is it's probably a lot bigger than the district. I think we should be working with a lot of other areas that have tourist-driven navigable waterways, because that's where the vulnerability, I think, exists.
Mayor Kelly, would it be fair to say that there's an awful lot of eyes looking around this and we need to let it go? I think what you're saying is there's a lot of eyes working on this right now. We need to let them get a little farther along before we put our endorsements behind it. Is that what you're suggesting?
Personally, my style is to be involved in crafting whatever the solution is, not trying to find the right solution and buy into it. And what's interesting, again, Mr. Pierce mentioned it. I believe it was the, I don't know if it's Canadian or Ontario Sailing Association that apparently lobbied and had some of these things, which might have been helpful to us, taken away because of not the confusion, but the distinction between what is a float home and what is a sailboat that you live aboard and maybe do a 2-week vacation on. I honestly can't find anywhere that says you can't drop anchor on a sailboat and anywhere you think is a pretty view. And I can't find anywhere that says you have to do that. You can't rent it out from week to week, or you can't use it as a base of operation and travel back and forth to it by tin boat, for instance. If those kinds of things are important, and I think they might be, we need to get ahead of it.
The Gloucester Pool Cutters Association would like us to write a letter to the Minister of Transport and Transport Canada. Is that something you think we should do now?
Yeah, I think we actually did we not send a letter to Mr. Payne?
Thank you. I might try to help clarify, and I apologize if I'm not entirely up to speed on this, but I think I have a fairly good understanding of what the concerns are and what the request is. I think where other municipalities may struggle, and we're a bit advanced, is our zoning bylaw and official plan policies already regulate structures over water, and quite well because of boathouses. I think, as Mr. Pierce mentioned, we're quite familiar with the Glassville decision, because if it was an opposite decision, that would really open things up and we would no longer be able to control someone's boathouse if they push it 1 foot offshore. So we're quite familiar with that. Our zoning bylaw and official plan, again, are very strictly control structures and buildings that you construct over water. So I don't think we have the same concerns or research that needs to be done by others and to get those controls in place. Like, we zone our lakes water body open space and say that anything constructed over them needs to comply with the nearest abutting zone. So it's always been set up that way very well here. What the loophole is, and the province did have an excellent draft. You recall, staff wrote a report. It was well supported. We had a good debate about the size of one's jumpy castle, if you recall. And the proposed changes to the regulations would really, I think everyone was quite supportive, would really address the concerns that these floating homes potentially imposed. The problem is, as we pointed out, shortly after council passed that resolution, and we did submit those comments to the province completely changed course and essentially in all fact, watered down the changes quite significantly. And I think it was as a result of lobby groups of whether it's houseboats or a sailing association, what have you, and the lack of distinction. For whatever reason, they watered down the proposed regulations. I think now what's just simply being asked for, and I trust Georgian Bay, who's been studying this at length, is whatever standards have been imposed by the federal transport minister in BC or Victoria Harbour would work well to just essentially, the loophole is that, yes, we can control buildings and structures. We have no authority to control vessels. So you can build essentially a house on a boat and then anchor it right offshore. And you're right, there's nothing that we could do to stop that. So the simple request is to the Federal Minister of Transportation to essentially put the same standards that Victoria Harbour has in Ontario. And that seems to be what our neighbors are doing. I think we can, again, I haven't studied it at length, but we have a draft resolution prepared if you want to agree with the Township of Georgian Bay's request that we submit a similar letter. I think that would largely address the issue if they did pass such a regulation, because then again, they wouldn't be able to have these floating containers unless they're subject to our rules, I think is what they do in Victoria Harbour.
Councillor Nishikawa, then. Mayor
Thank
Kelly.
you. Today, I would be happy to request or ask for that letter, like if that basic, whatever that basic letter be done, but I don't want to miss the opportunity that we should be staying focused on this. And I would look at the mayor, you figure that one out of how that, you know, who we join and like all of that other stuff. But today I would be happy to pass this letter, but again, let's jump on board and not lose focus on how it might affect our lakes.
And I would agree, every bit of noise and every bit of issue that we can raise is likely to get some attention and buy us a bit of time. My concern is less about the floating home or whatever they're calling it, and more about the fact that a vessel is a vessel, and we can't declare a vessel to be a floating home just because we don't want it parked in front of our house. We are on a much smaller or on much smaller bodies of water than much of Georgian Bay, even in their smallest bays. And so they do deal with much more with these kind of barge and containerized shipping unit converted weekend residences. That's, I guess, a possibility on our lakes, because I don't know how you would stop them if somebody thought it was a good idea. We need to fight that fight, but we also need to be concerned about the possibility of, you know, a houseboat's not a, I don't think a houseboat, maybe I'm wrong, but I don't think a houseboat is a floating house. It's meant to navigate. It's meant to be steered and maneuvered and anchored and not trailered anywhere. But those could become absolutely the same problem on our water, because our water's not as challenging for a boat that size or a vessel that size. And I just don't think we have the luxury of redefining that as a floating home. I think that is a vessel is a vessel. If it's got a Coast Guard sticker on the back of it, even if it doesn't have a motor in it, from my understanding, it can be a vessel. So it can be barged on site, anchored permanently. There is an issue about whether you have the right to drop anchor in any kind of long-term or permanent basis on the lake bottom, which presumably the province owns. I think that's a constitutional loser to make that argument. There's a lot at risk in terms of, there's a lot of opportunity for people who are creative enough to find a way to do this. We need to stay equally crafty in trying to find a way to make sure that what happens here is not appropriate, it's not the word, is within our ability to control.
Whereas transport now therefore we resolve the council authorized draft of the letter 24 federal apply the same standards standard for both homes and
Excuse me, Chair Bosworth, I can't hear.
Oh, I beg your pardon. I didn't have my, sorry.
Thank you.
I'll read it again. Yep, thank you. Moved by Mayor Kelly, seconded by Councillor Nishikawa. Whereas Transport Canada issued by order of the Port of Victoria Harbour Master on November the 1st, 2001, the standards for float homes and live aboard vessels in Victoria Harbour. And whereas Transport Canada has yet to apply the same standards to floating containers and or floating homes in Ontario. Now be it therefore Now therefore be it resolved, the council authorize staff to draft and send a letter to Transport Canada and the Federal Minister of Transportation requesting that Transport Canada apply the same standards in Ontario as outlined within the standards for float homes and live aboard vessels in Victoria Harbor. Any discussion? All those in favor? Any opposed? Carried. All right. I have one more that everybody's quite keen to hear about. Dated June 15th, Councillor Mazin, moved by Councillor Mazin, second by Councillor Zavitz. Be it resolved that the planning committee meeting adjourn at 4:31 p.m. and the next regular planning committee meeting be held on Thursday, July the 13th, 2023 at 9 a.m. via next electronically and in-person hybrid format from the council chambers and municipal offices in Port Carling, Ontario. Any discussions? All those in favor? Any opposed? Carried. Thank you very much. Yeah, yeah.